Thank you so much, Pam. Good morning. My name is Felicia Orth, hearing officer appointed by the Environmental Improvement Board to conduct a hearing in proposed 20.2.92. This is the Clean Transportation Fuel Program. We are on day 9 of the hearing, beginning a little early in order to accommodate some schedules of witnesses. We turn now to the New Mexico Oil and Gas Association, and I see Mr. Trujillo at the podium.
Can you hear me? Morning, Madam Announcer, members of the board. This morning, Namoga API will be presenting 4 witnesses to testify. 2 of the witnesses will present non-technical testimony, as we indicated previously, and the other 2 witnesses will present technical testimony. I will start with presenting the 2 witnesses dealing with non-technical issues, and the order will be Ms. Felix, Andrea Felix, and Prentice Searles. After that, Mr. Mallenberg will come up and do the direct examination of our 2 expert witnesses at that juncture.
Thank you.
Madam Hearing Officer?
Ms. Sona.
I just wanted to confirm that before we begin, we're going to follow the same process for voir dire for this panel, for the 3 witnesses on this panel, as we did for Dr. Schubert.
We can certainly do that.
Thank you.
Thank you for the reminder. Let's see, Ms. Felix. Hi. Hello. If you would please spell your first and last name.
Yes, my name is Andrea, Andrea. Last name is Felix, just like the cat, F as in Frank, ELIX.
Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. And where's Mr. Searles? There you are. If you would spell your first and last name for the transcript.
My name is Prentice Searles. First name is Prentiss. Last name is Searles.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Trujillo.
We're going to begin with Ms. Felix. Ms. Felix, where are you employed?
I'm employed with the New Mexico Oil and Gas Association. You'll hear referred to as NMOGA throughout the day.
Ms. Felix, what is NMOGA?
The New Mexico Oil and Gas Association was established in 1928. We are a coalition of oil and natural gas companies operating right here in New Mexico. We represent more than 200 member companies, from production to refining, from pipeline to fuel distribution. Our members supply the transportation fuels that power everyday life, and they support communities across the state through means of jobs, investments, and reliable energy supply. NMOGA works to ensure that energy development is safe, responsible, and beneficial to the public, while also helping the state meet its environmental and economic goals. We bring a uniquely New Mexico perspective to these discussions, reflecting both the opportunities and challenges by implementing programs like CTFP in our state.
Ms. Felix, what are your job responsibilities with NMOGA?
A full description of my job responsibilities is set forth in the resume, which is NMOGA API Exhibit number 4. In summary, my job responsibilities with NMOGA include monitoring and interpreting regulatory changes at the state and federal level impacting the oil and gas industry, develop and implement regulatory strategies alongside of our members, leading advocacy efforts before regulatory agencies alongside of our members, building and maintaining relationships with regulatory agencies, community members, and our members, coordinating cross-functional activities to align with governmental affairs, legal, community engagement, and communication activities to align with regulatory practices across the state, collaborating with all stakeholders, and managing rulemaking matters for NMOGA.
Ms. Felix, is NMOGA API Exhibit 4 a copy of your resume?
Yes, it is.
Do you have any changes to your resume?
No, I do not.
Would you please summarize your professional experiences?
My professional experience over the last 2 decades have included a very hands-on experience in the oil and gas industry. I began my career as a surface landman on the midstream sector side of things. I chose to begin my career in the weeds, walking the lands here in the state of New Mexico, working to integrate the skills that I had and also what I've learned through multiple mentors throughout the years and achieving my right-of-way certification that you'll hear and you'll see within my resume. The required coursework in order to achieve the right-of-way certification provided for a high-level overview of all the disciplines within right-of-way negotiations and processes to acquire, appraise, relocate, and environmental matters in terms of the oil and gas industry. My certification reflects evidence of personal accomplishment in the right-of-way profession. Leveraging the right-of-way profession gave me the foundation that I needed to help me begin my career in the regulatory realm in the state of New Mexico. I'm a little bit of a nerd and I love rules and regulations and having that understanding in black and white, but it is a little bit of a niche to be able to interpret those because we're all human and we interpret things very differently. And so I found that I like to be able to work with multiple stakeholders and come together and bringing a consensus of that interpretation in what I do. So I have been able to work in upstream, downstream, onshore in the state of New Mexico and other states to bring operational teams together for an understanding and an interpretation of rules and regulations in order to safely and efficiently do the right thing and operate in the oil and gas world.
Thank you, Ms. Felix. Ms. Felix, is NMOGA API Exhibit 3 a copy of your joint statement with API of the non-technical testimony based
Yes.
on NMED's position filed in May of 2025?
Yes, it is.
Ms. Felix, why are you qualified to testify on NMOGA's modifications to the proposed rule and the underlying reasons for such modifications?
Objection, Madam Hearing Officer. This goes beyond the scope of her resume and her written testimony, and we would request that we are permitted to voir dire Ms. Felix at this time.
All right, Mr. Trujillo, I think I did indicate that when we had the motion to exclude. It sounds as though if you're moving outside of her credentials, it would be time.
Yeah, this question was directed to go at her credentials that was indicated in her resume to have her speak to those credentials. What
Okay.
I'll do,
Go ahead.
Madam Chair, if that's all right, just so we can get to the voir dire aspect. I have a couple more just foundational questions, if that's fine, and then
That's great.
And then we can turn over to her.
Thank you.
Ms. Felix, with respect to that joint statement that I referenced, why did NMOGA decide to file a joint statement with API instead of a separate statement solely on behalf of NMOGA?
We need to get you to a microphone. Hold on. Oh, I.
Test. Oh, you could hear that.
Hello. No.
You off.
Testing.
Hello. Shoot. This happened briefly last week.
Is that one working? Hello? Hello? Can you hear me on this one? Yeah. Oh, there you go. Can you hear me now?
No, none of them work.
No.
Makes it difficult.
Madam Hearing Officer, this is Chair Sweeney. We can hear you on the platform.
Yeah.
Can't change what it is.
So
Test,
while we
test.
lost his amplification, does this, oh, this is working again. Thank you, Luis.
And
Okay.
Madam Hearing Officer, this is Chair Sweeney.
I'm not sure
We
that's
can
the
hear
reason.
you on the platform.
All righty. Let's see. So Ms. Nixon, he is drawing her out on her credentials, and then you or Ms. Sona can do the voir dire.
And Madam Hearing Officer, the question that was posed by Mr. Trujillo to Ms. Felix just now was why she filed the joint statement, which goes beyond the scope of her credentials.
Okay. These are, is this part of your introductory foundation before we get to voir dire? You know we're
Right.
going to voir dire.
Yes,
Okay, go ahead.
Madam Chair, yeah, I'm attempting to establish a foundation so we can go to voir dire and have that discussion at that juncture.
Thank
So
you.
I'll go back to my question. Again, Ms. Felix, why did NMOGA decide to file a joint statement with API instead of filing a separate statement solely on behalf of NMOGA?
NMOGA and API chose to present this joint statement because as industry trade organizations, we serve as a unified voice for the businesses that make up the oil and gas industry, which are our members. Our role is to facilitate collective advocacy, provide technical and regulatory expertise, and help our members establish standards that are both transparent and operationally feasible. In addition, because NMOGA and API represent a large and overlapping membership, we believe it was both efficient and responsible to present a joint statement in these proceedings. Without this collaboration, multiple individual member companies might feel compelled to have to testify and enter an appearance separately, thereby resulting in duplicative efforts and unnecessary strain on both the industry and the board's time.
Ms. Felix, do you adopt NMOGA API Exhibit 3 as your testimony?
Yes, I do.
Ms. Felix, now I want to turn your attention to NMOGA API Exhibit 1. Do you have that document in front of you?
Yes, I do.
This document, a copy of NMOGA's and API's modifications to the department's proposed rule filed in May of 2025, along with NMOGA's and API's reasons for their modifications?
Yes, it is.
Ms. Felix, how did NMOGA and API go about preparing NMOGA and API Exhibit 1?
Okay, so now I think you're going beyond her credentials, right?
At this point, I'm not going to talk about the specific Exhibit 1. I'm just asking how they prepared it so that any questions relative to their qualifications can be tested against how they went about preparing the document.
Okay, thank you.
Again, Ms. Felix, just to repeat the question for you, how did NMOGA and API go about preparing NMOGA API Exhibit 1?
Madam Hearing Officer, I understand that this is intended to get at the credentials for Ms. Felix. However, that is not included in the record. It's nowhere in the joint statement, and so would object to this line of questions.
So as I understand it, Mr. Trujillo, you are drawing Ms. Felix out on the red line insofar as she helped prepare that and her background to be able to do that is called into question?
Yes, Madam Mayor, that's exactly, just establishing the foundation of what NMOGA API Exhibit 1 is, how it was developed, and then at that point, we can deal with the qualifications on her to be able to testify.
All right, thank you. Go ahead.
Okay, thank you. As trade associations, NMOGA and API, we recognize the scale and complexity of the New Mexico Environment Department's task at hand in developing these rules to meet the legislative mandates. It's a significant undertaking, and we appreciate all the efforts involved. That's precisely why we formed this joint working group focused on the clean transportation fuel program. This collaborative structure allowed us to bring together the perspectives from multiple companies in an efficient way, avoiding the need of dozens of individual speakers or interveners during the hearing process. Our work group met weekly for numerous hours since the advisory committee was announced in 2024. We've actively engaged with the department throughout. The overlapping membership between NMOGA and API creates a unique synergy. NMOGA contributes deep New Mexico-specific knowledge of regulatory frameworks and agency processes, while API brings national experience with clean fuels programs implemented in other states. Together, we offer a comprehensive and balanced perspective that reflects both local realities and broader industry experience. By working together, our associations consolidated the insights, concerns, and expertise of hundreds of companies into a single unified perspective. This approach streamlines the presentation of industry feedback and allows the board to engage with a comprehensive and well-vetted position. Reaching the unified position has required hundreds of hours, collaboration, technical review, and consensus building between our membership. It reflects not only the depth of our commitment to constructive engagement, but also the value of trade associations as a strategic partner in shaping workable, transparent, and effective regulations.
Madam Mayor, also I have one more question, and then we can go to the board diary just in terms of foundation. Ms. Felix, do you adopt NMOGA API Exhibit 1 as the views, information, and comments of NMOGA and NMOGA's membership, including the modifications to the proposed rule and the reasons for those modifications?
Yes, I do.
Thank you, Madam Mayor. I believe I've done what I needed to on the foundation, and I'll turn it over.
Thank you so much. Ms. Sona or Ms. Nixon?
Good morning, Ms. Felix.
Good morning.
I'm not sure that we've had the pleasure, but my name is Jessica Nixon, and I'm one of the attorneys representing the department in this proceeding, okay? According to your resume, you earned your high school diploma in 1998. Is that correct?
Yes, ma'am.
And you also received some training in various aspects of business management from the Anheuser-Busch Talent Center and Williams Midstream Employee Excellence, correct?
Yes, ma'am.
And then in your resume, I also see that you note other relevant training related to the National Historic Preservation Act, Section 106, the Endangered Species Act, and NEPA, correct?
That's correct.
And you talked about this before. You earned your certification as a certified right-of-way agent in 2011.
That's correct.
And I note that you obtained that certification, but you have not gone on to obtain the right-of-way professional or senior right-of-way professional certifications, correct?
That's correct.
And your educational background does not include a college degree, is that correct?
That's correct.
So you do not have any specialized academic training in life cycle fuel analysis, GREET modeling, or carbon intensity measurement, correct?
That's correct.
And you have not published any peer-reviewed academic literature in any of those areas, is that correct?
That's correct.
You've not taught any courses, lectured, or otherwise been invited to present academically regarding those areas, correct?
That's correct.
And presently you serve as the Vice President of Regulatory Affairs for NMOGA, correct?
That's correct.
And in that role, one of your primary duties is to, I'm quoting from your resume, lead advocacy efforts, represent associations' interests before regulatory agency and government entities, participate in policy discussions, developing positions, and potentially providing testimony or comments on proposed rules, end quote, correct?
That's correct.
So in other words, your position at NMOGA, one of your primary duties is to advocate for oil and gas industry interests to policymakers, correct?
My position would be to advocate on the views of our members of the trade association.
And your members of the trade association include members from the oil and gas industry, correct?
That's correct.
So your day-to-day work for NMOGA does not involve conducting or reviewing technical economic studies, correct?
That's correct.
Nor does your day-to-day work for NMOGA involve conducting or reviewing scientific studies, correct?
That's correct.
And in your professional experience, you have not designed nor implemented a clean fuels program in any state, have you?
No.
In fact, in your professional experience prior to your employment with NMOGA, you have not advised regarding regulatory compliance with a clean fuels standard, correct?
That's correct.
So your resume does not identify any experience advising regulators on technical compliance related to a low carbon fuel standard, correct?
That's correct.
So you do not have personal knowledge about the technical aspects of the proposed rule described in your joint statement, correct?
That is correct, but I bring together the members' knowledge.
And when your organization needs technical expertise, you hire or rely on consultants and outside experts. Is that correct?
So we rely on our memberships, day-to-day operational expertise, and then we also do seek outside technical experts.
So for this rulemaking, NMOGA and API engaged outside technical experts because the policy staff didn't have the necessary technical expertise, correct?
So that's not a yes or no answer. I want to explain my answer a little bit further. The positions of NMOGA and API, as demonstrated in Exhibit 1, with the red line and the reasons, is a direct representation of members' expertise and knowledge. And then we did bring on the two experts that are sitting here with us today to expand on that knowledge.
And in your joint statement, it stated your organization engaged experts to, quote, comment on necessary changes to the proposed regulatory framework, end quote, and then, quote, to provide alternatives that will ensure the program can be implemented and function properly, correct?
That's correct.
So you would agree with me then your prior experience and training equips you to understand the regulatory processes and industry positions, but not to conduct scientific, technical, or legal evaluations, correct?
So I would agree with you, yes, but I'm not here as a technical witness. I'm here as a non-technical witness, bringing the views of our membership.
Thank you, Ms. Felix. And as an organizational witness, you advocate on behalf of member companies such that those companies do not necessarily have to be present or offer their own independent analysis of the proposed CTFP to this board.
Madam Hearing Officer, I'd object. This line of questions been asked and answered.
I think you have already asked that, Ms. Nixon.
It's a slightly different question. I'm trying to clarify that Ms. Felix is here so that the individual members do not have to be here and they are essentially faceless parties.
Okay, that seems like an argumentative phrasing. She did say that she is here speaking with API, a unified voice on behalf of the coalition of companies.
And those individual members do not have to be here, correct?
Madam Chair, I would object to the relevance. Much like the department, there's multiple people that worked on issues and they weren't required to be here either. And again, this is a rulemaking proceeding. I won't belabor the point.
Right. Ms. Nixon, please move on.
I'll move on. Ms. Felix, to move to your joint statement just a little bit. The joint statement includes detailed assertions and conclusions about baseline carbon intensity values, GREET modeling, EERs, life cycle emissions, program solvency, deferral provisions, and EV penetration, just to name a few, correct?
That's correct.
Would you agree with me that those are individually and collectively technical issues?
Yes, those are technical issues, but those are the views of our members and which we're here to represent today.
And you did not model or otherwise test any of the values which are alleged to support those technical assertions in the joint statement, correct?
No.
Madam Hearing Officer, again, I would object this line of questions. I think we've established she's already not done any modeling, et cetera.
It seems repetitive, Ms. Nixon.
Sure. And Ms. Felix, if you were asked to defend the correctness of those technical assertions in the joint statement, you would not be able to do that from your own expertise, correct?
I would have to go to NMOGA's and API's exhibit number 1 and the statement of reasons from our members to be able to answer those questions.
So you would not be able to do it from your own expertise. You would rely on the expertise of others.
No, as a reminder, I'm a non-technical witness and I'm here to provide the views of our members.
Ms. Felix, are you responsible for any regulated parties' compliance with the Clean Transportation Fuel Program?
Will you repeat the question?
Sure. Are you responsible for any regulated parties' compliance with the Clean Transportation Fuel Program?
No, I'm not.
Madam Hearing Officer, at this time, on behalf of NMED, we would ask that Ms. Felix be excluded from offering both technical and non-technical testimony in this matter. As demonstrated in the joint statement, it is replete with technical issues along with those raised in API and NMOGA exhibit number 1. And for the reasons that we just explored, Ms. Felix does not have either the personal knowledge nor the technical expertise to defend and explore the issues raised in either exhibit.
All right. I'm not granting that request. As I mentioned when we had an earlier discussion around this, I think Ms. Felix's role in this proceeding has been clearly set out as essentially someone who helped compile, if you will, the analysis made by their members. But more to your, I think your more fundamental point or your more profound point, to the extent NMOGA is pressing modifications and setting out the reasons for the modifications they would urge the board to make, they're going to have to support that with technical testimony, and it won't be coming from Ms. Felix, but they're going to have to support it from somewhere.
Thank you, Madam Hearing Officer.
Thank you. Back to you, Mr. Trujillo.
Thank you, Madam Hearing Officer. I believe for Ms. Felix, let me double check here. Where I last left off, Ms. Felix, I believe that I asked you if you've prepared a summary of your direct testimony. Actually, let me back up to a question that I skipped over because of an objection. Now that we're through with the voir dire, I'm going to go back to a question. Ms. Felix, why do you believe you are qualified to testify on NMOGA's modifications to the proposed rule and the underlying reasons?
I think that my 2 decades of hands-on experience in the oil and gas industry in New Mexico and my role with NMOGA more than qualify me to provide the board with the views and information and comments from our membership.
One last question, Ms. Felix. I mentioned, you said you prepared a summary of your direct testimony. How will this summary be presented since it is a joint statement with API?
So our joint summary, I'll begin with some opening comments and then I'll turn it over to Mr. Searles for closing remarks.
Thank you, Ms. Felix.
Thank you.
Mr. Searles, good morning.
Good morning.
Mr. Searles, where are you employed?
The American Petroleum Institute, otherwise known as API.
Can you please tell us what API is?
The American Petroleum Institute, or API, is the national trade association representing all facets of America's oil and gas industry. Our membership is broad and diverse, ranging from large integrated companies to smaller independent producers, refiners, pipeline operators, marketers, and service companies. Collectively, our industry supports more than 11 million jobs across the United States and contributes approximately 8% of the nation's gross domestic product. API has been serving the industry since 1919 with a mission of advancing safe, reliable, and sustainable energy development while providing policymakers with technical expertise and practical recommendations. In short, we work to ensure that our nation's energy resources are developed responsibly, efficiently, and in ways that benefit both consumers and the economy.
Mr. Searles, what is your current role with API?
I'm the Policy Director for Fuels, Marketing, and Vehicles at API.
Mr. Searles, what are your job responsibilities with API?
I lead a team on fuels and vehicles, technology, and marketing as my role says in the previous part. The fuels team examines federal and state regulations and legislation on issues such as the RFS and responding to emergencies such as hurricanes or outages of facilities that impact supply and distribution of fuel. I work with the Coordinating Research Council, which is a group that is put together to fund research for for the use of petroleum products. And this Coordinating Research Council is put together with the automobile manufacturers. And they work on engine technology, fuels technology, and emissions and what those look like. Finally, I work on marketing issues that interact with the associations that represent the jobbers who own the retail stations. And then I work on the National Conference on Weights and Measures, which is putting together a set of model regulations, and that's put together with the regulators.
Mr. Searles, is NMOGA API Exhibit 5 a copy of your resume?
It is.
Do you have any changes to your resume?
I do not.
Mr. Searles, would you please summarize your professional and educational experience?
In addition to my more than 3 decades of professional experience at API, as previously discussed, my undergraduate and graduate degrees provided me with a basis to understand technical issues, while my experience working for API has allowed me to work alongside and learn from member employees who have a deep understanding of how the rules are implemented. The combined experiences provide me a foundational understanding of the downstream industry, and I use my association experience to help develop member consensus on multiple industry issues, and I have served as a conduit for the members' positions to improve regulations and legislation.
Mr. Searles, is NMOGA API Exhibit 3 a copy of your joint statement with NMOGA of non-technical testimony based on NMED's petition filed in May of 2025?
Yes.
Why did API decide to file a joint statement with NMOGA instead of filing a separate statement solely on behalf of API?
Instead of repeating Mrs. Felix testimony on this point, I adopt her response as to why NMOGA and API decided to file a joint statement instead of filing separate statements.
Mr. Searles, you adopt NMOGA API Exhibit 3 as your testimony?
Yes,
Now I want to turn your attention to NMOGA API's Exhibit 1. Is this a copy of NMOGA and API's modifications to the department's proposed rule filed in May of 2025, along with NMOGA's and API's reasons for the modifications?
yes.
Mr. Searles, how did NMOGA and API go about preparing NMOGA API Exhibit 1?
Instead of repeating Ms. Felix's testimony on this point, I adopt her response as to how NMOGA and API went about preparing NMOGA and API Exhibit 1 with one addition. I think it is important to point out that before each gathering of the working group, Ms. Felix or I would provide the following antitrust statement. It is API's and NMOGA's policy to comply with the antitrust laws. API and NMOGA staff and member companies' representatives should observe the following guidance. No discussion or forecasting of prices for goods or services provided or received by a company. No sharing or discussing any company's confidential or proprietary information. No discussion of any company's specific purchasing plans, merger or divestment plans, production information, inventories, or costs. No sharing or discussion of specific company compliance costs unless publicly available. No agreement or discussion regarding the purchase or sale of goods or services. Such decisions are independent company decisions. No discussion of how individual companies intend to respond to potential market, economic scenarios, or government action. Discussion is limited to generalities and no disparaging remarks regarding specific vendors, products, or services. If a discussion presents an antitrust issue, we ask the members to raise their concern immediately, and if the discussion continues, announce that they are leaving the meeting. And if they
Mr.
have,
Searles,
yes,
I'm sorry. We have 2 interpreters and a court reporter trying to capture every word,
going too fast.
and that was a little fast.
Apologies, I'll slow it down.
I think you left off at the.
At the end of it, if the discussion continues, announce that you are leaving the meeting because you have an antitrust concern and immediately report your concern to API's Office of General Counsel, NMOGA's counsel, and to your company's own counsel.
Just to be really clear, Mr. Searles, this particular admonition was given every time with the working group that worked on developing the red line
That's correct.
and the proposed reasons.
Correct.
Mr. Searles, why are you qualified to testify on API's modifications to the proposed rule and the underlying reasons for such modifications as set forth in the NMOGA API Exhibit 1?
I have been with API for 3 decades, and my experience and work on multiple downstream and transportation issues in my role at API working with member companies qualifies me to provide the board with the views, information, and comments from the membership of API.
Mr. Searles, do you adopt NMOGA API Exhibit 1 as the views, information, and comments of API, including the modifications to the proposed rule and the reasons for those modifications?
I do.
Mr. Searles, have you prepared a summary of your direct testimony?
Madam Hearing Officer, at this time, we would request to voir dire this witness.
All right. Thank you, Mr. Trujillo. Ms. Nixon.
Good morning, Mr. Searles. I'm not sure that I've had the pleasure of meeting you either, but again, my name is Jessica Nixon.
Nice to meet you.
Thank you. It's nice to meet you as well. Technology is failing me, I'm sorry.
Maybe you need to plug the coffee pot back in.
Mr. Searles, according to your resume, you earned your Bachelor of Science in Electrical Engineering from Louisiana Tech. Is that correct?
It is not. I earned my electrical engineering technology degree from Louisiana Tech.
Thank you for that clarification. And that degree program focused on applied engineering schools rather than environmental science, carbon accounting, or life cycle fuel modeling, correct?
Yes, that is correct.
And you also earned your Master's of Engineering Management with an environmental concentration from George Washington University, correct?
That is right.
And that program emphasized management, planning, and policy. Is that correct?
It actually went through the regulatory rules of things like the Clean Air Act. And so you would review those as part of that curriculum.
But that curriculum did not include education in GREET modeling, life cycle carbon intensity calculations, or transportation emissions science, did it?
On the first two, I would say that's correct. I did take a class or two on emissions due to the how you do combustion in an engine. Yeah.
You have not published any peer-reviewed academic literature in relation to life cycle greenhouse gas modeling, transportation fuels, or environmental science, correct?
That is correct.
And you have not taught any courses, lectured, or been invited to present academically on those subjects, correct?
That is right.
And I just want to make sure I have this correct. You are presently the Policy Director for Fuels, Marketing, and Vehicles at API, correct?
That's right.
And in that role, you manage API's policy activities related to fuels, vehicles, and marketing, correct?
That is right.
And in your role at API, you have, quote, led and participated in developing education materials for legislators and regulators. Did I read that correctly?
You did.
And those materials are designed to promote API's policy positions and educate regulators about that, correct?
Those presentations are intended to provide information that most people don't understand about our industry, how the supply chain works, where the fuel comes from, how it gets there, who owns it along the way.
And that's in support of your member organizations and your collective organization policy goals.
It's in, yes.
So they're not neutral scientific reports intended for peer-reviewed publication.
I don't think that that's accurate. We go through and have just worked with I'm trying to leave out the name of the company, but we hired them to go in and do an analysis on some fuels issues, and that is actually going through and being published in an SAE publication.
What's the name of that publication?
I'd have to go look. I'd have to get back to you on that.
But
I don't know.
you did not personally write that article?
Oh, no.
Okay. You hired an outside expert.
Absolutely.
And so is it fair to also say you do not personally create GREET model runs or life cycle emission calculations?
That is correct.
So your primary duties at API involve policy management and industry advocacy, not technical modeling or scientific research.
We oversee scientific research. So our members work with this group that I was talking about earlier, the Coordinating Research Council, and we have a significant research budget, and the members work with them and the automobile manufacturers to come up with joint technology. I do not write that technology, and this is why we have experts within our industry.
And you have, Mr. Searles, have never been retained by a state or federal agency to personally perform that type of modeling or compliance analysis for a clean fuels program, correct?
That is correct.
And in your professional experience, you have not designed nor implemented a clean fuels program in any state before, correct?
That's correct.
And your resume did not identify any experience advising regulators on technical compliance with a low carbon fuel standard, correct?
My resume does indicate LCFS, but it is not on the technical part of the LCFS. It's on API's goals of what our policy should look like and how the LCFS can be achieved in a way that's implementable and achievable and workable.
And you've never done that type of work on behalf of a regulatory agency?
I have never worked for a regulatory agency.
And API and NMOGA engaged outside technical experts for this rulemaking because you and other policy staff don't have the technical expertise. Is that correct?
Yes, that is right.
And you did not personally draft the proposed red line, which has been submitted on behalf of API and NMOGA, did you?
I was part of the meetings that we held to get to the red line. We were having weekly meetings where we would take the input of all of the members around the table and consolidate that into one place, come up with what we thought was a consensus position, develop that consensus position, test it, and then read it back to them and say, okay, did you do this? And so, yes, I think I did help significantly in writing that document and in the form that it currently is in.
And those individual members that contributed to the review and those proposed revisions you're explaining, they're not present here today to further explain and dissect the rationale for those proposals, correct?
Those members have relied upon Ms. Felix and myself to share the revisions to the red line, or our red line of the proposed rule.
So you're designated as the organizational witness for API to adopt the joint statement adopted or presented on behalf of API and NMOGA here today, correct?
Correct.
And again, that joint statement includes detailed assertions about baseline carbon intensity values, GREET modeling, EERs, life cycle emissions, program solvency, deferral provisions, EV penetration, to name a few. Is that correct?
It is, and those positions are based on the experience that our members have with having to comply with the programs in the 3 states on the West Coast that have those, as well as in Canada, as well as similar programs in Europe. And then we have hired Ms. Losi to do the analysis that you've asked about regarding GREET.
And so individually and collectively, those issues are technical issues. Is that correct?
Some of them are technical, some of them are views on how you should do things better and make the program more implementable. Some of them are common sense, and they're based on the history of people trying to comply with the existing rules.
So just talking about those technical assertions in the joint statement, you personally cannot defend or explain the correctness based on your own expertise, correct?
Madam Hearing Officer, I would object. I believe this line of questioning, witnesses asked and answered, then asked and answered.
I think it is becoming repetitive on that point, Ms. Nixon.
Madam Hearing Officer, I do think it's important to make this point based on page 2 of the joint statement adopted by these witnesses, where it reads, in the event of objections to any portion of the testimonies of Ms. Felix and Mr. Searles, NMOGA and API reserve the right to designate Ms. Felix and Mr. Searles as technical witnesses. So I think it's important to establish that these witnesses do not have the expertise necessary to testify as technical witnesses.
Okay, and I think we've already heard from Mr. Trujillo that they're not being presented as technical witnesses.
Okay. I just want to make sure the record is clear given this statement in the joint statement.
Thank you.
Mr. Searles, my last question is, are you responsible for any regulated parties' compliance with New Mexico's Clean Transportation Fuel Program?
I'm not.
Thank you, Mr. Searles. And Madam Hearing Officer, at this time, NMED would move again to exclude the testimony of Mr. Searles, again, because of the technical concepts included therein, and he lacks the expertise to defend those as set forth both in the joint statement and the proposed red line that has been introduced as an exhibit in this matter. And additionally, he lacks the personal knowledge to fully defend the statements and positions set forth by NMOGA and API.
All right, thank you. I'm denying that request for the same reason I denied the request as to Ms. Felix. I believe Mr. Searles has set out his role in the preparation of these documents. And I also believe that to the extent the board wants to adopt any of the modifications proposed in the red line, they're going to have to find a substantial basis in technical evidence if in fact it's a technical change.
Thank you, Madam Hearing Officer.
Thank you. Mr. Trujillo.
Thank you, Madam Hearing Officer. Mr. Searles, I believe, we had a correction to NMOGA API Exhibit 1 that you had identified. Is that correct?
We do.
Can you walk us through that correction that you'd like to indicate for the record?
Yeah, on page 39 of the Exhibit 1 on line 28, we have a call out box with a formula that is a drafting error, so that should not be there. The appropriate equation is actually found at what appears to be line 41.
Thank you, Mr. Searles. With that, Mr. Searles, as I indicated, I asked you earlier, you prepared a summary of your direct testimony, correct?
That is right.
At this point, Madam Hearing Officer, we have a short summary we'd like to be able to give. And again, as indicated, Ms. Felix and Mr. Searles, to conserve time, will share the presentation with Ms. Felix going first, and then Mr. Searles finishing it off.
All right, thank you.
Thank you, Madam Hearing Officer and members of the board. Together, our two organizations, NMOGA and API, are presenting this summary of our joint statement of non-technical testimony regarding the New Mexico Environment Department's proposed Clean Transportation Fuel Program, or CTFP. At the outset, I would like to make clear that NMOGA and API members support implementing a clean transportation program. We believe New Mexico can play a constructive role in reducing emissions and advancing cleaner fuels. However, yes, sir. Apologies. However, our joint members' views as a review of NMED's proposed rule reveals that the rule as written would not meet those goals. Instead, they would impose significant costs, legal uncertainties, and market distortions. The rule diverges from the clear direction given in House Bill 41, which was carefully crafted to balance environmental benefits with economic realities. Unfortunately, the proposed rule departs from that balance. Our members have collectively identified three core issues in which our amendments in Exhibit 1 are explained. The first one would be to modify the baseline carbon intensity values based on 2018 values calculated using the R&D GREET model using petroleum-only based fuel, renewable free gasoline and diesel, as was done in California, Washington, and Oregon. Secondly, use of the R&D GREET model, unmodified, to calculate lifetime carbon intensity values rather than model as proposed by NMED. Thirdly, include a well-planned and immediately functional deferral mechanisms as required by House Bill 41 to prevent unforeseeable crashes of the program, including using a deferral that is automatic under certain circumstances and defining the deferral provisions. NMOGA and API members maintain that there are 4 additional issues that must also be addressed. The first one would be a deferred implementation schedule under which would be effective as of July 1, 2026, with reporting obligations and generation of credits only to go into effect on January 1, 2027. And with deficit generation and market for credit purchases to go into effect on January 1, 2028. Second, immediately provide for greenhouse gas reduction project credits. Third, eliminate the energy economy ratio multiplier portion of the department's proposed rule, consistent with the statutory requirement that the rule be technology neutral. And fourth, modify the criteria for periodic program review and provide a more specific role for the CTFP Advisory Committee. In short, our members support a clean fuels program, but the version before you today must be significantly improved to succeed.
Thank you, Ms. Felix. House Bill 41 laid out clear legislative intent for how the Clean Transportation Fuel Program should be designed. Unfortunately, InMed's proposed rules do not fully meet that charge. First, the rules place an outsized emphasis on electric vehicle credits, creating a market imbalance. By awarding disproportionate benefits to electric vehicles, the program risks sidelining other low-carbon fuels that should have an equal role in reducing emissions. The law was intentionally written to be technology neutral. Second, some of the technical assumptions underlying the program are flawed. For example, the proposed crediting for vehicle efficiency improvements is inconsistent with the statutory provisions and fails to reflect real-world conditions. Finally, these shortcomings collectively risk higher costs for consumers. By failing to align with the legislative framework, the rules could lead to compliance inefficiencies and increased fuel prices, potentially. These are outcomes that are clearly not intended by House Bill 41. Beyond the substance of the rules, the process by which they were developed also raises serious concerns. The CTFP Advisory Committee was given too little time and too few resources to provide meaningful input. Stakeholders, especially those representing petroleum-based fuels, often had minimal opportunity to weigh in. Compounding the problem, InMed released draft rules during compressed periods, including holidays, which made it difficult for stakeholders to review and provide thoughtful feedback. These procedural shortcomings created confusion and left critical questions unanswered. For example, how will compliance be monitored? How will adjustments be made if credit markets fail? What safeguards exist for consumers? When processes are rushed and input is limited, the end result is rules that are less predictable, less transparent, and ultimately less workable. That is exactly the challenge we face here. In conclusion, NMOGA and API reiterate our support for the goals of cleaner transportation fuels implemented in a way that is efficiently and effectively implemented with minimal impacts to the consumers of transportation fuel. But the draft rules before you fall short in both substance and process. We are concerned that the state's focus has been on timelines rather than on developing a program that is economically feasible and workable for all obligated parties, and it fails to fully implement the statutory framework established by House Bill 41. We urge the board to carefully consider the modifications our members have recommended. API and NMOGA are committed to working collaboratively with NMED and with this board to achieve a program that delivers real environmental benefits without unnecessary costs or legal risks. Thank you for your time and consideration. Andrea and I will be glad to answer any questions.
Madam Hearing Officer, this time I'm going to switch with Mr. Mullenberg, and he's going to set up the direct for the next two witnesses.
Thank you.
Good morning, Madam Hearing Officer, Madam Chair, members of the board. Again, good to be here with you today. And I'm going to kick off the two technical experts that we're going to present for you today. As you'll recall, we've already presented Dr. Schubert's testimony. Let me start with Ms. Losey and remind me, Madam Hearing Officer, did you go through oaths for?
Oh, I did not for Ms.
Okay.
Losey or Mr. Rensing. Hello. If you would please spell your first and last name.
Hi, my name is Hannah Losey, HANNAH
Do you swear or affirm to tell the truth?
I do.
Thank you. Mr. Rensing.
Michael Rensing, Michael Rensing.
Do you swear or affirm to tell the truth?
I do.
Thank you very much, Mr. Mullenberg.
Thank you, Madam Hearing Officer. So turning back to Ms. Losey, where are you employed?
I am employed at Tricord Consulting.
Could you spell Tricord for
Yes.
the
Sorry.
court report?
TRICORD.
And what is your current role?
I am the Client Relationship Manager for our Low Carbon Fuels business unit.
And what are your job responsibilities?
My responsibilities include providing strategic advice and technical assistance with low carbon fuels programs, including program implementation, lifecycle assessment, capital project evaluation, and ongoing regulatory compliance assurance. The group I lead has performed lifecycle analysis and generated and submitted dozens of pathway applications for low carbon fuels producers into low carbon fuels programs in North America, including in California, Oregon, Washington, and Canada.
Ms. Losey, would you keep it slow?
Through this work, I have become an expert in life cycle assessment as it pertains to fuels and have significant experience in various GREET versions, Open LCA, and GHGenius carbon intensity calculation models. I also analyze potential greenhouse gas, or GHG, reduction projects for fuels producers.
Have you held other positions relating to this proceeding?
Yes, I started my career as a facilities engineer and then a process engineer with BP America, working on deep water oil and gas production platforms. In 2019, I was hired by Tricord Consulting, first as a technical specialist, then as a project manager, and now as a client relationship manager, all within Tricord's low carbon fuels business unit.
Thank you, Ms. Losey. And would you summarize your educational background for the board?
I received my bachelor's degree of science in chemical engineering from the University of Southern California.
Thank you. And is NMOGA API Exhibit 7 a copy of your resume?
Yes.
Do you have any changes or corrections to that resume?
No.
Is NMOGA API Exhibit 6 a copy of your written testimony?
Yes.
And do you have any changes or corrections to your written testimony?
Yes. Technical testimony on line 55 on page 4. I stated that, quote, the fossil jet fuel life cycle emissions basis was replaced with values provided by the International Civil Aviation Association, or ICAO. This is not correct. The ICAO factors are already built into the R&D GREET model. So these values were not replaced, but are utilized in the life cycle assessment.
Would you mind spelling ICAO for the court reporter?
ICAO.
Thank you, just like it sounds. Ms. Losey, do you adopt NMOGA API Exhibit 6 as your testimony before the board?
Yes.
And when you prepared your written testimony, it was based on the Environment Department petition draft of the proposed rule filed in May of 2025, correct?
Yes.
Have you prepared a summary of your written testimony to give to the board today?
I have.
Thank you, Ms. Losey. Would you please proceed with the summary of your testimony?
Good afternoon, Madam Hearing Officer, Madam Chair, and members of the board. I would like to start by thanking you for your hospitality in hearing my testimony. I am here representing my firm, Tricord Consulting, and providing technical testimony on behalf of API and NMOGA. My firm provides environmental consulting services to multiple industries. I co-founded and currently lead Tricord's Low Carbon Fuels business unit, which was launched in 2019. This unit focuses on providing strategic advice and technical assistance with global low carbon fuels programs, including program implementation, life cycle assessment, capital project evaluation, and ongoing regulatory compliance assurance, primarily for low carbon fuels producers. My technical testimony focuses on life cycle assessment using the GREET model, including the 2018 baseline values, look-up table carbon intensity, or CI values, and the temporary pathway CI values as included in the proposed rule. It also addresses the energy economy ratio, or EER, and greenhouse gas GHG emissions reduction project credits. The updated GREET modeling for the baseline, lookup table, and temporary pathways was conducted by my firm under my direct supervision. I want to clarify that while I am an expert in the GREET model and its application in various state low carbon fuels programs, I do not perfectly recall every parameter used in each calculation across all states. Furthermore, my testimony is limited to these technical topics. I am not qualified to provide opinions on economic, policy, or legal matters, nor shall I speak to specific applicability of these topics within New Mexico. I would like to start with a discussion of life cycle assessment, or LCA modeling. While it sounds complicated, at its core, all LCA modeling involves determining the appropriate factors to be used to calculate the emissions associated with specific processes, such as growing of crops or processing of corn into ethanol. The methods used to determine and compile these emissions factors are what define a life cycle assessment model. These factors can then be used to calculate the carbon intensity, or CI, of a particular fuel or process. The most widely used LCA model in the US is the GREET model, developed by Argonne National Labs. Argonne releases annual updates to the GREET model, and these serve as the basis for all US, state, and federal fuel programs that consider CI. My firm reviewed the GREET model, which forms the basis for the CIs of the fuels applicable to this program. conducted for NMED by Eastern Research Group, or ERG, led by John Kopel. These values form the 2018 baseline values, the lookup table pathway CIs in NMED proposed CTFP Rule Table 4, and the temporary pathway CIs in NMED's proposed CTFP Rule Table 5. I would like to note that when I reference NMED's proposed rule, I am referring to NMED's proposed rule circulated in May 2025 and not NMED's revised proposed rule. As the 2018 baseline values form the foundation of the entire credit and deficit generation system for the lifetime of the program, and serve as the benchmark against which statutory emissions reduction goals are measured, it is critical that these values are accurate and reflect the requirements of the statute. Any inaccuracies in these calculated values would have significant impacts on both the overall success of the program in terms of overall emissions reductions and the pricing and availability of credits. This same importance applies to the lookup table and temporary pathway CI values. These values will determine the number of credits or deficits that are generated by producers or importers of these fuels into New Mexico for the lifetime of the program. This is the case for fuels producers or importers listed in Table 4, or initial entrants for fuels producers or importers listed in Table 5. NMOGA, API, and Tricord support the use of the R&D GREET model developed by Argonne National Labs as the basis for the fuel carbon intensity calculations, as it is the most widely accepted model for fuels produced in the United States and is used by all other U.S. state and federal fuel programs. NMED used the 2023 version of the R&D GREET model for its analysis. Our modeling was completed using the 2024 version of the R&D GREET model as requested by API NMOGA, which is the most up-to-date version currently available. However, I recognize that the 2023 version was the latest available model when ERG completed its original analysis in March 2025. API NMOGA is recommending updating the CI values listed in the rule using the R&D GREET 2024 model in order to include the latest climate research. Dal, could you please go to the next slide? Thank you. API NMOGA asked me and my firm to put together a summary of the CI values for the 2018 baseline and the lookup pathway CIs in Table 4. This slide includes the 2018 baselines. The values provided by NMED are in the first column. We believe that ERG made errors in their calculations that impact the 2018 baseline values, as well as the lookup table pathway CI values in Table 4 and in the temporary pathway CI values in Table 5 of NMED's proposed CTFP rule. Due to time constraints, I will not enumerate these errors here, but they are included as part of my written testimony. The second column of this slide contains the CIs calculated using all of NMED's external models and deviations from defaults, but corrects these errors. The third column removes the external models and deviations from the GREET defaults and updates the model to the latest GREET model year of 2024. We performed the same analysis. Next slide, please. We performed the same analysis on the CI values in tables 4 and 5. We have not included table 5 in this presentation as it is extremely long, but the first column are the CI values provided in the rule text in table 4, The second column on this slide contains the CIs calculated using all of NMED's external models and deviations from defaults, but corrects these errors. And the third column, again, removes the external models and deviations from the GREET defaults and updates the model to the latest GREET model year of 2024. I would like to clarify that the model used as a basis for the New Mexico GREET model, or NM GREET, and the model that API NMOGA are proposing to use are essentially the same. The NM GREET model is based on the R&D GREET 2023 model, while API NMOGA is recommending the use of the R&D GREET 2024 model. The practical difference between these two models is the number of external inputs that deviate from the model's established defaults. NMED made several changes to the default GREET model to produce customized results. These fall into two categories. One, the inclusion of external models or data sources to generate inputs that differ from GREET defaults. And two, the use of alternative calculation methods also included within the GREET model framework that differed from the standard default methods. NMED incorporated 4 external models into the existing R&D GREET 2023 models. These included 1. Changing the global warming potentials from AR6 GWP 2023 to AR5 GWP 2014. 2. Replacing the well to refinery gate fossil crude emissions factor with a value obtained from the oil production greenhouse gas emission estimator, or OPG. 3. Substituting the baseline avoided GHG emissions using the calculated CI of renewable natural gas, or RNG, from animal waste with values from the 45V guidance. And 4, replacing the default indirect land use change, or ILUC, factors with those used in the California Air Resources Board Low Carbon Fuel Standard, or CARB LCFS program. In addition to these model substitutions, NMED also made several changes to default calculation methods, including switching the co-product allocation methods for all low-carbon fuels from displacement to market allocation, updating the dairy manure management region from the U.S. average to New Mexico-specific values, and adjusting the default liquefaction efficiency for natural gas pathways. Prior to the deadline for submitting written comments on September 2nd, 2025, NMED had not provided any context, justification, or supporting data set to explain why these changes were made beyond brief, single-sentence descriptions in the NM_parameters tab of the model released on their website, including the use of the OPG model. I would like to clarify that NMED has provided this input as part of their written comments ahead of this hearing in NMED's Exhibit 82. We plan to submit in response to this exhibit as part of our future written rebuttal testimony. However, I will not address this at this time as it was not included in my original written testimony. It is API NMOGA's position, as I understand it, to exclude all external model factors and minimize changes to the base R&D GREET model, calculating the CIs used in the program with a model as close to the R&D GREET defaults as possible. It is technically possible to calculate the 2018 baseline CI values applicable to ethanol-free gasoline and biodiesel-free diesel sold in the United States by changing only 3 values in the GREET model. First, the simulation year from 2022 to 2018. Second, the ethanol blending volume from 10% to 0%. And third, the jet fuel calculation method from ICAO to GREET. Similarly, it is possible to calculate the 27 values in tables 4 and 5 by changing only 2 default parameters. One, ethanol for vehicle fuel from 85% to 100%, and 2, biodiesel in vehicle fuel from 20% to 100%. Therefore, API NMOGA, as I understand, is advocating to reduce the number of input parameters used to determine the CIs in tables 1 through 5 of the proposed CTFP rule from 21 inputs to 5. Using a less modified baseline model would also eliminate the need for NMED to update the external input factors when updating the NM-GREET model. This approach would allow NMED to more quickly and easily update the CI calculation model to align with the latest climate research in the future. My testimony also includes a discussion of greenhouse gas emissions reduction project credits. Many regulatory clean fuels programs that provide credits for fuels sold in the jurisdiction under a certain baseline also offer pathways for parties to earn credits for approved projects that directly reduce GHG emissions in the transportation fuel supply chain, even if those reductions are not tied to producing or blending a specific low-carbon fuel. NMOGA API propose including project credits for direct air capture, carbon dioxide capture and sequestration, including but not limited to from refineries, hydrogen production facilities that supply hydrogen to refineries, and crude oil and natural gas production projects that supply refineries. Project-based crediting is calculated by comparing the emissions of a particular process after a project is implemented to what the emissions would have been had the project not been completed. The difference between these emissions is called avoided emissions. Essentially, the rationale is that by providing credits per metric ton of avoided emissions, the program incentivizes emissions reductions for projects that would otherwise lack financial motivation, thereby reducing overall emissions in the state. Ultimately, greenhouse gases are fungible, meaning that a reduction resulting from implementing a GHG reduction project at a refinery is functionally identical in terms of overall global warming, in effect to a reduction from replacement of fossil fuel with a low carbon fuel. There are a multitude of protocols available to calculate net GHG reduction for these types of projects, including those from the U.S. Department of Energy, the California Air Resources Board, and other international organizations such as Environment and Climate Change Canada. Finally, I would like to address some questions I have had regarding energy economy ratios, or EERs. The EER is a factor used in credit calculation to adjust the carbon intensity of a fuel to account for differences in vehicle efficiency. It essentially reflects how efficiently a particular vehicle converts energy, usually in megajoules, or MJ, to miles traveled. In similar programs, the EER uses gasoline and diesel-powered internal combustion engines, or ICE vehicles, as baselines to adjust the CI of other fuel vehicle combinations accordingly. If a fuel vehicle combination is more efficient than an ICE vehicle, it has an EER above 1. EERs are not standardized across programs, as they depend on the specific testing data that each jurisdiction selects to determine these calculated values. For example, the most commonly used EER value is for light-duty electric vehicles. This value is 3.4 in the California, Oregon, and Washington programs, and is 3.5 and 4.1 in the British Columbia and Canadian low-carbon fuels programs, respectively. The California, Oregon, and Washington programs all currently use EER values based on an analysis published by CARB in 2018, which relies on studies performed between 2013 and 2017. To date, I have not seen an analysis by NMED regarding the applicability of these studies and EER values to the current vehicle fleet in New Mexico. This concludes my statement, and I look forward to and encourage any questions. Thank you.
Thank you.
Thank you, Ms. Losey. Dr. Rensing, you're up.
Um, we have been going 90 minutes, and thank you so much, David. Let's come back at 9:45. Okay, we are back after the break. Mr. Mullenberg.
Thank you, Madam Hearing Officer. We're ready to proceed with Dr. Rensing.
Thank you. Go ahead.
And Dr. Rensing, I believe you've already been sworn, so let me proceed. Where are you currently employed?
I have a consulting firm, MJ Rensing Consulting.
Okay, very good. And what's your current role?
I am the company. I am president and sole owner and sole employee.
And generally, what do you do in your consulting firm?
I am relying on my experience with the British Columbia provincial government as the administrator lead head of the BC low carbon fuel standard, and I now provide advice to anybody who needs it on how to understand and plan to comply under low carbon fuel standards.
Thank you, Dr. Rensing. And you got into this a little bit, but have you held other positions relevant to these proceedings?
Yes, I started started working for the provincial government for 5 years. I worked in the air quality branch as a air quality specialist, focused a little bit on emissions related to fuels, did some regulatory amendments, and was recruited to work on the British Columbia low carbon fuel standard in 2007. And since 2007, until I retired from the public service in 2022, I was essentially the lead of the low carbon fuel program in British Columbia.
Thank you. And could you summarize your educational background for the board?
I have a bachelor's degree in science physics from the University of Victoria in British Columbia. I have a master's degree in astronomy and astrophysics from the University of Toronto, and I have a PhD in physics from the University of Victoria. I also spent 2 years in a postdoctoral fellowships in medical physics research in London, Ontario.
Thank you. Is NMOGA API Exhibit 15 a copy of your resume?
Yes, it is.
And do you have any changes or corrections to that resume?
No.
Is NMOGA API Exhibit 14 a copy of your written testimony to the board?
Yes, it is.
And do you have any changes or corrections to that testimony?
Yes, I have two. First of all, I want to correct a misunderstanding by clarifying that although my written testimony in questions 12, 22, 23, and 43 refers to a modeling report released in January 2025. I had erroneously assumed that the first page of the document had the correct date for the document. In fact, it is the document that was released with additional materials added on March 18th, beginning on page 7. And my source document actually matches NMED's Exhibit 59, pages 2 to 17.
Is that the extent of your corrections?
Thank you. I also want to correct a missing word in question 33. In the first sentence of my answer, the word biodiesel is missing. The sentence should read, quote, with additional time, suppliers may be able to prepare the distribution infrastructure, including offloading, transloading capacity, and upgrading of dispensing equipment to enable multiple compliance options such as E15, biodiesel, and renewable diesel.
Thank you. And do you adopt NMOGA API Exhibit 14 with your corrections as your testimony to the board?
I do.
When you prepared your written testimony, was it based on the Environment Department petition version of the proposed rule filed in May of 2025?
Yes, it was.
Dr. Rensing, have you prepared a summary of your written testimony?
Yes, I have.
Madam Hearing Officer,
Ms. Sona.
I would now ask to voir dire this witness, please.
All right. Mr. Mullenberg.
Thank you.
Good morning, Dr. Rensing.
Good morning.
As with NMOGA API's counsel, Jessica and I are dividing and conquering today. My name is Kelsey Sona. I'm the one of the counsel for NMED, the petitioner in this case. I'd like to ask you a few questions about your resume and some of your qualifications. To begin with, you're testifying today on behalf of the New Mexico Oil and Gas Association and the American Petroleum Institute, correct?
Yes.
And you are being compensated by these trade associations to provide this testimony?
Yes.
And you are testifying here only because the oil and gas industry have hired you to do so, correct?
Yes.
Your analysis that you have provided in your testimony presents the side of the picture from oil and gas industry's perspective, correct?
No.
Would you characterize your analysis as an impartial regulatory study?
Yes.
Would you characterize your analysis as being supported by more than 13,000 hours of work, more than 163 meetings over the course of 17 months with various New Mexico stakeholders?
No.
Objection. State's evidence not in record, and I don't know the relevance of that question.
Right. That may have been NMED's efforts. I'm wondering, though, Ms. Sona, if this belongs more in cross-examination than voir dire.
So, Madam Hearing Officer, part of my voir dire, as was established with Mr. Schubert, is extending to a little bit of this field research concept. I'm not going to be taking these questions further where they would go into cross-examination. I have differentiated those intentionally in my preparations. And as for the numbers that I provided, those actually are in evidence from Mr. Colt Vaughn's testimony.
All right. Thank you.
Madam Hearing Officer, just to clarify, and I think the proper objection probably was this goes beyond the qualifications of the witness and gets more into the basis for his testimony. So obviously we do object to Ms. Sona taking this time to extend her time for cross-examination.
Right. So, Ms. Sona, move on to your other questions.
Dr. Rensing, in your resume, you described your doctorate as a Doctor of Philosophy from the University of Victoria And in your written testimony, you clarified that it was a PhD in physics, which you also shared with us today. Can you clarify that the degree itself is a Doctor of Philosophy and the in physics is the focus of that degree?
I think that you need to understand that a PhD stands for the Latin philosophic doctorate. It is not an indication of a field of study. I have degrees directly in physics and astrophysics, and the name of the degree is Doctore Philosophiae or something like that, which abbreviates to PhD.
Okay, thank you. I was just seeking that clarification. And along those lines, your degrees prior to your PhD are in physics and astrophysics, correct?
Yes,
And those degrees did not have a focus on energy economics, infrastructure planning, or public policy?
could you repeat the question?
Yes. Let me combine it. Maybe it'll make more sense. Your degrees are in physics and astrophysics, not energy economics, infrastructure planning, or public policy, correct?
Correct.
And the academic research shared in your resume did not focus on any of these topics either?
I wouldn't characterize the research I did as academic research, as in suitable for peer review publication.
How would you characterize your research?
An analysis based on 15 years of experience of how a low carbon fuel standard works, how renewable fuels suppliers as well as fossil fuel suppliers and electricity providers behave when a low carbon fuel standard is imposed on their participation in the fuel market.
Is this this research that you're referring to, is this specifically the 2021 paper on how to measure renewable content in refinery units?
No.
So the characterization is that the publications you've listed on your resume go beyond physics and astrophysics and do address the topic of low carbon fuel programs?
The citations in my resume are the entire list of peer-reviewed publications that I have, publications that have been published, if you will. They do not reflect the work that I do. They are happy coincidences to somebody who likes to refer back to his career as an academic.
Okay, thank you for clarifying. With those specific publications listed in your resume, one more question about those. Those do not specifically address economic impacts or infrastructure investments, correct?
Correct.
Dr. Rensing, is it fair to say that you have no formal training in economics?
Could you define formal?
You don't have a degree in economics and you would not call yourself an economist.
Correct.
Turning to your current position, just to confirm, you are the president and sole employee of MJ Rensing Consulting, correct?
Correct.
And you do not employ any economists or engineers, correct?
Correct.
You state in your resume that the work that you do in this consulting role is, quote, model low carbon fuel policy impacts to estimate price impacts and greenhouse gas reductions.
Yes.
End quote.
Oh, sorry. Yes.
Okay. I may quote a few things to you. I copy them directly from, but if you do need to refer to the documents, please just let me know. When you use the word model in your resume, you're not stating model in the sense that you build formal economic models like professional economists, correct?
Correct.
And so what you call modeling is closer to running arithmetic calculations or scenario comparisons with judgment calls not the formal replicable economic model that represents relationships, variables, things and the like, correct?
I would take exception to the disparaging terms. I have been consulting with industry in my role with the provincial government since 2008. Since 2011, I have been maintaining what has become called a model because it is based in a spreadsheet. It involves complex equations that verge on first year differential calculus, so more than simple arithmetic. But the bottom line is that it always was, given this compliance curve for reduction, what are plausible scenarios for the stakeholders, the obligated parties, and the participants in the regulations to demonstrate or achieve compliance. And it includes behavioral limits that economic models have not been factoring in, but it is essentially a model that provides various scenarios so that we can discuss real world figures like the percentage of ethanol that is possible or the amount of renewable diesel that's needed.
Thank you, Dr. Rensing. I guess my confusion came from the fact that this model that you just described and shared with us, that hasn't been filed in this docket and that wasn't described in your testimony, correct?
Yes.
And so is it fair to say that in your testimony, you characterize the beliefs, I see I'm gonna draw an objection. This goes directly to the question about modeling. You did not file this 2011 model that you've shared, that you've updated since then. And instead, your testimony phrases the analysis as, quote, my belief, or my concerns, or in my experience, or, quote, my rough analysis. Correct?
Objection. Again, this goes into the area of cross-examination, not the witness's qualifications. It addresses the substance of the testimony.
Ms. Sona?
Madam Hearing Officer, to the extent we're talking about qualifications, credibility directly folds into that. And so I have this single question on this matter. I don't believe it's appropriate to require me to use my 30 minutes of cross for this question.
But it goes to what the model is based on, right?
No, it goes to the fact that he is basing his written testimony provided to us is not based on the model that he just described. It's based on a different characterization. And so if I need to explore that further in cross-examination, that's fine. But I do believe it is appropriate to be allowed to follow up on the question that he just provided an answer to that's outside the scope of any information we've had to this point.
All right. So just do that one question if you would. Thank you.
Yep. Dr. Rensing, do you need me to repeat it?
Yeah.
Okay. Your testimony phrases your analysis as, quote, my belief, or, quote, my concerns, in my experience, or, quote, my rough analysis, correct?
Yes.
Turning to your professional experience that you shared with us regarding your government career in British Columbia, your government career did not extend to employment for governments in New Mexico or the Southwest, correct?
Correct.
And in those policy administrator roles, is it fair for me to characterize that your work was focused on high-level regulatory processes and stakeholder consultations, and not necessarily the work that a staff economist would do?
No, it would not be correct.
Can you share with me the distinction between why staff economists would fit within the work that you did?
British Columbia did not work with economists on the team for developing the policy. The policy development was done in conjunction with California in 2005 to 2010. The British Columbia political levels that make the decisions to pass laws gave us a strict set of boundary conditions of what we had to achieve. So the original scope was a schedule of carbon intensity reductions from 0 to 10% by 2010, by 2020, starting in 2010. And the discussions with stakeholders did not require us to get into economic modeling to say, well, you're doing no ethanol now, E10 is a pretty reasonable target. You're doing no renewable diesel. Sorry, that would be a bad example because renewable diesel didn't exist when we started. We know we're going to see electric cars. You're not accounting for that. And this is where my spreadsheet came into the role. It was used to generate charts that showed, just as the New Mexico credit analysis report showed, curves with stacking layers of this many credits will come from that fuel, this many credits will come from electricity, and so on. And we could just create those charts and go into stakeholder discussions and say, explain to us why you can't do your part in this. And that meant that we could move forward without economists. And I would have to say that the team now includes economists, that the folks that have been hired since I left, because now people are waking up to the fact that there are further implications to the economy, to fuel consumers, than what was simply assumed in 2010. So I did all the work on that, the analysis, the policy background. I had staff of 2 people who assisted. But as we got into 2017 to 2020, there was a provincial review on the price impact on fuels. And
Dr. Ensing?
Oh,
I don't
I'm going too far. Okay,
Yeah.
but I did end up actually having to instruct the economists on how to model what factors they had to consider before they could come back. Their end result was the same as mine. So there was no role for an economist until after 2022 when I had retired.
Thank you for sharing those clarifications. I guess it sounds like NMED is lucky to have Mr. Ford. Dr. Ensing, I just have maybe 2 more brief lines of questioning for you to conclude the voir dire. In my review of your testimony, you did not cite the Stillwater report. Is that correct?
Objection. Again, this is proper for cross-examination, not for voir dire, and I believe counsel is simply trying to extend her cross-examination time.
So how is this for, dear?
This is voir dire. I'm going to the sources of information which go directly to his qualifications. It's not a long line of questioning.
Okay. Keep going, Ms. Stoney.
Dr. Ensing, did you cite the Stillwater report in your testimony?
I believe I mentioned it once or twice. I'm not sure.
Is the Stillwater report considered support for the opinions that you made in your testimony?
Continuing objection, Madam Hearing Officer.
Noted, Mr. Mullenberg. Go ahead, Dr. Ensing.
No, I was aware of the Stillwater report. I had been asked to provide some input to it, but the numbers and conclusions that I draw come from the sources. Some of them are the same ones as in the Stillwater report, and my own opinions.
Thank you. In addition to those sources cited and your own opinions, I believe you shared that you also used as a source the department's draft studies from the January 2025 report, and then the March 18th, 2025 report, which you clarified you were using the same exhibit. You use that as a source, correct?
In fact, so to clarify just a little so people understand what I'm saying, the March report that is on the website and is submitted in testimony, the first page is a cover page of what looks like a PowerPoint presentation with the date January 29th, 2025. You then go down through to page 7 or 8, in which there is a further report dated March 18th. And my usual understanding is the cover page defines the document. So I refer to it as the January report, but it was the one online that included the 2018 materials.
Thank you, Dr. Ensing. And
Right, March 18 material.
my question was slightly different, and I appreciate you sharing that clarification. But I just wanted to confirm that that report was one of the sources
Yes.
that you used.
Yes, it was.
And then very briefly, regarding the research to support the opinions that you have provided, is it fair to say that until being hired by NMOGA and API for this rulemaking, you have not specifically studied or consulted on energy infrastructure in New Mexico?
Same objection.
Overruled. Go ahead, Dr. Ensign.
No, I have not consulted or done any professional work on the market in New Mexico.
And you have not independently analyzed New Mexico's pipeline capacity, terminal storage, or blending facilities prior to this testimony?
Same objection.
Overruled.
Yes, correct.
And unlike British Columbia, where your experience draws from, and where fuel is supplied primarily by marine sources, tankers and barges, New Mexico is a landlocked state, correct?
Same objection.
All right. Ms. Sona, I think perhaps cross-examination would be a better place.
Madam Hearing Officer, asking about whether or not he has experience in something is directly to his qualifications. This is voir dire. There is overlap, but I'm not asking him to dive deeper. It's a yes or no question of whether he's done something. And, you know, I'm entitled to explore these to determine whether or not a cross-examination question is appropriate, as well as to make my basis for whether or not he is qualified to provide the testimony.
Okay. It sounded as though, however, it was becoming duplicative. He's already acknowledged no prior experience in New Mexico, and it felt like that was the third way you were asking him.
Okay, if I may have a moment just to make sure I don't have any others that would draw an objection.
Go ahead.
Dr. Rinsing, slightly different question. Your statements about ethanol blending limits, biodiesel struggles, and renewable diesel doubling are not supported by a New Mexico specific study that you prepared, correct?
Same objection.
Is this a wrap-up question, Ms. Sona?
Yes. So my prior questions were about infrastructure. This is different. And so it's a different topic despite being a similar question.
All right. Overruled. Go ahead, Dr. Ensing.
Could you repeat the question?
Sure. So your statements about ethanol blending limits, biodiesel struggles, and renewable diesel doubling are not supported by any New Mexico specific study that you've prepared, correct?
They are very simple statements based on a one sentence postulate. And so I'm just drawing a conclusion, and I'll be speaking to that in my, or I have spoken to that in the testimony. I guess what I'm saying is the literal answer to your question is you're correct. I didn't do a study except in the work to prepare for this testimony.
Thank you very much. I appreciate the time. Thank you, Madam Hearing Officer.
All right, thank you. Mr. Molenberg.
I forgot the final part. Sorry about that, Madam Hearing Officer. I'd like to make an oral motion that slightly differs from the motion that NMED filed regarding the qualifications of Dr. Rinsing. As we have heard, the board is not being asked to consider opinions and statements that are supported by evidence in the record. We have been told specifically for the first time that analysis that is completely absent from the record to support these opinions is missing, and therefore it is not possible for NMED to fully test the opinions offered by Dr. Rinsing. And so we would move to exclude him as a witness and to exclude his opinions on these matters for which he can only state today are his own opinions and cannot rely on any spreadsheets or information that he used to come to them, because that has not been disclosed.
All right, thank you. Mr. Molenberg, do you have a response?
Madam Hearing Officer, I appreciate that the department would like to exclude from the board's consideration the one person in these proceedings who's extensively, for a long period of time, administered a low carbon fuel standards program. In terms of that particular motion, as we have long observed in these proceedings, the board is entitled to consider the credentials, the information presented, and everything else as to the weight of the evidence. And I think the board's well qualified to do that and make its consideration. But I've heard nothing that indicates that there's any real basis to exclude this witness from testifying.
All right. Thank you for that. I'm not going to exclude Dr. Rinsing's testimony, and Ms. Sona, invite you to point out at the appropriate times that the certain bases for his opinions may not be in the record. Mr. Molenberg.
Thank you, Madam Hearing Officer. Dr. Rinsing, thank you for your answers to those questions. Are you ready to proceed with your oral summary of your testimony for the board?
I am.
Please proceed. Thank you.
And keep it slow.
Yes. Good morning, Madam Hearing Officer, Madam Chair, and members of the board. I'd like to start by congratulating the New Mexico Environment Department on completing the draft of a new low carbon fuel standard. I strongly believe in these policies for GHG reduction, and I'm one of a very small number of people who are uniquely qualified to confirm that this is a complex, difficult, and stressful achievement. And everyone who contributed to the process deserves to be congratulated for completing the proposed rule that we're speaking to today. I also hope that both the board and the department will find my experience and perspectives in implementing a low carbon fuel standard helpful in considering changes to the proposed rule that will increase the likelihood of a successful program.
Dr. Rinsing, you're speeding up.
Thank you. The carbon intensity reduction targets set by the New Mexico legislature are aggressive and the suggestions in my testimony are intended to help ensure a successful implementation. I'd like to note here that I was hired as an independent consultant, have no financial or competing interests that would benefit from the implementation of the CTFP in New Mexico. I strongly believe in the need for decarbonization and that the rules that are proposed take a holistic and reasonable approach to attaining these goals. I'd like to outline my experience with the low carbon fuel standards. British Columbia began working on the British Columbia low carbon fuel standard very shortly after California announced their commitment to do so. It depends on what measure of success you use as to who was first, but BC was first to bring the rules into effect beginning January 1st, 2010. It's always been a friendly rivalry. Between 2007 and 2022, I led the low carbon fuels team for the British Columbia Ministry of Energy, Mines, and Petroleum Resources with various titles. And for most of that time, I worked with a staff of 2 or 3 employees. During that time, I had direct involvement and responsibility for all aspects of implementing the BC LCFS in 2010. My duties included development of the, and I'm going to read the act and I hope we get all the convention here. It was called the Greenhouse Gas Reductions, open bracket, Renewable and Low Carbon Fuels, close bracket, Act, and the Renewable and Low Carbon Fuels Requirements Regulation. My duties included advising the drafters on legal language. I conducted regular stakeholder consultations, and as a result of the data that we collected in the first compliance period in 2010, combined with further input from stakeholders, we identified a significant policy error, which was addressed in 2012 by making major amendments to the Act and the regulations. At that time, we had conducted an in-depth review of the program and did another one of these in-depth reviews, including industry consultations in 2017 and again, in 2017. And in 2020, I directed the legislative drafters to complete a replacement for the Act, which was intended to fully incorporate all of our learnings in the first 10 years of the policy. The new Low Carbon Fuels Act was passed by the legislature early in 2022, and I retired from the ministry at the end of the year. During the 15 years I was in the ministry, I provided policy analysis, support, and briefing to the ministry executive and the minister, as well as the Ministry of Environment's Climate Action Secretariat on all issues related to renewable and low carbon transportation fuels. I supported the minister during debate in the House to introduce the first act in 2009, the amendments in 2012, and the new Low Carbon Fuels Act that was passed in 2022. By the time of my retirement, I had successfully increased my branch's budget to support a staff of about 35 people to properly support the ongoing administration of the BC Low Carbon Fuel Standard. Nationally in Canada, I provided advice and input to the development of the Canadian Clean Fuels Regulations and served as the co-chair of the Federal Provincial Working Group during the development of the CFR. I also have a good understanding of the technical issues facing fuel suppliers and represented the province as an active voting member of the Canadian General Standards Board, which develops and maintains national standards for gasoline and middle distillates or diesel fuel. I was the sponsor who initiated the development of the Canadian standards for biodiesel. In November 2022, I incorporated MJ Rensing Consulting, Inc., where I work with select clients to provide strategic advice that supports greenhouse gas emission reductions from the use of fuel. I assist clients in navigating low carbon and clean fuel standards to support compliance, advise on greenhouse gas emission reduction strategies, and model low carbon fuel policy impacts to estimate price impacts and GHG reductions. Fuel policy impacts to estimate price impacts and GHG reductions. Turning to the purpose of this hearing, there are a number of factors that are unique to the New Mexico Clean Transportation Fuel Program compared to others, which means that there are no clear precedents that can help predict the outcome of some of those choices. My two main concerns today are that, one, the quantity of credits generated by the supply of electricity has likely been overestimated due to recent changes in federal zero-emission vehicle policies, which will have an impact on the quantity of credits from electricity. And two, there may be difficulties in what I think of as the transition phase, which is the time between the commencement of the proposed rule and the point at which all parties have become accustomed to the new circumstances. I'm going to return to the electricity credit question later because it creates uncertainty for deficit generators, who are the parties that face consequence for not reducing reducing carbon intensity. I believe that the department's proposal to implement the act so quickly after the board adopts the final rules gives little time for fuel suppliers to understand the full implications of the rules, including any changes that the board may include, creating a risk of delays in implementing compliance plans by the parties who will generate deficits. As well, if the rules begin immediately with the full scope of requirements and consequences in a 1 year or perhaps even a partial year compliance period, there is a potential for reporting errors and adverse consequences beginning with the first compliance period. This timeline will have an impact on fuel suppliers, and it may be that some of those impacts are outside of the deficit generator's control. To address these concerns, the board should consider introducing a transitional period that would allow the rules to come into full effect after administrative systems have been tested and actual fuel supply data has been accumulated. This would significantly reduce the risk that the deficit generators will not be able to comply for reasons outside of their control. Until the transition phase is complete, the deficit generators will have to cope with a high degree of uncertainty regarding the scale and value of the various compliance options open to them. The schedule of the proposed rule requires those parties to comply despite having the information needed to be confident in their chosen plans, as this information will not be available until late in the compliance period, giving little time for course corrections. In my experience, uncertainty leads to delays in taking action, which increases the risk of non-compliance and could lead to near-term costs that are higher than would occur under a more measured pace of implementation and a stable, well-functioning credit market. I would argue that some of the credit market conditions that indicate that the transition phase is complete include a credit bank balance that instills confidence and liquidity in the market, data-driven understanding of the number of deficits generated each year, a known rate of credit generation based on actual quarterly reporting data, and a known credit price history. Implementing a transition period where all fuels are reported but only credits are accrued allows for the credit market to be established and functioning. This in turn enables the deficit generators to make compliance plans without having to cope with an overwhelming number of compliance options and no information to inform their choices. The source of much of this information will be the monthly market reports from the data management system, the DMS. And it is essential that the reports are informed by complete, accurate, and timely data. The department has described its plans to implement the DMS, register all entries, have them report correctly, and then issue all credits and deficits on schedule. This plan strikes me as being extremely ambitious due to the short timelines. And in my experience, implementation never goes as smoothly as we would like, and addressing problems requires either time or time and money. I expect that everyone has heard about the iron triangle of project management. The three sides of the triangle are scope, time, and cost. In order for the project to be successful, if one of the sides of the project triangle changes, the other sides need to adjust to compensate. If we recognize that The project in this case is an administrative goal to complete the first compliance period with all suppliers in compliance. I think that the scope, the size of the project, has been minimized or simplified as much as possible. And it is still a complex project due to the difficult task of starting up a new regulation. The time is effectively half of the time that any other jurisdiction has allowed. And I understand that right now the administrative budget is limited. I worry that there may not be enough flexibility available in the time that is available or the department's budget to accommodate any significant change if there are difficulties completing all of the administrative tasks required for success. The DMS implementation schedule laid out by the department leaves little time to accommodate errors or delays, and that could have a significant impact on credit quantities and the timing that they come into the market. The perception that there is a high risk for delays means that there is significant uncertainty, not just in the number of credits that are available, but whether they will be available in time to negotiate a fair price for those credits to then be transferred to the deficit generators. To be clear, the deficit generators will be generating credits largely through the supply of low carbon fuels, and each of them will have a reasonable sense of the number of credits that they are generating. However, the purchase of credits from the supply of electricity is expected to be a cost-effective compliance option in the long run, and the deficit generators who rely on these credits will not need to commit to other more costly compliance plans that take time to implement. So that those credits will come, the credits in the market will come significantly from electricity, and I'd like to address a number of concerns regarding those credits generated by the supply of electricity, as this will be a significant pathway to overall compliance. I believe that there's reason for concern that the department's credit forecast may have overestimated the number of credits from charging electric vehicles due to recent changes in the federal zero-emission vehicle policies, including the end of purchase incentives, the cancellation of enforcement of CAFE standards, corporate average fleet economy standards, and the removal of California's authority to set vehicle standards. This means that the department's modeling results are based on an assumption that could be rendered incorrect in the near future. Without modeling that describes the potential new circumstances, the expected number of credits from electricity is unclear, and it seems obvious that without federal incentives and NMVES requirements, the New Mexico program for electric vehicles, the actual quantities will be smaller than expected. This could have a significant impact on possible compliance scenarios, as the missing compliance from electricity credits will need to be met with increased quantities of other low carbon fuels. It's also worth mentioning that the quantity of electricity credits in a theoretical model assumes that all electricity supplied to electric vehicles is being reported. This would depend on full participation by all public charger operators beginning on February 1st, 2026, which is concerning given the fact that this participation is optional. I also believe that there are reasons to be concerned about the timely availability of electricity credits in the first compliance period, in addition to the concerns I mentioned regarding the modeling assumption and the data management system implementation timeline. In order for all possible credits to be available, electricity suppliers will need to decide quickly whether they want to opt in. The Federal Alternative Fuel Data Center identifies that New Mexico has 1,042 public charging ports and 51 private ones. At the time I prepared my direct testimony, the department had proposed a rule effective date of February 2026. And I understand that this may have changed, but that the department still proposes that full implementation of the rule will begin as soon as it becomes effective. Whatever is the rule effective date, all of the potential credit generating parties will need to begin registering after the CTFP DMS comes online, and to report for the quarter or portion of a quarter in which the rule becomes effective. In my experience, this is not as straightforward as it seems. Even assuming there are no glitches in the registration process, all of the serial numbers and locations of chargers are already known, and that agreements regarding who reports have been signed as required by section 20.2.92.403.E.2.B NMAC.
Okay, slow down just a little bit.
Did you get it? Okay. All of this needs to be completed in just a few weeks if the credits are to be generated for that period and available for sale in the following quarter. In my experience in British Columbia, despite several years of lead time to prepare, British Columbia's public charger operators were unprepared to correctly register their chargers, and the process of finalizing their registrations took several months. If there are any problems reporting, credits cannot be generated after the quarterly reporting deadline has passed, as stated in subject 301B NMAC. If this happens in the first quarter, the quantity of credits available for the compliance period would be reduced by roughly 1/6 to 1/4. In this case, the first credits available for sale would be the credits generated in the second quarter, which would not be available until the third quarter. For residential charging, the department will award credits on a schedule that appears to be semi-annual, and I'm not clear when the first tranche of these credits will become available for purchase. This could be the larger proportion of credits, and the timing would be critical to the deficit generators. They need to acquire those credits to comply if they plan to rely on the cost-effective option. Once the credits start to appear in the market, there will need to be a number of transactions on record through the monthly credit reports before the market price can stabilize and it becomes possible to make rough estimates of the quantities of credits that will be available in later quarters. It is unlikely that market participants will become confident in the credit market signals until several quarters of data have been made public, possibly sometime in the second compliance period. Certainty in the form of reliable, I'm going to speak a little bit to the investments by fuel suppliers and the certainty they're looking for in the market. Certainty in the form of reliable, data-driven market information is necessary to justify investments in infrastructure upgrades, from fuel transport and delivery infrastructure to the administrative systems needed to track the records that demonstrate compliance. To help understand the range of options that deficit generators need to consider, I think of two compliance scenarios that represent the ends of a spectrum. The first scenario is one where the deficit generators rely on the electricity credits as much as possible, which places the compliance fate of the deficit generators in the hands of parties they do not control. The second scenario is one where suppliers do not rely on electricity credits at all and instead increase the quantities of low carbon fuels through the supply of E15, biodiesel, renewable diesel, and other low carbon fuels, which ignores the reality of electric vehicle adoption rates and the low cost compliance credits that are generated. Neither of these options represent realistic behavior, and the real compliance picture will lie somewhere in the middle of these two extremes, balanced by the perception of risk and the economics of compliance. The balance can only be achieved with reliable information from the credit market. In a balanced market, if a potential overall credit shortfall can be identified in time, the most likely near-term response from deficit generators will be to increase the supply of low-carbon fuel, particularly renewable diesel. If the shortfall is large enough, additional renewable diesel could be needed in quantities that could disrupt the short-term renewable diesel market, leading to higher prices. It is also important to recognize that any non-trivial increases in the quantities of low-carbon fuel will require changes in the fuel supply infrastructure to accommodate new sources of fuel and in the logistics needed to transport and distribute these fuels throughout the state. These changes will require time and money, and suppliers are unlikely to make significant financial commitments without regulatory certainty. Once those commitments are made, time will be needed to implement the changes. To summarize, aside from my concerns regarding an accurate understanding of the quantity of credits from electricity, I have concerns related to the risks associated with the unusually short implementation timelines. Additional time would greatly reduce the risk of administrative problems or that credit market conditions are significantly different from the market that is described in the department's credit forecast. I have an additional concern, which is that under any circumstances where, despite a positive credit forecast, a serious credit shortage evolves, there does not appear to be any authority to issue a deferral based on conditions in the credit market that are not related to physical supply emergencies. And I'll explain this a little further in a few minutes. In order to address the issue I've just identified, API and NMOGA have proposed 3 changes to the proposed rule. 1, amend the proposed rule to implement a more measured pace for the transition into the rule. 2, add provisions for emergency deferrals that are based on credit and deficit balances. And 3, for forecast deferrals, make the credit forecast process more transparent by inviting a third party to conduct the forecast, having a third party conduct the forecast, including a period for review and comment, and publishing the decision earlier in the compliance period. In order to implement a more measured pace for the transition into the proposed rule, NMOGA and API propose that the rule should come into effect on July 1st, 2026, to establish the administrative requirements only, including registration, but not the requirement to report or the accrual of credits and deficits. This will ensure that there is sufficient time to implement the data management system and enable fuel suppliers to train their staff and implement the necessary administrative systems for accurate reporting. Beginning January 1st, 2027, the rules governing fuel reporting, credit and deficit generation, and credit accrual and trading, but no deficit accrual, would become effective. And beginning January 1st, 2028, the rules governing deficit accrual would become effective. The full rule would therefore be enforced beginning with the 2028 compliance period. To accommodate this revised schedule, there should be adjustments to the reduction targets for the affected compliance periods, but NMOGA and API have designed their reduction targets to comply with the requirements for a 20% reduction by 2030. Even with the steeper annual required reductions beginning in 2028, it is more likely that suppliers will be able to comply than with full implementation immediately, even though the proposed annual reductions targets are smaller. By implementing this timeline, all parties can be confident that the DMS will be fully operational and understood by those who need to use it. All suppliers have registered correctly, including suppliers of opt-in transportation fuels. There's a reasonable credit balance in the bank that will address near-term concerns regarding the availability of credits. The credit market will have passed through the market price discovery phase as deficit generators begin to accumulate the credits they will need and credit prices have stabilized. Infrastructure projects needed to support the supply of necessary quantities of low-carbon fuels will be substantially underway, if not complete. And initial assumptions regarding the feasibility of compliance in the first few compliance periods can be confirmed with data. Problems with the initial assumptions can be identified and addressed with minimal consequences. To address the recommendation to enable an emergency deferral based on credit availability, I would first like to clarify my understanding of section 20.2.92.601 NMAC and explain why we believe that this amendment is necessary.
Madam Hearing Officer.
Ms. Sarma.
May I request a time check, please?
Yes, you have just a few minutes left.
Section 601A NMAC authorizes the department to defer the provisions of the CTFS by declaring an emergency in one of two circumstances set out in subsection B and subsection C. The first deferral provision in subsection B is called the emergency deferral provision, and the second provision in subsection C is called the forecast deferral provision. The remainder of section 601 NMAC continues to distinguish between an emergency deferral and a forecast deferral. So to me, it's clear that an emergency deferral and a forecast deferral are not the same thing. The considerations for declaring an emergency deferral refer to the physical transportation fuel market conditions and address what is often described as force majeure conditions. I do not think that the credit market conditions would fall within the conditions prescribed in subsection 601B1 NMAC as proposed by the department. A forecast deferral due to a potential credit shortage can only be declared for the compliance period following the one in which the credit forecast is released. However, there do not appear to be any provisions to address a systemic credit shortage that might occur despite a positive prediction of the forecast. And as a result, a credit shortage could become apparent and worsen for most of one compliance period before it can be addressed in the next forecast cycle. To address this risk, NMOGA and API propose adding an automatic deferral that takes effect as early in the compliance period as possible in order to prevent a significant credit market imbalance from worsening the situation before it can be evaluated under the forecast deferral provisions. The proposed automatic deferral would work as follows. Each year at the conclusion of the reporting window for the final quarter of the compliance period, in other words, 45 days after December 31st, the department would evaluate the quantities of credits and deficits that have been generated in the compliance period. If the number of deficits exceeds the number of generated credits by 50% more than the number of credits generated, in other words, the deficits are more than 150% of the credits, deficit accrual would be paused beginning on July 1st, the beginning of the third quarter. And in each subsequent quarter, the number of credits and deficits generated in the previous quarter would be evaluated. If the number of deficits does not exceed the number of credits by more than 20% of credits generated, the department would announce the end of the deferral period to be effective beginning in the quarter that begins more than 90 days following the date of the announcement, which would likely be the second quarter following the announcement. NMOGA and API are also proposing that if an automatic deferral is implemented, the CTFS targets for the following compliance period would be held at the same level as the compliance period in which the automatic deferral is triggered. This would give time for the credit bank to rebuild to a suitable level.
So at this point, I think because the 30 minutes is up, it might be best if you identify the part of your testimony you weren't able to get to, and the board can refer to your written narrative.
Okay, I have a little over half a page on the proposal to make credit forecasts more transparent by outsourcing the development of the credits and a timeline that would bring the decision into effect by September instead of October.
All right, but that's in your written testimony.
And it's in my written testimony.
Thank you very much, Dr. Rensing. I'm wondering, Mr. Mullenberg, and the rest of you, if it might be helpful to take just a 10-minute break before we begin cross.
Thank you. The only item we had left to do was for Mr. Trio to handle the motions for admission of the exhibits.
Exhibits.
Would you like to do that first?
Yeah, let's do that. Thank you.
Mr. Mullenberg places faith in me that I'll get all this right here, but let's give it a shot. Madam Hearing Officer, I move to admit, I'm going to start with the easy ones, 2 through 7 and 14 through 16 of NMOGA API exhibits. I didn't include 11 through 13 because I believe they're already admitted than the previous witness we had.
I don't believe so.
Oh, the extra resumes. I'm sorry. I apologize for that. 11 through 13 are the extra resumes. We obviously no longer needed to use those as Dr. Schubert was able to appear. So again, I'll go back, just move to admit exhibits 2 through 7 and 14 through 16.
Thank you. I'll pause for a moment in the event any party has an objection they'd like to put on the record.
Madam Hearing Officer,
Ms. Nixon.
on behalf of the New Mexico Environment Department, and just for the record, I would object to the admission of NMOGA API Exhibit number 1, number 2, and number 3 for the same reasons discussed following the voir dire questioning of Ms. Felix and Mr. Searles.
All right. I did not hear one moved.
I have a different motion under for exhibit 1. So again, that's 2 through 7 and 14 through 16 are the ones currently I'm moving to admit.
All right. So she still objects, though, to 2 and 3.
And Madam Hearing Officer, again, in conjunction with number 2 and 3, we would also argue that the introduction of Exhibit 4 and 5 and are also not necessary based on the reasons given in the voir dire motion.
All right. So your objection is noted. Are there any other objections to be made? All right. The exhibits are admitted. Again, your objection is noted, but the exhibits are admitted 2 through 7 and 14 through 16.
Madam Hearing Officer, I will NMOGA and API now move to admit NMOGA API Exhibit 1 on the basis of Mr. Searles and Ms. Felix's testimony that the reasons expressed in Exhibit 1 are the views of NMOGA and API. However, at this juncture of the proceedings, we are not seeking to admit Exhibit 1 as technical evidence.
Thank you for that clarification. I'll pause for a moment in the event there's an objection.
Madam Hearing Officer, it's no surprise that I'm interjecting here on behalf of the department. Again, the department would object to the inclusion of Exhibit number 1 as it lacks a foundation, contains substantial technical testimony, which cannot be supported by any witness in the record. And again, any witness on this panel and presented by NMOGA lacks the necessary qualifications and personal knowledge to testify to the contents thereof.
All right, so I'm admitting Exhibit 1 regardless, with the caution that when it becomes necessary to have the discussion around what the board can rely on in reaching its decision and adopting a statement of reasons, we're going to have that discussion. So thank you. 1 is admitted. Anything else?
I believe that would be it.
All right, thank you.
Thank you, Madam Officer.
So let's take 10 minutes, come back at 11:03.
TJ. Hey, TJ. For your office, this is the same as the meeting exhibit 36, maybe?
All righty, let's come back from the break, please. They're ignoring me. Dr. Rensing, would you return to the witness table, please? All right, we'll start with Mr. Noyes or Ms. Menard. Do you have questions of the NMOGA panel?
Greetings all from the Sierra foothills in California. No questions. Thank you.
Okay, thank you. I don't know if Mr. Nasco is with us. Mr. Duff? Mr. Smith? Mr. DeSalen?
Thank you, Madam Hearing Officer. Yes, I do have a few questions, not too many. Got enough wires here. I look like a CIA agent. Okay, I'm going to be directing all of my questions to Dr. Rensing. So good morning, Dr. Rensing. My name is Charles DeSalen, and I'm an attorney representing Coalition for Clean Affordable Energy in this proceeding. And I appreciate your testimony today. Before we get started, I want to just lay a little bit of groundwork. There are a lot of abbreviations, a lot of acronyms in this field, and I would like to ask you that when you answer my questions, try to avoid using acronyms and abbreviations, because it makes things a lot clearer, much cleaner record, and it makes things easier for our court reporter. And I'll try to do the same thing. Okay?
Yep.
Great, thanks. There are a couple of exceptions, though, and that is when I say NMOGA, I'm referring to the New Mexico Oil and Gas Association, okay? And when I say API, I'm referring to the American Petroleum Institute, okay? And then I'm going to be asking you questions about the red line, which is NMOGA API Exhibit 1. And I'll also be asking you questions about your direct testimony, which is NMOGA API Exhibit 14. And I just want to make sure that you have copies of both of those documents handy.
I have them both. They are 3/4 of an inch and 1/2 inch thick, so you'll have to give me time to find them.
Of course, I intend to do that. So let's begin with Exhibit 1, which is the API red line. And I want to ask you a few questions about the proposed schedule. So let's go to page 2, which should be pretty easy to find. On page 2, about line 32, there's a effective date, and that's section 20.2.92.5. Now, under the environment.
Excuse me, I'm looking at a copy that doesn't appear to have the same alignment.
Okay, I'm looking at the red line. This appears to be the clean version.
Well, it says API Exhibit 1.
Yes.
So, madam, it's on page 1. Yes, section 92.5.
Correct.
Right.
Okay. Now, under the Environment Department's proposed rule, the effective date would be February 1st, 2026. Is that your understanding?
That's what the original appears to say.
Okay. Now, NMOGA and API proposed to change that date and replace it with effective date of July 1st, 2026. Is that correct?
Yes.
Okay. And in NMOGA API Exhibit 1, I believe following that that section, there are several paragraphs of interlinear explanations. Do you see that?
Yes.
Okay. And did you prepare that?
No, I did not.
Were you involved in preparing that?
I had some input to some passages. I'm not sure exactly which without reading it in depth.
Okay. Well, I believe you talk about the schedule also in your testimony, your direct written testimony at page 28.
Yes.
Okay. Now, in justifying the proposed July 1st date, you make a number of assumptions, or NMOGA and API make a number of assumptions about the length of time that this proceeding is going to last. Is that correct?
Yes, assumptions would be one way to put it.
Okay. And that includes, I think you say about 60 to 90 days for the briefing.
I'm sorry, what do you mean by briefing?
The post-hearing briefing, in other words, the
Oh,
submittal
yes.
to the board afterwards. Okay. And then you're assuming that the board would meet in February or March?
I don't think I said anything like that in my testimony.
Okay, I think it's in the exhibit, in those interlinear paragraphs in the exhibit.
Can I check in with the council for a moment? I'm not.
Mr. DeSalen, he may or may not be the right person to answer that question, because Ms. Felix, I think, also addressed it.
Okay, well, his name is referenced in those paragraphs repeatedly. So I mean, I understand that he didn't write them, but he is testifying about the schedule and what the proposed revised schedule is.
Can I maybe clarify a little bit? The Exhibit 1 from NMOGA API is NMOGA API's submission, and I think Ms. Felix is the best person to address that, or Mr. Searles, depending on the topic. My testimony I will speak to, but when the API exhibit says Dr. Rensing, they're interpreting my testimony or reading from my testimony.
And Madam Hearing Officer, just to try to shed some clarification on this, Dr. Rensing has provided technical testimony based on his experience as to concerns about the department schedule and so forth. That doesn't encompass everything that's in the reasons in Exhibit 1. So certainly questions about that are fine, but some of them may be better directed to Ms. Felix or Mr. Searles.
All right, thank you.
Okay. Well, can either of you ask my last question, which was, you are assuming that the board will meet in February or March, is that correct? I'm sorry, I didn't hear that answer.
Now we're waiting, passing the mic.
That's correct.
Oh, okay.
That's correct, sir.
Okay, thank you. And then after the meeting, there would be 3 months. That's April, May, and June for the preparation of a final rule, a statement of reasons, and publication in the New Mexico Register. Is that correct?
That's correct.
Okay. And let's say that instead of July 1st, 2026, we just say that the effective date is the date of publication in the New Mexico Register. Would that not make more sense?
It could, if the commission decides to adopt the rule and make it effective on the effective date, yes.
I'm sorry, could you repeat that?
Yes, the effective date could be the effective date of the rule if that's what the commission decides.
Okay, thank you very much. So back to Dr. Resning. Is it your understanding that under the Environment Department's proposal, the entire program would commence on February 1st, 2016?
I believe that's what it says.
Okay, but the registration requirements would begin
Yeah,
and the accrual of credits would begin
yes,
and the accrual of deficits would begin.
yes.
Okay.
That's
But
my understanding.
okay, and that's what I'm asking for is your understanding. But under the NMOGA and API revisions, those requirements would be phased in. Is that correct?
Yes,
Okay, and that's in section 20.2.92.301K proposed by NMOGA and API. Is that correct?
sounds like it. It's 301K, right? Do you have a page number for that? Save us time.
Well, my page numbers might not be the same as yours, but yeah, 43, page 43.
Yes, I see it. Yes.
Okay, so under the NMOGA API proposal, the credits would not begin to accrue until January 1st, 2027. Is that correct?
Credits, yes.
And the deficits would not begin to accrue until January 1st, 2028. Is that correct?
Yes.
Okay, but it's not until the deficits begin to accrue that there is any real requirement to reduce the carbon intensity of fuels offered for sale. Is that correct?
That would be the effect of scheduling the stages of the implementation. The requirement would not be fully in force until the deficits start to accrue.
Okay. And your justification for the delayed schedule is to allow more time for suppliers to become familiar with the rules and for markets to become established. Is that correct?
Yes.
Okay. Now, let's step back just a second. And let me ask you, is this rulemaking, is it your understanding that this rulemaking is in response to legislation enacted in New Mexico?
Yes.
Okay. And do you happen to know when that legislation went into effect?
2024 April-ish, I understand.
Okay. So I believe that it was signed on by the governor on March 5th, 2024. Does that sound right?
That sounds right.
Okay. And so the industry has known about this program. It's not for all of the details, but it's known about the program since March of 2024. Would you agree with that?
Yes.
Okay. And would you also agree that we already have well-established markets for clean fuels in California, Oregon, Washington, and British Columbia?
Yes.
Is that correct?
With the proviso that California, BC are 15 years into the implementation. Oregon is 5 years less than that, 10 years, and Washington's about 3 years now. So the regulations are scale up in their difficulty. So each jurisdiction, the industry has experience commensurate with the reductions that are expected of them and the difficulty in implementing that level of reduction.
Okay, but that would, those other jurisdictions and those other markets would provide a foundation for New Mexico's program, wouldn't it? Or wouldn't they?
I don't feel I can give a yes or no answer to that. It depends on each market, what the details are, what the costs will be, and what decisions the suppliers need to commit to in order to get into compliance.
Okay, but it would give New Mexico suppliers an idea of what to expect. Would
Yes.
you agree with that? Okay, and is it true that British Columbia implemented its program in 2009.
The act and regulations came into force January 1st, 2010.
Okay. And the low carbon fuels market has evolved significantly since then. Would you agree?
Not quite. When the act and regulations were implemented in 2010, if we had continued without changes, there would have been a complete failure of the regulations within 2 years. We had made a fundamental policy misstep that looked really good. The California experts, the team at the UC Davis Center for Transportation Research, Colin Murphy's group, all saw no flaws with what we were doing. When we got the first year of compliance data where we actually had quality data, we discovered that the structure of the act would have implemented an unfair burden on the fuel suppliers who are subject to the regulation. We put a pause on the requirements and went through a process that led to an extensive rewrite of the act. And so I would then say the credit market started functioning in July 2013.
Okay, but again, my question it has evolved significantly since then.
It is since 2013, yes.
And we also have 3 other states in the United States that have adopted programs.
Yes.
Okay. And isn't it true that many of the fuel suppliers and other companies that are participating in the California, Washington, and Oregon programs are the same suppliers and other companies that will be participating in the New Mexico program?
I can't answer that. I don't know.
Now, let's assume that the Environment Department's estimates are correct and that the markets in New Mexico work as they're supposed to do. Given that assumption, the NMOGA and API proposal would delay the rules requirements for reduction in greenhouse gas emissions by roughly 1.5 to 2 years.
Objection asked and answered.
I think my question previously, Madam Hearing Officer, was slightly different. I was asking about the delay in the implementation of the rule. Now I'm specifically asking about delay in the benefits of this rule, the reduction in greenhouse gas emissions.
That's different. Go ahead, Dr. Ensign.
Can you repeat the question then?
Yes. Assuming that the markets work as the Environment Department anticipates, would the NMOGA API delay in the rules requirement for reduction in greenhouse gas emissions result in approximately 1.5 to 2 year delay in those reductions?
The requirements do not require emission reductions. They require carbon intensity reductions. My understanding is that the enabling statute requires a 20% reduction in 2030 and is not speaking to the details. The proposed draft that we're discussing today does set a schedule, and it would mean that there would have to be an adjustment to the schedule of carbon intensity reductions. One of the main reasons being if there's no deficits generated in the first year, there will be no recorded CI reductions. That doesn't mean that the carbon intensity average of fuels won't go down. It just means that it won't be regulated to go down.
Okay, but if the carbon intensity is reduced, that means carbon indirectly, that means that carbon emissions will be reduced. Isn't that correct?
Assuming that the amount of energy used in the state does not increase. Carbon intensity is per unit of energy consumed. If the carbon intensity goes down 5% and the amount of energy goes up 10%, there will be a net increase, as an example.
Okay, but all other things
Yeah.
being equal, then you would agree with me.
That there would be a reduction in the tons of GHG reduced over that period? Yes.
Okay. Now, let's look at your direct testimony. Again, that's exhibit NMOGA API, exhibit 14. Look at page 15, please.
Okay, I'm there.
Are you there?
Yep.
Okay, so you state at beginning around line 8, I think, that you believe that the Environment Department has overestimated the contribution of credits from electric vehicles. Is that correct?
I said may have overestimated.
Yes, right. Thank you for that clarification. And then beginning on line 13, you state the risk of overestimation has increased significantly since January as U.S. federal laws supporting the manufacture and sale of electric vehicles have been or will be repealed, and EV adoption rates can be expected to drop significantly from current levels as a result. Did I quote that correctly?
Yes.
Okay. And could you tell us what those U.S. federal laws are?
In general, there have been federal programs to provide rebates to the purchasers of electric vehicles. There is a corporate average fuel economy standard that mandated the improvement of fuel efficiency, but also drives the automobile manufacturers to have to produce electric vehicles. And I also know that there was expectation in California that if there was an easing of these requirements, they had an authorized exemption to set their own standards that is also on the block to be removed if the current administration has their way.
Madam Hearing Officer.
Ms. Sona.
I do not believe that Dr. Rensing has been set up as an expert to provide legal testimony. And so I would ask that those interpretations of the law be stricken from the record as legal conclusions.
All right, I'm less inclined to strike them, knowing, again, Dr. Rensing is not a lawyer and the board would not be relying on legal advice from him, but he was a regulator and familiar with implementing the program. So that's how I'm taking your testimony. Go ahead, Mr. DeSalen.
Okay, thank you, Madam Hearing Officer. So the corporate average fuel economy standards have not been repealed, have they?
I believe that the administration has been directed not to enforce it. And I don't have any further knowledge, but the information that I have through my contacts is this has introduced significant uncertainty. There is no clear signal as to whether vehicle manufacturers are going to continue producing EVs, and the incentives. That is as far as I go on that one. I will note that on the plane flying, or in the airport, on the plane flying right on the way down, there are already stories in the news. Ford estimates that their EV sales will drop 50% because the purchase incentives came off yesterday. So I think it's general public understanding that the federal programs play a significant role in the rate of adoption of electric vehicles in the United States. The zero emission vehicle mandates in California, Oregon, British Columbia, and Quebec play a very significant role going farther. And my understanding was New Mexico's regulations build on that and emulate the same for the state of New Mexico, but it hinges on the ability to rely on the federal support as a backstop for the rate of adoption.
Madam Hearing Officer,
Ms. Solon.
that testimony there was very clearly an interpretation of the impact of the law. That one in particular, I would more strenuously object to striking rather than just a direction for the board to not give weight to it. And I would add for this objection and the prior one that the experience established, I believe, in regulating is in British Columbia, which is Canada, not the United States.
I understand. I'm going to issue the same caution. Go ahead, Mr. DeSalmon.
Thank you. Now, are you aware that the state of New Mexico offers tax credits for the purchase of electric vehicles?
No.
Okay. And are you aware that New Mexico utilities offer credits or rebates to residential customers for the cost of installing chargers in buildings, electric vehicle chargers in buildings?
Actually, I would also like to revise that last no. I am aware of, and that's the limit of my understanding.
Okay, let's assume that those programs exist. Would you agree with me that those will offset any reduction or repeal of federal programs?
Only if they fully replace the dollars that are involved from the point of view of the purchasers of those vehicles, which means that if they've been stacking now, that those programs are going to have to step up and replace the loss of federal programs.
Okay, but they will at least partially offset any reduction in federal programs. Would you agree with that?
No, because they exist now. And if the federal program goes away, that's the impact. If there's no change in the New Mexico program, the incentives fall back to a smaller scale. There's no replacement of the federal program.
Okay, thank you. I think that is all my questions. Thank you, Madam Hearing Officer.
Thank you, Mr. DeSalon. Do we have Mr. Lobdell or Ms. Reno with us? Mr. Sorayas, do you have questions of the NMOGA panel?
We have no questions. Thank you, Madam Hearing Officer.
Thank you. Ms. Vercruz? I don't know if she's with us. Ms. Tremblay? Is Ms. Tremblay with us? Mr. Maxwell, do you have questions of the NMOGA panel?
No questions, Your Honor. Thank you.
Thank you. I don't know if we have Mr. Weatherby with us. Mr. Boutier or Mr. Harris? All right, he said no questions. Mr. Tucker or Ms. Jones? Thank you. Mr. Tucker said no questions. Mr. Wexler or Ms. Olson? All right. And finally, NMED. We have just 25 minutes before lunch, but we can make sure you have all of your time.
So thank you, Madam Hearing Officer. In looking at the 25 minutes we have before lunch and sort of the approach and structure we have to our cross-examination, we don't think it's going to be very effective for us to get started right now. We don't think this is going to prejudice the time for us to be able to finish this afternoon in any way, shape, or form. And so we would ask that rather than have to break up the cross and not be able to set the foundation with some of the questions that we have, that we would just take an early lunch at this point.
Sorry. The thing is, so I have to ask for public comment at 1. So we're going to have the same issue unless we take a almost 90-minute lunch.
Right. And we believe that from our perspective, our ability to get our cross-examination done, as long as we're not dealing with tons of objections that add to a lot of length, we're we're going to be fine to finish that up in time in the afternoon after public comment, even if we take an early lunch for 90 minutes.
Okay, and then obviously we have the 2 Oxy witnesses and the American Fuel witness as well, and we need to finish all of this by tomorrow afternoon.
Madam Hearing Officer?
Mr. Mullenberg.
Yeah, just to interject, I would also like to remind everyone that we agreed to the early 8 o'clock start date at the request of the Environment Department Council. So we could move this along, and you know, that meant some.
I think actually it was my idea, but
Okay, fair enough.
So I'm just hoping there's something you can do with 25 minutes.
I can ask some of my questions, but please anticipate we may be having to make a motion later to deal with potential prejudice.
That's fine.
Okay. Need my clock. All right. Ms. Losi, can I start with you?
Good morning.
Good morning. Thank you for joining us. As you heard, my name is Kelsey Sona, and I'm representing the New Mexico Environment Department. I want to start with some questions for you about GREET modeling. I do have a couple quotes from your testimony. I'm not intending to try and trip you up by reading them in the wrong way or anything. If you feel you want to turn to them, let me know and I can give you the page number. So you state in your testimony that, quote, and this is on pages 9 to 10, the R&D GREET 2024 model is a suitable tool for the New Mexico CTFP, as the R&D GREET model is used as the basis for the models used by other U.S. regulators. Is that correct?
Yes.
Okay. One of those regulators that you list is the Oregon Department of Environmental Quality, correct?
Yes.
Is it true that Oregon's GREET model was built directly from the California GREET model, which California was built off the R&D GREET model? And so it's not fair to say that it was directly built from the R&D GREET model?
I don't think I can answer that with a yes or no question. I would say that, you know, if A equals B and B equals C, then A equals C. So you could say that one model is built directly from another model, and therefore that model is built directly from another model. Additionally, the Oregon DOE model incorporated their own Oregon-specific factors, which also relate back directly to the GREET model itself. So, no, I would say that it is directly based on the same model.
So it's based on the R&D GREET in your characterization, with additional considerations that come from California GREET and Oregon's own parameterization choice.
Yes, I think that's accurate.
Okay. Can the same be said for the approach Washington State took for their Washington model?
Yes.
And so would you agree that for New Mexico, having their starting point being directly R&D GREET and parameterizing from that, rather than taking California GREET and parameterizing from that, means we're a step closer to using the basic of R&D GREET rather than Washington and Oregon?
I'm sure you could argue that, but I think that you're not representing the fact that the NM GREET model also includes factors that are directly from the California GREET model. So you're basically saying well, NM GREET is closer to R&D GREET, even though NM GREET is using factors from the California model, the exact same way that Oregon and Washington did. So I would characterize those as being roughly the same, in relation to the original Argonne National Labs GREET model.
Is it true that Oregon's GREET is not rooted in the 2024 model year of R&D GREET?
Oregon's, that's correct. The model predates 2024.
Throughout your testimony, you refer to R&D GREET models as unmodified, as well as using terms like GREET defaults, defaults in the base model, R&D GREET model defaults. Do you recall using some of those terms in your testimony?
Yes.
Okay. And you also state in your testimony that NMED made several changes to the default model. Do you recall that?
Yes.
Do these terms and the way you've described this, do they all essentially refer to the state of GREET that is the GREET model downloaded from Argonne National Labs?
Yes, that I would be referring to defaults as the version provided by default from Argonne National Labs.
Okay, thank you for the clarification. NMOGA and API advocate for the usage of an unmodified R&D GREET. And I want to understand your testimony because that was the position that I took away from your written testimony. But what I heard you say today in your oral testimony was something different, which was that the ask is for New Mexico to be as close to R&D GREET as possible and to use a less modified baseline model. So can you explain what you mean with that distinction?
Absolutely. So I think that it is not possible to calculate the values established in tables 1 through 5 of the CTFP red line without making at least a few changes in the default GREET model. For example, the default GREET model, R&D GREET 2024 and R&D GREET 2023, their simulation year is 2022. So in order to get a 2018 baseline number, you must change the simulation year to 2018. I think that the use of the word unmodified is referring to not including outside models. For example, the OPG model would be one outside model. The ILUC values would be another outside model. They're referring to unmodified in terms of those additional models. But there is no way, for example, to calculate the 2018 baselines without at least updating the simulation year.
So if I understand it correct, the recommendation to the board is not to use the downloaded R&D GREET from Argonne National Labs. It's to use a download that has been parameterized.
I wouldn't say parameterized. I would say has some specific inputs changed to get the required output. But to stay within the model as downloaded, so without using additional outside models such as OPG or C Club would be one ILUC model. Sorry, land use change model.
So I'm trying to understand and reconcile this use of the word unmodified, because in your answer to me for a question a few minutes ago, you said that yes, the terms default, unmodified, defaults in the base model, those terms referred to the downloaded version of GREET. But now what you're saying further is that what you actually mean by unmodified is the downloaded version of GREET with information changed through utilizing it. Is that right?
I would say with a few inputs changed to meet the requirement of the minimum number of inputs to meet the requirement of the statute as written. I agree that the term unmodified implies that you can just download the GREET model and then instantaneously the values are there. But that's not how the model works. So that's why in my oral testimony, I tried to clarify that by unmodified, we meant without external models input. We did not mean without any inputs put in. I think that summarizes what I intended. And I acknowledge that the written testimony, that could be confusing. That's why I tried to clarify in my oral statement.
Thank you, Ms. Losi. So in choosing these, can I use the word configurations? When you download the model and you go into it to start your work, you have to make selections to begin configuring the model to get to your life cycle analysis and begin your modeling exercise. Is it fair to say that those decisions suit certain purposes? Because you have to make decisions to be able to move forward, right?
Could you clarify for what type of output you're looking for? I'm sorry, I didn't really understand kind of what the end goal of your, like what the end goal of this hypothetical exercise would be.
Sure. I will try and explain this. I've gotten a lot of education from my team on GREET, so if I use the wrong terms, feel free to correct me, but I may not always be perfect. So I'm not looking more for an outcome in this question. I'm focused more on the beginning stages of it. And so I'm further expanding this question to understand that unmodified means you have to move through the model by making some selections. And there's options. There's more than one option. And maybe an example would help you. You shared with us that the petroleum jet fuel product baseline selection was changed from 1 GREET to 2 ICAO. And then you had also shared, I think, that the blend level of ethanol and gasoline was changed from 10% to 0%. And so I'm just clarifying, those are steps, those are choices you have to make when you start using the GREET model.
No, I wouldn't say that. What I would say is if you, let me provide an example. So those examples are specifically referring to modeling the 2018 baseline values. So if I were to open the GREET model and I wanted to model the 2018 baseline values, the first thing I would have to do is the simulation year in the model is 2022. In the 2023 GREET model, that's the default value. So the first thing I would do is I'd have to go into the model in inputs, the tab inputs in cell F8. I would need to change that number to 2018 because I'm looking at the 2018 baseline. And then if I wanted to then calculate what the ethanol-free gasoline value would have been in CI value in 2018, currently the GREET model uses a default value of 10% ethanol in the gasoline. That's the average for the US. But if I wanted to calculate the ethanol-free CI, I would need to change that number from 10% to 0%.
So you make these choices to fit an intended purpose for use of the model, correct?
Yes, I suppose. I'm not sure I would. Sure.
Okay. Shifting this topic slightly, in your testimony, you referred to R&D and GREET, the 2024 model. Can you share which version of R&D and GREET you mean for that and which models you used?
The full name of the model is R&D GREET 2024.
Okay. And so are you referring to the model that was released in January and not the most recent model that's the revised one released in May?
I think what.
Can we clarify that as to year?
20, I'm talking about the 2024 model.
Okay.
The Argonne National Labs R&D GREET models are released every year in April. So I'm not clear on what you're referring to. I'm not aware of any models released by Argonne National Labs in January. Their annual model comes out every year in April, or May if they have a delay.
Are you aware of a more recent released model that is titled as the R&D GREET 2024 Revision 1?
I think what you're referring to is the R&D, it's actually the GREET, I believe, the GREET 1_1 2024 model, which was released as packaged with the changes to the 45Z program from the IRS, the Internal Revenue Service. And that is a different version of the GREET model. It's also based on the R&D GREET model, but it is not the R&D GREET 2024 model itself. I believe that's what you're referring to, but if there is another GREET 2024 model that was released in January, I'm not aware of it.
Can you share which, from the model that you used for your work for NMOGA and API, what month and year was that released in?
I can check the, let me check the.
If you say that April of each year is when they're released, would it make sense that 2024's was released April of 2025, or is it April of 2024?
It's April of 2025. And I'm looking now, and I do believe that we're using the Rev 1 version.
You emphasized in your testimony the importance of others being able to reproduce results from modeling, correct?
Yes.
Did you submit your GREET modeling files as part of the record for this proceeding?
No, it was never requested until I think this week was when it was first requested.
And by requested, do you mean that NMED asked for them on Tuesday to try and help understand your testimony?
That's what I'm referring to, yes.
Okay. Do you recall that NMED asked for them before this hearing began?
I believe that the first time it was requested in writing was this week, yes.
Do you agree that those files are very important for someone else's ability to reproduce your work?
Yes, I would agree that those files are very important.
On page 7 of your testimony, you shared with us, and I'm just going to generically characterize for you. You shared with us how you were unable to find the documentation or reproduce ERG's OPG calculations for New Mexico GREET. Do you recall that?
Yes.
Okay. Were you listening during the hearing when Mr. Kupal was testifying?
I heard portions of his testimony, yes.
Okay. Did you hear him explain that ERG's appendices specifically contained that information? And by appendices, I mean the ERG report that was filed as an NMED exhibit and the appendices within that exhibit.
Yes, I'd also like to expand on that. Thank you for asking this question. I did mention this in my oral statement that that was specifically released on September 2nd after the deadline for my written testimony. And therefore, as you mentioned, having backup information is very important for transparency. That information was not provided ahead of the deadline for written testimony by NMED. And I can read for you the full statement that NMED provided prior to the September 2nd release that I felt was insufficient to understand how that OPG value was calculated. There's perhaps a 2 to 3 sentence statement in the New Mexico GREET model that's supposed to explain the OPG calculations, but OPG has 72 independent inputs. And so it was impossible with the information publicly available from NMED prior to September 2nd to determine how that number was calculated.
Okay, but is it fair to say that now that that information has been provided, you would likely be able to go reproduce those results?
As I stated in my oral testimony today, we will be reviewing that as part of our written rebuttal testimony, but as that is outside of the scope of my written testimony that I am talking about today, I can't answer any further questions on that.
Okay, fair enough. I think, Madam Hearing Officer, this is a natural break for me.
All righty, thank you very much. We'll return at 1. We have, I believe, at least 2 public comments to accept then, and then we'll return to your cross. Thank you.
Yeah, find out how much time is left for Ms. Losey.
Yes, she has 10 minutes left.
Thank you.
You're recording? All right. We come now to the 1 o'clock public comment session for today. And we have several folks signed up for public comment. Just a few things about offering public comment in this hearing. I will ask you to spell your first and last name. I will ask you under the board's rules to swear or affirm that you will tell the truth. I will ask you to keep your comments to 3 minutes. And we can accept oral comment from each person only once. If you have more to say than you can fit in 3 minutes, you are able to submit written public comment to the administrator, Pam Jones, here at the podium, up until some point in the week of November 17th before we adjourn the entire hearing. Lisa, would you please?
Good afternoon. If there's anybody present here in the hearing room that would like to give their public comment in Spanish, if you could just please come up to the podium, let us know, and we have interpreters available to interpret into English. Buenas tardes. Si hay alguien aquí que quisiera dar su comentario público en español, por favor avísenos y pasen adelante. Tenemos intérpretes disponibles para interpretar su comentario al inglés. For anyone who is on the Webex platform that would like to give a public comment in Spanish, if you could please send us a chat and we will put you down in order. And we do have interpreters available who can interpret your comment into English. Si hay alguien en la plataforma de Webex que quisiera dar su comentario en español, por favor, déjenos saber. Y con mucho gusto, los intérpretes le van a interpretar su comentario al inglés.
Thank you very much. Oh, just one more thing. When folks read, they tend to speed up a lot. And since we have 2 interpreters and a court reporter trying to capture your every word, it's important that you maintain a reasonably slow pace for your statement. So the 2 folks who indicated in the last couple of days they wanted to speak at this session are Paul Gessing and Antoinette Reyes. Mr. Gessing, are you in the room or on the platform? No. No? Okay. Antoinette Reyes, are you in the room or on the platform? Okay. Tony Gerlix. Hello, would you spell your first and last name, please?
Sure. Tony, Tony, Gerlich, Gerlicz.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Yeah, thank you, members of the the dais. I come here as a private citizen, really, a concerned private citizen, and one that's giving a lot of feedback. I'll stand further back here, but really,
I'm going to, oh my God. Should I go?
sure.
Try it again. Yes, no? No. Yes, no? Is that better?
Testing, testing.
That's a little better. I think it's still too much.
Testing, testing.
Much better. Thank you. Alrighty. My apologies, Mr. Gerlich. Please resume anywhere you'd like in your statement.
No problem. I come here today as a private citizen, a concerned private citizen, and as a retired educator here in Santa Fe, having founded and developed 2 schools for secondary school students, the Monte del Sol Charter School and the Mandela International Magnet School. And so I wear that hat as an educator as well. And I'm reminded what we used to ask kids and teachers all the time is, what's the point and the purpose of education? Why are we starting these schools? Why are we getting educated? And we would historically answer that, well, we want you to use whatever skills you develop here with us to make the world a better place in any way, shape, or fashion that you so choose. Use your hard skills, use your soft skills, and employ them for the benefit of society and the community at large. And it's for that reason primarily that I urge you to adopt these clean transportation fuel standards. Not really for me and my generation, mostly for my children and my grandchildren's generation. And speaking of children, my son is the director of sustainability for Netflix, and Netflix as a company and a corporation is already adopting very high fuel transportation standards as well as other standards. And with their footprint here in New Mexico, in addition to California, it just makes total logical sense to adopt these standards as well so we can move clean energy forward. And it's not that we want to shove anything down anybody's throat. We're not getting rid of fossil fuels, but we need to nudge human beings, private citizens, and private companies in a way that makes it easier for them to adopt these standards. That's the nudge why we bought our electric vehicle years ago. It wasn't shoved, it was a nudge that we move forward. And that's why I urge you to do the right thing and to adopt these fuel standards. Thanks very much.
Thank you very much. Next is Gary Payton. If you would please spell your first and last name.
My name is Gary Payton, G-A-R-Y-P-A-Y-T-O-N.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
I hope you each had a good lunch break. My name is Gary Payton, and I am speaking on behalf of the Coalition of Sustainable Communities New Mexico. Our organization is a coalition of governments that includes the cities of Las Cruces, Albuquerque, Santa Fe, Bernalillo and Santa Fe counties, and more. Our elected members represent half of the population of 2.1 million in our state of New Mexico. I'm here to express our strong support for the proposed clean transportation fuel standard. The rule is not just another piece of regulation. It is a key to New Mexico's climate strategy. The transportation sector, as you well know, is the second largest source of greenhouse gas pollution in the state. Addressing these emissions is essential in protecting our air, water, and the health of our citizens. We commend the Environment Department for its balanced approach in translating the 2024 legislation into this draft rule, and we urge you to implement it on schedule. Any delay is a missed opportunity to secure a healthier New Mexico, especially in the face of the dramatic rollbacks in federal environmental regulations. The program's 20%, then 30% reductions in fuel carbon intensity are ambitious but achievable goals, and they send a clear signal to the market that New Mexico continues to be serious about clean energy. The potential to generate millions of dollars of credits will create a powerful, self-sustaining engine for private investment in clean transportation solutions. A critical component of an effective rule is recognizing the science-based climate benefits of electric vehicles. They're more efficient, increasingly run on a cleaner grid. Thanks to our Energy Transition Act, our state is on path for 50% renewable energy by 30, 100% by 2045. As our grid gets cleaner, so does every EV mile driven. We urge you to reject any arguments designed to protect legacy industries and undermine New Mexico's clean energy leadership. Our county and city members, which include public fleet owners and operators of public charging infrastructure, are not just supporters of this transition, they're active participants. They are working to electrify municipal fleets, from sedans to transit buses to fire trucks. They're installing charging stations at public facilities, and they're eager to participate in the credit market to leverage local investments for greater impact. This standard will empower cities and counties to do more faster. Finally, we encourage you to ensure that the rule allows public transit agencies to earn credits for projects that deliver additional emissions reductions. Investing in public transit is an investment in equity. It provides affordable mobility, reduces congestion, cuts harmful air pollution. All of these things that expand the services aid our low-income and underserved communities. Thank you very much for this opportunity to comment. We urge you to move forward without delay and adopt a strong, clean transportation fuel standard. Thank you very much.
Thank you, Mr. Payton. Next, we have Owen Peterson. Hello.
Hello.
Would you spell your first and last name, please?
Yes, Owen, Owen, Peterson, Peterson.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Hello, everybody. First off, thank you for the opportunity to provide public comment on such an important rule. I just want to say before I begin, I'm here on my own behalf and my views are exclusively my own. My name is Owen Peterson. I'm 30 years old. I live in Santa Fe County. I grew up here, and in my lifetime, I have seen the effects of climate change firsthand. It's a very important issue to me, and I think I'm very excited for New Mexico to step up and be a leader on climate action. That's all I have to say. Thank you for everyone who's had a hand to play in these rules, and looking forward to the result. Thank you.
Thank you, Mr. Peterson. Wes Jensen.
Hello.
Hello. If you would please spell your first and last name.
Wes Jansen, Wesjansen.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Hi, everyone. Thanks for the opportunity for giving public comment. I'm very nervous. I do not like public speaking, but I think this is important enough that I'm up here, so I'm going to do my best. I'm 28 years old. I was born at St. Vincent's Hospital, and I grew up here in Santa Fe. I feel very lucky to be able to call this beautiful state my home. And I'm very excited and fired up to see progressive climate action measures like the Clean Transportation Fuel Program taken seriously in the state. As a young citizen here in New Mexico, I want to see that our government is taking action to be on the front lines of the fight against climate change and being an example for states around us to show that there is a path towards a healthy future of our planet if we have the courage right now to stand up to those whose private financial interests are keeping us in the past. I work in the climate technology sector. My company builds building efficiency software to reduce carbon emissions. Slow down, thanks. Like I said, I'm nervous. My building builds building efficiency software for the real estate industry, commercial real estate industry, by controlling optimum startup and shutdown times of energy-hungry heating and cooling systems for large buildings. We are doing our part in doing our best. However, the truth is that in the pie of carbon emission sources, buildings make up a much, much, much smaller sector or piece or slice than the heavy hitters like transportation, which makes up almost a third of national greenhouse gas emissions. We have to find cleaner fuels to operate our transportation needs. And from what I know about it, adopting the Clean Transportation Fuel Program, rules as they are written today is low-hanging fruit, and I believe we would be making a massive mistake to not adopt them right now. I'm impressed with measures like this that don't impact consumer wallets, but rather create a new credit market that provides opportunity for companies committed to producing clean fuels, and most importantly, holds corporations accountable for their actions that contribute negatively to our climate and forces them to either change their ways and get on board or pay the consequences. I urge you to listen to the citizens of this state as we stand before you, having taken time off work to plead for action that will support a brighter and cleaner future for us and our future kids. For those who oppose these rules are protecting private interests and massive corporations that do not share the values of those who live in our community, and we expect much, much more than to let them get in the way of our future. We expect clean air. We deserve a future in which we can raise kids without the fear of forests burning down around us, and we deserve a future in which New Mexico is a role model for our country in fighting against climate change. We deserve action, and we deserve it now. Thank you very much.
Thank you, Mr. Johnson. Acacia Burnham. If you would please spell your first and last name.
Yeah, Acacia Burnham, Acacia Burnham.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Okay. Thank you for the opportunity to give public comment. My name is Acacia Burnham. I'm 25. I grew up in New Mexico, and I love this land. I love it here. It's like nowhere else on earth. And in my lifetime, I've felt and seen the impacts of anthropogenic climate change, including rising temperatures, increased wildfires, and worse droughts. I'm in favor of anything that will reduce greenhouse gas emissions, reduce pollution, and help protect our ecosystems and our communities for generations to come. My understanding is that the Clean Transportation Fuel Program can help with that. And that's why I'm here making public comment in support of it. Thank you.
Thank you, Ms. Burnham. Aviva Faust. Hello.
Hi.
Do you spell your first and last name, please?
Aviva, Aviva, Levy, Levy, Faust, Faust.
Thank you. Do you swear or affirm to tell the truth?
I sure do.
Thank you. I'll start your time.
So I stand before you as a private citizen. My history is I'm a lactation consultant. I've worked with many, many small babies, some of whom had some breathing issues, premature. And I just wonder if each of you might know people who have asthma, who have, or elderly, use oxygen like I do sometimes, who are affected by poor air quality. Or perhaps in the future, you'll have grandchildren who are affected by poor air quality. We are at an opportune moment to make an actual difference in the quality of the air here. So JAMA, the Journal of American Medicine, and again, I'm not a public speaker. It is making me very nervous. But JAMA has studies, and we've known this for years. I'm just going to cite one, is a cohort study. This is from 2024 of 5,279 children. And then air pollution during the first 3 years of life were associated both with asthma incidence by early and by middle childhood after adjusting for individual level characteristics. What that is a real difference we're making. If we talk about fuel efficiency, we talk about climate change, but air quality is also right up there. And we have an ability for you to say, I was part of that. I protected this next generation. Or perhaps in the future to hear about somebody who is suffering from asthma and think, I wonder what would have happened if I took a stand then. Please don't let it haunt you. Please vote to approve this measure and to help us move forward in a way that protects our environment and our children. Thank you.
Thank you, Ms. Faust. Alexandra Faust. I'm sorry. What? Okay. Hello, if you would spell your first and last name, please.
Of course. Alexandra, Alexandra, and then Faust, Faust.
Do you swear or affirm to tell the truth?
I swear to tell the truth.
I will start your time.
Great. Hello. I'm grateful for the opportunity to speak with all of you. I am born and raised here and returned here because I love Santa Fe and I love New Mexico with all of my heart and soul. And that love is what has brought me here to talk with you today and to urge you to adopt the Clean Transportation Fuel Program rules, which will help ensure that that love of mine, but of the next generations, can continue. I am also not just speaking for myself, but also for the many friends who wish that they could be here, but have other obligations like work that prevented them from saying these same things. And also, I'm an elementary school teacher. I teach art to a number of different aged elementary schoolers, and I'm here talking for them. We ended up in a conversation about climate change earlier this week that absolutely blew me away and completely derailed the speech that I had initially planned that speaks about, the percentage of emissions that come from transportation fuels and how this can make a real impact on that. The thing that standards like this already exist, so we have some roadmap to follow, but adopting this now means that we can be a leader in this kind of policy across the nation. And experiences of mine living in Texas and California and spending some time in Shanghai, China, that have proved to me and the people around me how much of an impact air quality has on the quality of our lives. But this conversation with these children who then left me with these images to show you both of the world that they want to see, but also of the forest fires and the devastation that they've felt and seen within their lifetimes, and the thing that they want to avoid of air pollution on cars and what that does to our health, of general pollution, of actors who are getting in our way and continuing to try to stall our ability to take action on climate change. This one is labeled bad with X's on the eyes. And like Earths, I've just been sitting with like the heaviness of knowing that these 7 and 8-year-olds have already felt these things and are so innocently capable of knowing what they want for their futures and knowing that measures like this help protect the next generation, who are them and the people that come after them. And then also some beautiful images of the world that they love and want to protect and want more of. This is a forest, a thriving forest with plenty of food for animals and for us. We are all in this together. I urge you to be in this with us and adopt the Clean Transportation Fuel Program rules immediately, yesterday, but today or soon. Thank you.
Thank you, Ms. Faust. I believe Ms. Reyes is on the platform now. Ms. Reyes?
Yes. Can you hear me?
Yes, I can hear you. If you would spell your first and last name, please.
Antoinette, Antoinette. Last name Reyes, Reyes.
Do you swear or affirm to tell the truth?
Yes.
All right, I'll start your time.
Thank you. My name is Antoinette Reyes and I live in southern New Mexico. I want to speak today about the benefits of electric vehicles and why it's so important that New Mexico continues to move forward with policies that help families and communities make the transition.
Ms.
Personally,
Reyes, I'm sorry. I have to ask you to slow down a little bit.
Okay, sorry. Personally, one of the things I love about driving an EV is the reduced maintenance. No oil changes, fewer moving parts, and fewer costly surprises mean more peace of mind. That is not just a convenience, it's savings that can go back into families, households, and small businesses. But the benefits go well beyond cost. When more people drive electric, we all breathe cleaner air. Here in New Mexico, air pollution is not an abstract issue. It's a daily reality that shows up in nosebleeds, headaches, and worsening respiratory illness. As a mother, I see this firsthand. When my children has asthma, and the difference that cleaner air makes is dramatic. Fewer attacks, fewer missed school days, and the chance to grow up healthier and stronger. That is why the proposed New Mexico rules matter. The state credit can help fill the gap left as the federal credit expires at the end of the month. I believe it ended in September, actually. Making sure families don't lose momentum in adopting cleaner cars. And these rules are about more than individual purchases. They are about building the infrastructure to make EVs practical and accessible to everyone. Expanding chargers in public spaces and especially at rental units means people aren't left behind just because of where they live. Even my own experience points to this. While charging on long trips takes planning, it also shows how much opportunity there is. With stronger charging infrastructure, the barriers fall away. Investing in this network makes adoption smoother for all families and ensures that driving electric is not just possible, but practical. Supporting EVs is about more than cars. It's about healthier kids, healthier communities, and a more resilient future. For families like mine, it's about breathing easier, both literally and financially. I urge you to adopt and strengthen New Mexico's rules so we can build on these benefits, close the gaps left by expiring federal support, and make clean vehicles accessible for every New Mexican. Some asks are that there is not a delay in the implementation schedule, which would result in less greenhouse gas reductions and delay the benefits for New Mexicans, and the necessity to include an energy economy ratio for the program to fairly treat EV efficiency, as well as the importance of including credits for the build out of the fuel supply equipment, which would help fund the EV charging infrastructure I referenced. So to close, for my daughter and for every child who deserves to grow up breathing clean air, I urge you to act. Thank you for your time.
Thank you, Ms. Reyes. Jessica Shelton. Ms. Shelton, can you unmute yourself?
Good afternoon. I'm Jessica, Jessica, Shelton, Shelton.
Thank you. Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Thank you. Good afternoon. My name is Jessica Shelton. On behalf of Animal Protection New Mexico, I want to start by thanking NMED and the Environmental Improvement Board for your work on this proposed rule, and Governor Lujan Grisham for her leadership in fighting climate change. Animal Protection New Mexico is strongly supportive, but we must also raise serious concerns over the avoided methane crediting for biogas sourced from large animal agriculture operations. It's important to note captured methane doesn't come from small family farms with pastured animals, so small family farmers don't benefit from this program. The benefits are solely for big factory farms and mega dairies, where thousands of cows are tightly confined for their entire lives, and their manure accumulates under their feet and is moved into giant manure lagoons, largely untreated, where it festers and produces methane gas. While it may be inadvertent, nonetheless, the current proposal encourages, with financial incentives, large industrial mega dairies to grow and multiply with as many cows as possible to create as much manure and methane as possible. Why is this bad policy for New Mexico? New Mexico already has the largest average dairy herd size in the country. And according to the latest data we've seen, our mega dairies generate 11.5 billion pounds of manure every year. That's 4 times more than New Mexico's human population. The resulting manure and urine are notorious for polluting groundwater and drinking water. Mega dairies subject local communities to dangerous public health threats and nuisances. They use enormous amounts of New Mexico's precious water, consuming 1.63 million acre-feet of water every year. And they are the site of some of the worst large-scale animal cruelty found in the state. Most recently, this year, the New Mexico Livestock Board undertook a felony animal cruelty investigation of a mega dairy in Roswell with approximately 6,000 dairy cows and calves after footage showed cows being brutally beaten and pregnant cows having calves prematurely and violently extracted, resulting in injury and death. So, for reasons of clean and available water, healthy communities, and humane treatment of animals, the last thing New Mexico should do is adopt a policy that gives factory farms and mega dairies a green light to get bigger and create even bigger problems. We strongly urge the board to craft the final rule such that the state is rewarding true reductions in greenhouse gas emissions, not paying polluters to create even more pollution and the harm that comes with it. Thank you so much for the opportunity to comment.
Thank you, Ms. Shelton. Is there anyone else in the room who would like to offer comment at this time? There will be several other opportunities, including 1 o'clock tomorrow afternoon. No? Is there anyone else on the platform? Please raise your digital hand. No? Okay, thank you, Luis. I'm sorry, Vice Chair Trujillo.
I just want to take a moment and thank you all for coming and giving public comment. I also get nervous talking up here. So thank you for having the courage to come up and share what you're most passionate about, and for those on the platform as well.
Thank you. Thank you all. We'll return to the technical case at this point. All right, we have the NMOGA panel back in their seats. Ms. Sona, you have 10 minutes left with Ms. Losi and all the time with everybody else.
Thank you, Madam Hearing Officer. Do you guys have a microphone? Oh, the batteries get changed at lunch and they get charged. We have a lot to say.
Go ahead.
Okay. Thank you, Madam Hearing Officer. All right. Ms. Losi, I wish I had 2 hours to talk to you and ask you more questions, but I'm going to try and keep it consolidated for our 10 minutes left. I say 2 hours because that's what our witnesses answered questions for. In your written testimony, you explained that California, Oregon, and Washington use what's considered like a tier 1 model and a tier 2 model, correct?
Could you point to the section of my testimony where that's stated?
Sure, it's on page 15 of your testimony. And the quote begins with listing the states, California, Oregon, and Washington.
Yes, I'm with you.
Okay, and is that what that portion of your testimony is saying?
Could you repeat what you were saying at the beginning was do you want me to repeat the quote or?
So I'm just generally asking, do California, Oregon, and Washington use tier 1 and tier 2 models?
Yes.
Okay. For a tier 1 model, is a good way to explain it as being a simplified calculator, often in an Excel spreadsheet, that lets users input data in sort of a structured way?
Yeah, I think that's an accurate explanation, if not heavily simplified.
We're just going for a high level.
Yeah.
So by contrast, the tier 2 models are a more robust, full life cycle analysis model with all the complexities that come along with GREET, right?
Yeah, I think that a way to explain the difference is that the tier 1 models are applicable to only one common type of fuel that's produced in a standardized way. So as an example, corn or ethanol from corn, the California has a tier 1 model for ethanol from corn, as opposed to the tier 2 model, which has every fuel, I guess not every fuel under the sun, but dozens of potential fuels, including some very uncommon ones.
In your experience, have you done a tier 2 application previously?
Could you explain what you mean by done?
Like, have you completed one on behalf of an applicant to assist them with their submission to a government agency?
Yes.
Is that something that Tricord assists its clients with?
Yes.
Are you aware of the specifics of the NMOGA and API proposal that eliminate the tier 1 pathway?
Yes, I believe that their proposal does suggest eliminating the tier 1 model.
Is this because they propose that table 5 be used indefinitely?
I couldn't speculate on why the reasons for that. That's more of a policy. That would be a question for the other two panelists.
Okay, I'll ask it a different way then. Are you aware that in the proposal, in addition to table 5 being used indefinitely, the only manner of changing the values in table 5 would be through rulemaking with the board?
I think that is true for both the NMED's proposed rule and also I think it's the proposal for NMOGA. Frankly, I'm not really an expert on NMOGA's red line. I would have to defer to them on that. I mean, I've read it, but that's the extent of my involvement with Exhibit 1 itself. Is the same as yours. I've read it, but I don't remember every aspect. Sorry.
That's fine. Assuming that was the proposal that's contained in there, does that mean that I'll skip past that and ask it later. So on pages 15 and 16 of your testimony, kind of starting near the end, I'm going to paraphrase quite a bit because it was a really long quote that I had been looking at. But in general, what I took away from that was that GREET covers almost every possible fuel pathway, even new ones. And that makes it a useful tool, but also, on the other hand, it's pretty big and it can be hard to use. And so with that, small input errors can swing the results that come out of the analysis. And even experts can get very different numbers for the same fuel. Is that a fair
Yeah, I think you've
characterization?
paraphrased it accurately.
Okay, thank you. I try. If NMOGA and API eliminate the tier 1 calculator from options and require the use of the full R&D GREET model, does that mean there's going to be applicants working in a system that's very complex, more open to interpretation, and more prone to inconsistent results?
Well, NMED has not provided a tier 1 model at all. And so I don't, without something to compare to, NMED has not provided a tier 1 or a tier 2 model. They've provided NM GREET, which was used to calculate the values in tables 1 through 5. So they have not provided, like, this is the tier 2 model, and they've not provided any tier 1 models. I don't think it was ahead of September 2nd, they have not provided any tier 1 models. So I couldn't speculate on whether the non-existent tier 1 model is more or less complicated than any other existent model.
In your experience with what other states do with tier 1 and tier 2 models, in general, is a tier 2 model more complex?
The base tier 2 model let's use a concrete example in California. That is the R&D GREET model with some inputs into it. And that has, and it's very complex, you're correct, more than 30 tabs, hundreds of, thousands of calculations. It is very complex. The tier 1 models that California, so for example, the California tier 1 model would be only applicable to a single fuel. So for example, ethanol is one example of a tier 1 model. So yes, I mean, a spreadsheet that is only applicable to one very limited subset of overall fuels would be simpler than a very large model that has all of the fuels in it. But in theory, if you took every tier 1 model and put them all together into a giant additional model, it would be just as complex, perhaps, depending on your vision of what complex means as the tier 2 model. Does that make sense?
So my takeaway from this is that in general, tier 2 is more complex. And so my follow-up question to you is, do you support the recommendation to remove the more simplified pathway option for industry seeking to participate in this program in New Mexico?
I think that I feel as though you're misrepresenting what complex means. I think when we're evaluating whether something is complex or not, we need to determine to whom it is complex. Who are you referring to? Are you referring to the public as a whole? Are you referring to people who might want to enter the program as pathway applicants? Are you referring to those who have very unusual fuels that they want to sell in New Mexico? I mean, what perspective are you asking whether this is complex or not? I guess it's whose perspective you're looking at.
So my perspective would be looking at a industry seeking to come to New Mexico, and where they may have a staff member that has the qualifications to be able to complete a tier 1 pathway using that model, compared to if they were required to use tier 2 because that option was foreclosed to them, they would have to go hire a consultant to guide them through and to do that process for them. And so they would then be forced into a position of having to hire someone that this isn't complex to. But for a certain business, it may be too complex for them to handle in-house. And so my question is this the best recommendation for a regulatory program in New Mexico?
Sorry, give me a minute. Your question was quite like a compound question. I think that it seems as though your question is, if I were a fuel producer of any type who wanted to enter the New Mexico market, would it be easier for me to enter on a tier 1 pathway or a tier 2 pathway? Is that your question?
I think that's a good way to characterize it, if you have an answer to that.
Yeah, I think that question is too broad. You need to give very specific examples. I mean, so for example, in the California market, there's a short list of fuels that have tier 1s. So yes, I think if I were the existence of a tier 1 model for ethanol makes no difference if I'm an algae biofuel producer. It doesn't matter to me. The outcome is the same. So yes, for specific individual companies, having the availability of a tier 1 model does make their compliance perhaps simpler, although in practical terms, the list of applicants, if you look at California who are using tier 1 versus tier 2 models, I don't know the exact breakdown, but it's not the vast majority who are using tier 1 models. So I think that you're trying to kind of generalize that having the tier 1s is more simple for everybody, but that's not accurate to say. For a lot of entrants, the tier 1 models, there's a short list, and so it doesn't apply to them at all.
So unfortunately, I think I've run out of time to follow up on the specifics in the rule that have to do with that. So I guess unfortunately we have to just leave it there with non-specifics. Thank you, Madam Hearing Officer.
All right.
If I may have just a minute.
Yes.
Okay. Dr. Rensing, it's me again.
Good afternoon.
Good afternoon. Let me restart my clock. Okay, so I have a lot of questions for you. You've shared a lot. I'm going to try and move through them as neatly as possible. First off, can you clarify for us, you shared a little bit about your role with the Red Line, but specifically, did you help write the Red Line changes in the rule for some provisions, or would you more characterize your participation as testifying on what those final changes were as proposed by the NMOGA and API members?
So there have been drafts of the Red Line. I commented on an earlier draft, and in the current draft, I see my name. As Dr. Rensing can provide information on this, that the area around that text reflects the feedback I gave to the team that drafted the Red Line.
Okay, thank you. I want to sort of jump us into the middle of a few of Mr. DeSalen's questions. And I'm going to try really hard to not repeat them. But one of the pieces of your testimony is that you wrote, you are, quote, concerned about the lack of time available to plan and execute all the actions needed to comply, end quote. Do you recall stating that? Is it your opinion that industry has not been planning for this rulemaking and for a clean fuel standard since House Bill 41 passed in 2024?
I don't have any understanding of what New Mexico industries have actually been doing. I have my experience both in the province of British Columbia and nationally with the Canadian industry as a whole, that at some point in planning for compliance on a regulation like this, you need to spend money. You're either going to be changing your fuel contracts to get more low carbon fuel, or you're going to have to go to an auction market to buy something that your president never heard of before in their life, and you have to convince them to give you a budget of millions of dollars. Or you are going to get your fuels and you need to make sure that you can transport them from new sources through new modes of transportation to get them into the market, and that will take some investment. These investments will make or break the profitability of a company if they are handled right, which means that as they go through their corporate due diligence processes and their budget planning, they need to figure out all the risks and they need to plan. When you have a very short timeline, and in the fuel world, a year is kind of short, not too short, but by now I'm sure that there are suppliers in New Mexico that have contracts for purchasing that are more or less take or pay. In other words, if they don't take the fuel, they forego and they still have to pay for it. That would have to change as they plan for compliance. And they are planning for compliance. I'm sure of that as well. That's not based on knowledge. That is like nobody is foolish enough not to.
So your advice to them would be, when you heard this was coming, start planning.
Yes. And can I elaborate a little bit?
Well, we only have 30 minutes.
Yeah, I know. And so part of what I want to talk about, and I'll let you decide, but what plans do you make when the options are too broad?
So I don't testify.
Yeah, I know. So I'll call it a rhetorical question.
Another piece of this that you shared in your written testimony is regarding the DMS system that New Mexico is developing. And you stated that you, quote, anticipate that there could be delays before all regulated entities are able to report. Is that correct?
Yes.
Okay. Do you have personal knowledge of the status of the New Mexico DMS?
No.
Okay. Turning to deferrals, does any other jurisdiction have an automatic trigger to defer without agency discretion?
I can only say that BC does not, and neither does the federal Canadian, and I can't speak to Washington, Oregon, or California.
Okay. Are you aware that in NMOGA API's red line, in section 601, which is the deferral section you've testified about, that the proposal is that if there is an inadequate credit supply or excessive credit costs, then compliance obligations would be automatically deferred?
I don't recall the costs part.
Costs for fuel costs or credit costs?
Sorry, give me a moment to find this section. Do you have a page?
This is the one piece I did not write the page numbers on.
Okay, I can find it. This is going to take me longer. 601. I'm still in the 500s.
And this would be under the forecast deferral section, which comes after the
Yes.
emergency deferrals.
We can talk forecast.
Hmm.
Is that the question? I'm just trying to help find it.
Forecast deferrals, yes.
so that's
I believe it's subsection B.
That's
B.
B? No, it's forecast deferrals is C. It's on page 97. And the comments, the first comment I see says that API and NMOGA recommend a qualified third party be contracted to provide the forecast. And then
So
there's
this
another.
would be in this, let me think of an easier way to do this for you. In the red line, the proposal specifically states that compliance obligations would be deferred if there are sudden fuel increases. Is that correct?
I'd like to read it. So this is the red line C1 that was proposed.
I believe that's where it would be, yes.
I'm sorry, I don't see anything that says cost, but I'm reading it quickly. So
Let me ask it this way. In your experience, would a sudden fuel cost increase be something that would be of the nature that a deferral might be considered?
I don't have any, nobody has any experience to answer that question on the basis of experience. You're asking whether cost would be a consideration. I believe that the proposal is simply credit versus deficit balance consideration. Cost didn't enter into that.
So if,
Am I missing something? That's what I'm.
well, perhaps I'll take a break and come back to this and give you the correct citation, because my homework obviously didn't do myself justice for this question. Much of your testimony involves the credit market and the credit supply the market will potentially generate, correct?
Yes.
Are you aware that your testimony on these issues is fully mirrored in the Stillwater report?
No.
And as part of this rulemaking, you shared that you have a mathematical analysis to support your testimony. And I believe you said that that would include about potential credit supply issues. Is that right?
Effectively, yes.
Do you consider your spreadsheet proprietary?
Yes and no. Yes, in that I don't like releasing public copies because I use that to support my work as a consultant.
Is that why that spreadsheet was not included in this record?
The spreadsheet was not included because it didn't occur to me that by mentioning it, I brought it into the scope. My statements are, to what is a scientist, a simple hypothesis followed by a conclusion. And I believe that those are all supportable if the hypothesis is correct. And so the spreadsheet I'm referring to helped inform me as to whether my hypotheses were reasonable in terms of the quantities of credits, the balance in the market between gasoline and diesel, that kind of thing that affects compliance.
Okay, so one of the opinions that you shared about what could affect compliance was your warning that electricity credits may be overstated and that reporting delays will prevent credits from being generated in early years. Is that a fair characterization?
Not quite. I'm actually, in those considerations, I'm actually thinking of the first few quarters, fractions of a compliance period, because the time between the proposed date, February 1st, I know that there's talk of it being later, but that could worsen the situation. By the end of the year, the fuel suppliers need to retire enough credits to offset the deficits they generate. If there's any glitch in getting those electricity credits available for purchase, visible in the market, there will not be, or not will, there could be a shortage of credits that is very near term, that has to do with being able to demonstrate compliance for 2026. I don't think those are the issues after the credit market has been reasonably well established, where suppliers, because right now suppliers have zero cushion against failure.
Do you mind if I just ask you some questions to help
Sure.
us guide through this? Okay. So when you were preparing your analysis, did you interview New Mexico utilities or charging providers?
No.
Are you aware that of the 3 investor-owned utilities that provide 70% of the power in New Mexico?
No.
If I represented to you that these 3 investor-owned utilities, Public Service Company of New Mexico, El Paso Electric, and Excel Southwestern Public Service, who make up that 70% of power, have filed letters of support in this docket regarding this program, would that surprise you that they are supportive?
No.
Were you aware that PNM, the largest utility, expressly stated it intends to opt in and generate credits in the New Mexico market?
No.
Are you aware of the provisions under the department's proposed rule regarding residential electricity credits?
Aware, just a reading of the proposed rule gave me a sense of what's intended.
Okay, let me briefly reread you a quote from the rule that might help establish your memory for the next few questions. So this is 20.2.92.201H, and it states the department shall calculate the number of credits associated with residential electricity dispensed for EV charging and shall deposit those credits into the account of the electric distribution utility or the backstop aggregator as applicable. So with what I just shared to you, is it fair to say that residential electricity credits will be deposited into the accounts of the EDU, whether or not they choose to opt in, because we have the fail-safe of a backstop aggregator?
Can you go on to indicate the timelines that are mandated? Because that's what I'm arguing, is that the timelines are critical.
So I'm asking you, is this an activity that the rule provides for?
Yes, literally.
Okay. You've also raised concerns about there being insufficient credits or a shortfall in the early years. No, I just asked the question, sorry. I skipped ahead in my outline unintentionally. So given that there's these opportunities for electricity credits to enter the market, regardless of whether the EDUs are opting in, is it really fair to characterize this outsized risk of a worst case scenario that there's not going to be enough credits?
As I testified, yes, I think it is. But not, I understood all of what you were saying about those credits and the availability. My concerns are the fallback credits, backstop credits, for example, requires clarity that the first parties that are entitled do not opt in, and therefore it goes to the backstop aggregators. I believe that the requirement is for the department to do this every 6 months. So in the case, for example, where the regulation starts on July 1st, the first time the department has to deposit those credits is the end of the compliance period.
So let me read you another provision from the rule. This is 20.2.92.7 D as in dog 18. And it states credit means a unit of measure in metric tons of CO2 generated when a transportation fuel with a carbon intensity that is less than the applicable CTFS is produced in New Mexico, imported into New Mexico, or dispensed into New Mexico. This ties in with 20.2.92.300B, which states each regulated party that generates credits shall report such credits to the department within 60 days after the end of the calendar quarter. The department shall record the credits in the Clean Transportation Fuel Program Data Management System. And so is this not addressing the concern that the department explicitly considers quarter and not calendar year?
No.
Okay, we'll move on. With renewable diesel, I heard something a little bit different during your oral testimony, and I wanted to make sure I understood. In your written testimony, you suggested that renewable diesel is the only fallback. But in your oral testimony, you recognized that there's other renewable fuels for generating credits. Is this
You want me to clear it up?
distinction that you can clear up?
Yeah.
Of why this opinion changed from your written to today?
Through all the years of having to communicate on this, I do fall into going straight to the heart of a matter. So in order to get enough credits, suppliers are going to look at all of their options. They're going to increase the potential supply of anything that makes sense to them. And by making sense, it usually means what's it going to cost. And they are already at 9% in the state, which means for ethanol in gasoline, which means that putting more ethanol in is an option, but it's not going to generate a lot of credits. It'll be important in the long run. Natural gas, propane, I don't remember if renewable propane is allowed to generate credits. All of those can contribute. But if you have to mobilize in a bit of an emergency mode in the last quarter of the year to get more fuel, everybody in Canada, in BC, Washington, Oregon, California goes to renewable diesel, because you can go to a renewable diesel producer and you can buy out a commitment if you pay enough, and you can get a emergency, I'll put in quotes, an emergency supply at a cost. And you can if you can get your hands on enough of it, you can generate a relatively large quantity of credits that presupposes that you have the infrastructure to get it into market, but you don't have to depend on the consumer to make a choice. If they're buying diesel, they will get it in the mix automatically. So it's a very useful tool, if you will, for quick changes in your compliance picture if there's enough available.
So you're not representing that it is the only change?
No.
Okay.
Change.
Yeah, don't step
Yes,
on each
of
other's.
You've claimed that infrastructure can't adapt quickly in your testimony, but you have not done a New Mexico specific study of infrastructure capacity, correct?
Correct.
Are you aware that the rule specifically provides for opt-in fuels and pathways which allow credits from existing infrastructure like residential electricity?
I'm sorry, can you, I don't see the connection with your first sentence. Can you just repeat the whole thing?
Are you aware that the rule specifically provides for opt-in fuels and pathways which allow credits from existing infrastructure?
Yes.
Okay. You warn that consumer prices may rise in response to a limited supply of fuel credits. Do you recall that from your testimony? Yes. Okay. In connection with that, you stated you fear that fuel suppliers may curtail the supply of deficit generating fuels if they are, quote, unable to see a path to compliance as they approach the end of the compliance period. Do you recall that? Is it your testimony that oil and gas companies will stop selling petroleum products in New Mexico out of fear of deficits?
I don't want to answer straight yes, because that implies that I am saying it's a done deal. I am saying it's a risk, and I'm basing that on our experience in British Columbia, where the oil industry, the petroleum industry came to us as the regulators said that could happen. If we can't find a path to compliance, we will exit the market. We chose to go ahead regardless. Two major suppliers have left the BC market, and they are the two that own the refineries. Now, the way they exit the market is they sell it to somebody else who knows what they're getting into and has done spectacularly in complying with the regulations, converting to the production of renewable fuels and so on. But there is that glitch that it's too expensive or it's too hard, we will cut our losses and leave. And that could happen.
Are you aware that this has not occurred in the United States?
I would like to not answer that because my understanding is there has been turmoil in the industry as a result of these regulations. And I don't know who has moved around and which sale was dictated because they felt it was due to low carbon rules versus market conditions in a more general sense.
So the oil and gas companies that supply and distribute fuel, those companies are the ones that decide how much of their costs to pass on when they sell their fuel, correct?
Yes.
And fuel prices in New Mexico are influenced by these very oil and gas companies' decisions on whether or not they pass on their refining and distribution profits.
Objection calls for speculation.
Dr. Rensing, if you can answer the question without speculating, go ahead.
I will say that if the renewable fuel prices that generate credits are sufficiently expensive, it will lead to
So this,
I'm not going to speak about the fuel prices. It will lead
that's
to the
my question though, Madam Hearing Officer.
Okay.
So
Okay.
I'm sorry to cut you off, sir.
Okay.
I'm not
That's all right.
trying to be rude.
You have about 5 minutes.
Yes, I just want to ask a couple more
Sure.
questions. Is the question that I asked you about fuel prices and the influence these industries have in their refining and distribution profit information, is some of the concern and hesitation about answering the question and ultimately having public knowledge about the true impacts, because those very decisions are considered proprietary by oil and gas operations?
Objection calls for speculation.
Okay, I don't know that it calls for speculation, but Dr. Rensing, if you have to speculate to answer the question, just say so.
Can you repeat the question?
Sure, I can shorten it even more, I think. Are much of oil and gas operational decisions regarding profits considered proprietary information?
Yes, I believe that is in the area that was addressed when council brought forth the competition statements they make. They're not allowed to share it because it speaks to their ability to compete with each other directly to the profit motive.
So if oil and gas companies have the authority to pass along costs, they have the authority as well to decide whether those costs are aggressive or preemptive. And they could create sudden fuel cost increases themselves by their business decisions, correct?
Objection calls for speculation.
Same caution, Dr.
I don't
Rensing.
want to speculate on that.
So I'd ask, do you know the answer to that?
That would be speculating too.
Okay, overruled. Go ahead, Dr. Rensing.
I have my understanding of that situation. I don't know what the answer is.
So in your testimony, you have provided opinions about fuel prices. Is that correct?
Yes.
Okay. As part of your understanding of how fuel prices are set, do you have knowledge about whether a business decision to pass on costs for fuel supplied or distributed could lead to a sudden fuel cost increase at the pump?
It could, and companies are subject to profit and loss and profit margins, and I think it's a complex question that you should ask of an economist.
Tried. He didn't answer either.
It's because they don't understand this either.
So, last few questions for you, Dr. Rensing.
Sure.
Your resume states that you led the development of the British Columbia Part 3 Agreements Program, correct?
Yes.
And your resume highlights that this program spurred over $2 billion of investment in clean fuels in the province by 2020, right?
Yes,
That's $2 billion in investment in the clean fuels sector, correct?
that's right.
And that investment supported infrastructure build out, fuel diversification, and market compliance in British Columbia?
Yes, it spurred the market compliance by supporting the other activities. It wasn't used to directly subsidize fuel in the marketplace. It was designed to solve fuel supplier problems.
Thank you for that clarification. And this is a pretty awesome achievement, and I take it you're proud of it.
I am.
On your resume. Okay. And so with that potential for investment with a clean fuels program, it begs the question of your testimony here today on behalf of oil and gas interests that's presenting a one-sided negative picture of New Mexico's program and highlighting the risks and shortfalls about growth and potential investment opportunity. Is this a contradiction that you can clarify?
Objection, argumentative.
All right. I didn't find it so argumentative, but go ahead, Dr. Rensing, if you would address that tension, please.
I feel that the issue is not can the industry comply with these regulations, and one of the exceptional things about New Mexico's regulation is the 4 or 5 years to get from 0 to 20 to minus 20, and I think it's achievable, and I don't think my clients disagree with that. What I am saying is that as you make a critical path through your project planning of the first year of compliance, there are some significant risks if something happens, and that there's not really the mechanisms needed to cope with that gracefully to get a successful conclusion to the first year.
And last question, Madam Hearing Officer. It is true that members of American Petroleum Institute and the New Mexico Oil and Gas Association are already participating in other low carbon fuel programs, correct?
I think so, yes.
That's all. Thank you very much.
And do you have questions for the other two?
I am going to pass it over to Ms.
Ms. Nixon, thank you.
Before I get started, Madam Hearing Officer, we've been back on the record for close to an hour and a half. I didn't know if you wanted to take the 15-minute break before we started.
Yes, sorry, I keep falling down on that particular job. So I think that is a good idea. Let's come back at 2:40. We are back after a short break. Ms. Nixon.
Yes, and Madam Hearing Officer, before I start the next sets of cross-examination, I did just want to correct for the record one thing I said earlier this morning. My nerves also got the best of me. I mentioned during voir dire that there was a disclaimer in what I called the joint statement, but that actually appears in the MOGA and API's notice of intent. And just for the record again, that disclaimer was in the event of objections to any portion of the testimonies of Ms. Felix and Mr. Searles, NMOGA and API reserve the right to designate Ms. Felix and Mr. Searles as technical witnesses. So that actually appears in the NOI, not the joint statement.
Thank you.
All right, and for the fun, I'm going to start with you, Mr. Searles. Good afternoon. Mr. Searles, do you understand that the enabling statute for the program requires CI reduction targets of 20% below the 2018 baseline by 2030?
Yes.
And the CI reduction target by 2040 in the statute is to reduce by 30% below that 2018 baseline, correct?
Yes.
Additionally, the statute requires that the program implement a standard that annually decreases the carbon intensity of transportation fuels used in the state, correct?
Yes.
So if implementation is delayed until 2027 for credit generation and 2028 for deficit generation, then the program cannot effectively decrease on an annual basis the carbon intensity of transportation fuels until those implementation dates, correct?
I'm not a lawyer, so I'm not going to try to parse those words.
It's not really a legal conclusion. I'm just asking for your understanding of how dates work.
So my understanding of how those requirements work is that you have to hit a target on the given date. So by 2020, or I'm sorry, that would be hard. 2030 and 2040, you've got to hit certain targets. And so in our proposal, we actually make that, it's just on a different slope than what InMed suggested.
So what I'm asking about is the second requirement that you just agreed with me about the annual reductions that are required in the statute. If the program is not implemented until 2027 for credit generation and 2028 for deficit generation, program cannot decrease annually in 26 or 27, correct?
Again, I think that is a legal question, and I'll defer to the lawyers on how to read that piece of the statute. I think I've heard it read differently.
But you agree that the statute does require annual decreases of carbon intensity?
Madam Chair, ask and answer.
Do you have anything to add, Mr. Searles?
I do not.
Mr. Searles, delayed implementation, you would agree, would reduce the ability of the program to achieve compliance with the reduction mandates.
I wouldn't say that, no.
Would the proposed delay in implementation of the program reduce or postpone the early climate benefits intended by the legislation?
You would have, I would defer to Mr. Rensing on that.
Do you
Sorry,
have an
Dr.
answer?
Rensing. I do not. I would defer to Dr. Rensing on how that works.
So based on your own knowledge and in your organization's knowledge, API's knowledge, you don't know whether delayed implementation would reduce or postpone climate benefits?
I don't know.
And during the time between the adoption of the Clean Transportation Fuel Program and the proposed implementation of the Clean Transportation Fuel Program, members of API and NMOGA would not face compliance obligations. Is that correct?
It's my understanding that you would be generating credits at the beginning, and then you would come into having to report, well, you would report deficits at the beginning also, but then you wouldn't have to be held in compliance until the second year.
The red line that has been adopted by yourself and API and presented in this hearing suggests that the implementation deadline should be July 1st, 2026, correct?
That's correct.
And the proposed red line suggests that credit generation should be delayed until 2027, correct?
Yeah, you would have that half year.
And deficit generation would be delayed until 2028, a year and a half, correct?
I believe that's correct.
So during that time from July 1st, 2026 until deficit generation begins in 2028, there's no compliance obligations for API and NMOGA members.
That's correct.
Let's transition just a little bit to API and NMOGA's criticism of some of the near-term targets that the department includes in its proposed rule. That is one of the concerns that's embodied in the joint statement, statement of reasons, and or the red line adopted by NMOGA and API, correct?
Could you repeat the question?
NMOGA and API are concerned about the near-term targets embodied in the rule, correct?
Correct.
And that criticism is essentially from API and NMOGA's perspective, that those near-term targets cannot be achieved, correct?
Our concern is that those near-term targets are going to be difficult and create uncertainty in the market and can just cause challenges that are unnecessary.
Thank you, Mr. Searles. I appreciate that clarification. Supply trying to get me. Do you know by what percentage the carbon intensity of fuels consumed in New Mexico has already declined between 2018 and today in 2025?
I do not.
Then you also do not know how much additional reduction would be required in the initial compliance year beyond what has already occurred in order to meet the 1.8% reduction target for the initial year, correct?
Correct.
If you do not know how much additional reduction would be required in the initial reduction year to meet that 1.8% reduction below the 2018 baseline, then you cannot accurately say that such reduction requirements are unrealistic or create unworkable compliance guidelines.
What we did because I think what you're trying to, where you're headed is a yes or no, and I think it's more complex than that. Our members went through in the meetings and looked at the compliance schedule and tried to assess whether or not there would be enough credits for the, and to offset the balance the deficits, and ultimately didn't feel that that was achievable.
Madam Hearing Officer, if I may, it's very distracting to have counsel and witnesses passing notes while I'm asking questions of this panel, so I would ask that that stop.
Okay, yeah. Let's not communicate that way. Go ahead, Ms. Nixon.
Thank you, Madam Hearing Officer. Mr. Searles, are you aware that Washington amended its clean fuel standard in April of this year?
I'm not.
If I represented to you that Washington amended its clean fuel standard in April of this year, would you have any reason to disagree with me?
No.
So assuming that that representation is accurate, are you aware that the prior version of Washington's low carbon fuel standard, the 15-year CI reduction target was 20% below the 2017 baseline?
No.
In the amended version of Washington's low carbon fuel standard, the 15-year CI reduction target is now 45 to 55% below the 2017 baseline. Is that correct?
I've indicated I do not know what Washington's specifications are.
So if those representations are correct, I'm not a lawyer, so my math isn't great. I am a lawyer, so my math isn't great. That indicates that Washington recently doubled its 15-year CI reduction targets, correct?
The math would say that, yes.
In the joint statement on page 7, it's suggested that the EV uptake in New Mexico contributes to those reduction targets being unachievable, correct?
Let me find it. And where are you? Page 7.
It's page 7. I believe it's
Exhibit 5.
Of the joint statement, which is Exhibit 3.
Oh, I misread on my side. Sorry. Okay.
And I'm not asking for an exact quote, but that second paragraph that starts with the word second talks about the EV uptake in New Mexico and the effect of EV uptake in New Mexico making the reduction targets unachievable, correct?
That's what it says, yeah.
Would you agree with me that EVs in New Mexico represent 1.2% of on-road light-duty vehicles?
That sounds about right.
Are you aware that in 2015, when California restated its programmatic targets, EVs made up only 0.36% of its on-road fleet?
In what year?
2015.
That would not surprise me.
Do you have any reason to disagree with my representation of that fact?
I don't. I would put it in the context of California has provided significant incentives to be able to improve their percentage of electric vehicles. Everything from
Mr. Searles, I'm just asking about 2015. That's fine.
okay. It's kind of an incomplete thought, just asking about 2015 and how they, but please, it's your time.
This next question will tie it all together for you.
All right.
So California in 2015, when it restated its own programmatic targets, had less than 1/3 of New Mexico's current EV share, correct?
I'll let you do the math if you say so.
Man, making lawyers do math all day. Do you know the current percentage of EV light duty vehicles on the road in Oregon?
I don't know off the top of my head.
If I told you it was 1.83%, would that sound correct?
Today, that of the fleet of vehicles,
Light
that's the 1.8% of the fleet. It's light duty fleet.
Yes.
That sounds probably about right.
So the number of light duty vehicles, electric vehicles on the road in Oregon is not substantially different from the number of EVs estimated on the road in New Mexico, correct?
Okay.
1.8 compared to 1.2.
Okay. Lost track of all the numbers you're throwing at me. You've got 0.05 and 0.5 and yep.
I got a cheat sheet. That's the only way I can do it. You are aware that Oregon's Clean Transportation Fuel Program has been in effect for nearly a decade, 8 years.
I believe that's what Mr. Rensing testified to before.
And to your knowledge, Oregon has never had to issue a deferral under its program, has it?
I don't know.
Do any of your members of API operate in Oregon?
Yes.
And you just don't know whether the program has ever been deferred in Oregon?
API does not work in the West Coast states of Washington, Oregon, and California. So for those reasons, I'm not tracking that as closely.
Thanks for that clarification. Would you agree with me, Mr. Searles, that transportation technologies have changed since those 3 states first adopted their low carbon fuel programs?
For California, certainly, and Oregon at 8 years, yes.
You do not have any data-based evidence which you rely on to support the concern about New Mexico's near-term reduction targets, do you?
Database, no, but experience, yes. And that experience goes to what the percentage of vehicles are across, the vehicle fleets for all the states that adopted, that are Section 177 states, which are the states that adopted California's rule for the Advanced Clean Cars 2. And the states that have adopted, there are several states this year that were supposed to hit their 2026, which is model year 2026. And model year 2026 starts in February of 2025. And I think this is important to the point that you asked me, which is what is the need and what is my evidence for our concerns for electric vehicles. And so I'm putting that in context.
Hold on. We need to speak one at a time.
Respectfully, Mr. Searles, my question was simply a yes or no question. Your counsel will have the opportunity on redirect to help flesh out any of those answers.
Madam Chair.
So you don't feel like you have the opportunity to do with me.
Okay. Mr. Trujillo.
Madam Chair, the witness did answer that he couldn't, it wasn't a yes or no that he needed to explain. And I feel that's perfectly acceptable for him to be able to explain his answer if it's incomplete.
All right. So I'll add a minute, Ms. Nixon, if you want to finish your answer, Mr. Searles.
Thank you. So in the state of Maryland, where I live, our governor actually, and it's not even due until next year, but they delayed it because they didn't see a way to come into compliance with the 42% of the vehicles having to be electric vehicles on that timeline. And you get similar results up in Massachusetts and New York, I believe. And they needed to come in compliance this year. And that number would have been 35%. And they were at, and these aren't exact numbers, but they're in the ballpark of about 8%, 6% of sales. So sales are what's the driving factor. The fleet is going to take a long time to be able to come up to that speed.
I'm going to transition again just a little bit.
Okay.
Mr. Searles, there's a lot in y'all's testimony and redline. Moving on to the proposal to modify the baseline of carbon intensity values proposed by NMOGA. The proposal from NMOGA and API is that the CI values for 2018 should be calculated using petroleum only or clear gasoline and diesel, correct?
That is right.
And if adopted, the baseline values would be calculated with no renewable content, essentially E0 and B0 fuels, correct?
Yes.
Mr. Searles, Washington and California and Oregon all used finished or blended gasoline and diesel in their CI baselines for their analogous rules, correct?
That is not my understanding.
Okay. Where does that understanding come from?
From the members,
Which members?
the ones that are participating in the work to be able to create the red line,
What is the basis of their knowledge?
the experience in working in those states.
But API does not operate in those states.
We do not, our members do.
And so your members can't help me today understand why they believe that California, Washington, and Oregon did not use finished or blended gasoline and diesel in their CI baselines.
I can defer to Ms. Losey. I think she can probably answer that question for you better than I can.
I'm asking you as the organizational witness, Mr. Searles.
And as the organizational witness, we hired Ms. Losey, who has the details on the R&D GREET, as well as the numbers that are in the tables that you're referring to.
But you just told me that it was your members that gave you that information.
Okay.
And those members aren't here to explain that to me, are they?
So the members have experience in working and implementing LCFS, and I trust that they are are knowledgeable in that space.
So let's just say, for purposes of this hypothetical, that California, Washington, and Oregon did all use finished or blended gasoline and diesel in their CI baselines.
Okay.
Presuming that is true, your proposal to not include blended gasoline and diesel in the baseline would make New Mexico's clean transportation fuel program different from any other state.
Mm-hmm. That's correct.
And in reality, almost all gasoline sold in New Mexico today contains 10% ethanol, correct?
Most all gasoline in the country is 10% ethanol.
Are you aware that according to the Department of Energy Information Administration, more than 2.2 million barrels of ethanol were consumed in New Mexico in 2018?
And 2.2 million barrels annually?
In the year 2018.
Okay.
Any reason to disagree with that?
And I don't.
So by ignoring ethanol and biodiesel in the baseline, API and NMOGA's approach makes it more difficult for renewable fuels to show CI reduction progress. Is that correct?
I would refer to Mr. Remsing on how that works.
Based on your organization's knowledge, do you know the answer to that?
I do not.
And in effect, that proposed baseline creates a compliance advantage for fossil fuels such as petroleum by inflating the starting baseline, doesn't it?
Asked an answer. I believe he said he didn't know.
Oh, I'm sorry. Did you say you didn't know?
I didn't answer.
Oh, okay. You can answer now.
I don't know.
Thank you.
Didn't know the answer to the previous one, and it's related. That's all right.
That was some good telepathy. I want to move on next to another topic regarding project credits. The department, are you aware that the department has addressed the request by API and NMOGA that project credits become immediately available upon implementation in 2026?
I believe that happened in the red line.
In the revised red line that was presented to this board between September 2nd, with our September 2nd
Yes.
filings. And that's consistent with API and NMOGA's proposal, correct?
Yes.
And immediate eligibility for CCS or carbon capture sequestration and DAC would create potential compliance advantage for petroleum companies. Is that correct?
It would allow those companies to be able to take credit for those technologies. Yes.
And your competitors, such as electricity, are not able to earn those same types of project credits.
I don't know which credits the electric utilities are able to take advantage of.
Would the electric companies and utilities be able to take advantage of project credits from CCS?
Possibly. Depends on what their feedstock was and what their, so if it was coal or it was natural gas, then they could theoretically capture the carbon dioxide out of that combustion and then send it off and capture it, sequester it.
Would you agree with me, Mr. Searle, that CCS and DAC, those types of project credits, are generally associated with fossil fuel companies such as those in your organization?
Yes. But I would also expand on that and say it's also available for biofuels. So for ethanol compliance, when they manufacture the product, they also generate carbon dioxide, and they can take that and sequester it. So it goes over to biofuels also.
How many of API and NMOGA's members have submitted applications for project credits in other states?
I don't have that information.
Do any of your members intend to apply for project credits beginning July 2026?
We do not discuss what they plan to do in the future about anything.
Do you know the answer to that question?
Objection, calls for privileged information. You read the antitrust statement and originally on what how they direct their members.
Madam Hearing Officer, I would disagree that this calls for privileged information. I'm not asking for the nature of the applications that his members are intending to present or the identity of the members that may be submitting such applications. I'm simply asking generally if members of API and NMOGA intend to submit project applications in July 2026.
Intends to submit project application
in July 2026.
Oh, in July 2026.
I will stick by my previous answer, which is I don't have any information about what companies intend to do in the future, particularly in regards to rules. All of that comes out in the antitrust statement that says we're not going to talk about that.
In the redline proposal from API and NMOGA, it is proposed that project types eligible for project credits be expressly identified. Is that correct?
Where would you point me to where you're referring to, please?
It's going to be in exhibit number 1. Section 303.
I'm with you.
Which, okay. So in the proposed redline version submitted by NMOGA and API, starting on page 51, line 32, NMOGA and API propose that the project types eligible for project credits be expressly identified in the regulation, correct?
No. It says project types eligible for credits include but are not limited to.
And that include but not limited to includes an express list of projects that must be eligible for project credits, correct?
Yes.
The text of the rule presented by the department, which does not preclude the project types identified in the proposed red line from API and NMOGA, does it?
I'm just going to the rule that you've got. I don't see where it specifically excludes projects.
Okay. So the proposed red line, which delineates and expressly requires approval of certain projects, those types of projects would certainly be permitted under the NMED proposal, correct?
I believe that it's not an approval, it's an application.
Okay. But those projects could be the subject of applications submitted under NMED's proposed rule, correct?
I would have to go back and read the rule in the InMed rule in detail to determine
Based
that.
on your recollection and the several meetings that you described to have had with your working group, do you recall anything in New Mexico Environment Department's rule which would exclude certain types of projects from submitting project credit applications?
I do not.
And just quickly on the issue of project credits, you've requested that the program make project credits immediately available, which according to your proposal, I think we established was July 1st, 2026, correct?
Again, it was to be able to provide the application for those programs or technologies.
However, API and NMOGA have also proposed that credit generation would not start until January 1st, 2027, correct?
That's right.
Mr. Searles, as described on page 5 and 7 of the joint statement, I'm transitioning topics again just a little bit. As well as described in the red line proposal, API and NMOGA are requesting that the EER be eliminated from the rule, correct?
That's correct.
And EER accounts for differences in vehicle efficiency. For example, EVs being more efficient than gasoline cars, correct?
I believe EER looks at the efficiency of the vehicle, yes.
So by eliminating EER, credits for electricity and hydrogen would be reduced. Is that correct?
That is correct.
In your joint statement on page 4, you raise concerns about program insolvency due to what you described as, quote, unrealistic baselines, correct?
Correct.
Well,
I'm not sure we describe it as unrealistic baselines. Yeah, unrealistic baselines, yes.
That's a quote, right?
No, I was thinking on the, sorry.
Okay, just want to make sure the record is clear. It is quoted as unrealistic baselines.
That's correct.
Thank you, Mr. Searles. In the energy economy ratio, if the energy economy ratios were removed from the rule, that would significantly reduce the number of available credits. Is that correct?
Yes, EERs are multipliers that are not technology neutral. And so they by default would be multiplying electric vehicles times, I believe in your rule, it is 3.4.
And that reduction in credits, if the EERs were removed, would amplify the risk of program insolvency, correct?
It eliminates the opportunity for other products to be able to participate because it overstates the value of an of an electric vehicle.
One at a time. Ms. Nixon.
I'm really running out of time and want to get through the rest of these questions, so I would really appreciate yes or no answers when I ask yes or no questions.
I feel like it's
there will be plenty of time on redirect for your counsel to elicit further information.
Hold on. So, Mr. Searles, Ms. Nixon is correct. If you will answer her questions, your counsel really will have time to allow you to provide a fuller answer. And Ms. Nixon, you've got about 4 minutes.
Oh, my time was different. Thank you, Madam
But-
Hearing Officer.
Madam Chair, just if I may, if it's a yes or no, calls for a yes or no or correct or incorrect, and the witness feels that doesn't provide for a complete answer, he can say that at least and not expand. Is that fine?
Well, if it's not a yes, if he doesn't believe he can answer a yes or no, he should just say that.
Okay, thank you.
Mr. Searles, without the credits generated from EERs, the program would have to rely more heavily on renewable diesel to meet the compliance requirements. Is that correct?
That would require more than just a yes or no answer.
Okay, tell me the complete answer to that question.
Sure. So you need to be able to take into account all of the technologies that are there, and biasing towards a single technology such as electrical vehicles in this instance biases the program to that one technology and skews the investments that might take place in additional renewable diesel, renewable naphtha, ethanol, et cetera.
Okay, Mr. Searles, my question was just a little bit different than that. If
Okay.
EERs are eliminated, then the reliance for program compliance with credit generation would lean more heavily on renewable diesel. Is that correct? Yes
Based
or
on
no?
what on my previous response, I would then say you would rely more on other fuels, and that would be
Including renewable
including
diesel.
renewable diesel.
And increased reliance on other fuels, such as renewable diesel, would drive up the overall costs of the program. Is that correct?
I don't know what the economics on that is.
Okay. And that increased reliance on other fuels, such as renewable diesel, that would shift compliance costs away from fossil fuels onto renewable fuels. Is that correct?
Can you repeat the question?
Sure. So if the compliance obligations are shifted to other fuels, such as renewable diesel, that would shift the compliance costs away from fossil fuels and onto renewables. Is that correct?
Yeah, I'm not sure I'm understanding what your question is. I apologize.
Okay. If EERs are eliminated from the rule, the steepness of the CI reduction target curve would get steeper in order to meet the statutory reduction targets. Is that correct?
I don't think the curve changes. It's just a matter of how do you buy the credits that will allow you to comply with the curve.
If there is no credit generation until 2027 and no deficit generation or deficit obligations until 2028, that's nearly a year and a half, 2 years of the program not being implemented from 2026, correct?
I believe that you're still buying credits and able to generate credits and procure those at that time.
But there's no reduction target goals that are in place for those years, correct?
In our proposal, it doesn't occur until 2028, where that kicks in.
So if there are no reduction targets for 2026 or 2027, then the steepness of the curve, once those targets kick in, must inherently get steeper.
Absolutely. And I think that's reflected in our table that shows the steepness of the curve.
Isn't it true that every other low carbon fuel program in the United States includes an EER?
Yes.
So if New Mexico were to follow API's proposal and eliminate the EERs, it would actually be the outlier compared to every other state with a low carbon fuel program. Is that correct?
It requires more than just a yes or no answer.
If every other state has an EER and New Mexico does not, that would make New Mexico the outlier.
Asked and answered.
Doesn't believe he can answer that with a yes or no. Do you want to ask one final question, or do you want him to provide his answer to this one?
I would like for him to answer this question. It's a yes or no question.
Mr. Searles, what is your challenge in answering that question as to whether New Mexico would be an outlier?
New Mexico's got a statute that specifically says that it should be technology neutral, and the other states, while they implement and suggest that they are technology neutral are not actually accomplishing that because of the adoption of EER.
Madam Hearing Officer, I would strike that answer as being non-responsive to the question. The question is simply, if EERs are not included in the proposed rule, New Mexico would be different from the other states.
All right, and again, I understand he's providing an answer that effectively denies the outlier status based on the language in the statute. Do you have one more question?
Can I ask 2 more questions?
Okay.
You gave us a break.
No objection.
Mr. Searles, I'm fairly confident I know the answer to this one, but it lays the foundation for my next one. You're not an attorney, are you?
I am not.
Yet you have offered testimony today regarding the legality of the proposed rule presented by the department based on legal and statutory interpretation of House Bill 41, correct?
Madam Chair, I object. Calls for mischaracterizes his testimony.
All right. So, Ms. Nixon, I heard him obviously comment on the contents of the statute. Mr. Searles, would you describe in what role, if you will, you are describing what you understand as the statute?
Thank you. I'm just doing a plain language read on the statute
And
that says that you have to have a technology neutral approach.
Madam Hearing Officer, I would just point out that the joint statement, I want to say 3 pages of the joint statement, is dedicated to a legal interpretation. So I was just clarifying that Mr. Searles is not a legal expert with the expertise and background to offer that testimony.
Okay, so I'm not going to strike it, but I would caution the board that they should understand it as the statement of the executive directors of their respective organizations who did describe how they were charged with sharing information about statutes and the rules with their members. And I don't think they've held themselves out as having legal expertise. Are you ready to move to Ms. Felix?
Yes, thank you very much, Mr. Searles.
Thank you.
Good afternoon, Ms. Felix.
Good afternoon.
I know you've been waiting all day for this moment.
I am just giddy over here.
Let me just make sure I start my timer this time. Okay. Ms. Felix, I want to start with you regarding the red line draft of the rule that was proposed by NMOGA and API, okay?
Yes, ma'am.
And one of the proposals by NMOGA and API is that the annual fees should be allocated on a pro rata basis amongst all registered parties. Is that correct?
That's correct.
And the reasoning described for such change includes that, quote, fees should be allocated in proportion to the department's workload to administer the CTFP program, end quote, correct?
I'm going to go to that section just to be sure.
Sure, take your time. And if it helps, I believe it's on page 163 or page 63.
Oh, thank you. Okay, could you repeat for me? Thank you.
Sure. The reasoning for the proposed change that registration fees be allocated on a pro rata basis is that, quote, fees should be allocated in proportion to the department's workload to administer the CTFP program, end quote, correct? It starts on page 63, line 35.
Will you repeat the quotes again, please?
Fees should be allowed in proportion to the department's workload to administer the CTFP program.
That's correct.
And administration of the program includes verification of quarterly reports submitted by deficit generating parties. Is that correct?
That's correct.
And the process of processing and verifying quarterly reports by deficit generating parties requires more work than is required for verification and reporting by credit generating parties, correct?
Yes, ma'am.
And the red line proposal by NMOGA and API also calls for equal registration fees for all parties. Is that correct?
That's correct.
If annual fees and registration fees are equal for all regulated parties, including opt-in participants, then smaller opt-in credit generators could be deterred from participating in the program, correct?
I don't have an answer for that.
Another aspect of NMOGA and API's proposal related to fees is to eliminate the requirement that there be late fees or late submissions, correct?
That's correct.
And if there is no consequence for late submissions by regulated parties, then there is no method by which the department can ensure that regulated parties are timely submitting the required reports and submissions, correct?
As written, yes, that's correct.
I want to transition just a little bit to NMOGA and API's proposal related to fuel supply equipment, or FSEs. And fuel supply equipment just means the dispensers where fuels are delivered, correct?
That's correct.
And FSE credits are a separate concept, a capacity-based crediting tied to those dispensers, correct?
Yes, ma'am.
And your red line didn't just strike FSE credits, it struck the very definitions of FSE, FSE stations, and FSE units, didn't it?
I believe that's correct. Yes, ma'am.
Isn't it true that in your red line, NMOGA and API deleted both the crediting provisions and the provisions needed even when FSEs are the point of regulation?
Can you point me to where you're looking at?
Just 1 second, sorry.
Sorry, I didn't mean to do that while you were taking a drink.
Just try not to make a mess. And Ms. Felix, I don't know that this is necessarily going to be verbatim in the red line, but we just agreed that the red line strikes everything related to FSEs. So if that's true, then the red line deletes both crediting provisions and the provisions even needed when FSEs are the point of regulation, correct?
I don't know that.
Do you acknowledge that eliminating references to FSEs also eliminates the ability to regulate fuels dispensed at FSEs, such as electricity from public EV charging or multi-family housing chargers?
Yes.
And in fact, without FSE registration, the department could not track compliance for fuels dispensed at the pump or charger, correct?
I don't know that.
How would the department track compliance for fuels dispensed at the pump or charger if there was no FSE registration?
I don't know.
Okay. And you did not offer, you being NMOGA and API, did not offer an alternative for tracking or regulating those dispensers anywhere else in the rule, did you?
I don't believe so. I'll defer to Prentice, to my colleague, to confirm.
That's correct. Confirming Andrea is asking, yes.
Thank you.
I'm not sure that's clear.
So what NMOGA and API have really done is more than just oppose FSE credits. You've proposed to eliminate FSEs from the program entirely, correct?
That's correct.
Ms. Felix, I want to transition just a little bit, and I want to talk very briefly about NMOGA and API's proposal to adopt, quote, unmodified R&D GREET. The department and NMOGA agreed that GREET is the best model used to calculate life lifetime carbon intensity values, correct?
That's correct.
And according to page 5 of your joint statement, API and NMOGA's proposal is that the CTFP should employ the R&D GREET model, unmodified, to calculate lifetime CI values, correct?
That's correct.
In addition to our agreement about use of the GREET model, the department and NMOGA agree that OPG is the recognized tool to modify crude oil emissions within GREET, correct?
I would defer that to Hannah.
According to Ms. Losi, in her written testimony on page 7, almost all the gasoline sold in New Mexico and 75% of crude oil used in New Mexico refineries came from PADD 3. Is that correct?
I need to, can I see her testimony?
It looks like she has that handy for you.
I'm sorry.
I don't remember the exhibit number, so. Page 7.
Madam Hearing Officer, while they're looking at that, she had deferred to, and this line of questioning was for Ms. Losi. That's fine. Can she go ahead and defer, let Ms. Losi answer?
So it depends on what Ms. Nixon is trying to do. If you're trying to get a follow-up question answered by Ms. Felix, you could just ask her to assume that in fact that was in Ms. Losi's testimony. If in fact it would be Ms. Losi who would be best to answer the question, she can do that.
Madam Hearing Officer, I'm simply asking a short series of questions about NMOGA and API's position, and as the organizational witness, I'd like to hear that answer from Ms. Felix. So, Ms. Felix.
Yes, I'm looking at her testimony and that's correct. Thank you.
Okay. So despite that data included in Ms. Losi's testimony, API and NMOGA opposed the use of PADD 3 OPG, correct?
That's correct.
But NMOGA and API agree that OPG should be used.
Can you repeat that?
NMOGA and API do agree that OPG should be used.
No.
Okay. I want to next move into some discussion about NMOGA's proposal regarding deferral mechanisms. You are aware that the CTFP, as proposed by the department, directs that the fuel supply forecast by October 1st of each program year shall be published and shall evaluate the availability of credit generating transportation fuel and banked credits to satisfy the forecasted deficits during the next complete compliance period, correct?
That's correct.
And following that fuel supply forecast, the department is next required, if the fuel supply forecast concludes that a shortage of credit availability will exist, then it must issue a forecast deferral declaration by December 1st of that respective program year, correct?
I believe that's correct.
And NMOGA and API advocate in the red line that this schedule should be moved up earlier in the year. Is that correct?
That's correct.
However, Oregon and Washington use the same October-December construct for their fuel programs deferral forecasting, correct?
I don't know that.
If I represented to you that Oregon and Washington use the same October-December construct for their fuel program deferrals forecasting, would you have any reason to disagree with me?
I would not.
So, assuming that that fact is true, the department's proposed approach for New Mexico is consistent with how those states handle forecasting deferrals, correct?
Assuming that's true, yes.
And in fact, the timing of the department's proposed rule will allow the department to analyze credit markets during the fourth quarter of a given year and announce whether a forecast deferral will be declared before the next compliance period begins, correct?
Correct.
Ms. Felix, you do not have any personal involvement in New Mexico's state budgeting process, do you?
No, ma'am.
You are not familiar with the revenue estimating group that prepares the fiscal report for the Legislative Finance Committee and the Legislative Council in January of each year, correct?
Madam Hearing Officer, go ahead.
Sorry.
This is outside the scope of her
I don't take
testimony.
part of that.
All right. I think Ms. Felix just answered it. Are you going to tie this to her testimony?
Yes, ma'am. Do you know that that revenue estimating group includes the New Mexico Department of Transportation economists who track fuel revenues for road construction and maintenance?
I do not.
So when NMOGA recommends a forecast schedule to occur in August and September, NMOGA and API are not taking into account that the October-December construct is designed to correspond with New Mexico's existing budget process, is it?
That's not part of my understanding, no.
And that was not something that was considered by NMOGA and API, correct?
No, ma'am.
Another aspect of NMOGA and API's proposal related to deferrals includes the automatic deferral mechanism, correct?
Correct.
More specifically, NMOGA and API propose that if deficits exceed credits by more than 50% at the end of any calendar year, then the department shall declare an emergency deferral, correct?
That's correct.
However, under the proposed rule, credits and deficits are only reported quarterly, with the final annual compliance reports not being due until April 30th of the following year, correct?
I believe that's correct.
So by December 31st of any given calendar year, the department will have not yet received verified year-end totals to evaluate whether the condition proposed by NMOGA for an automatic deferral actually exists, correct?
I believe that would be correct.
And in other words, NMOGA and API's automatic deferral proposal cannot be implemented with the reporting schedule provided in the proposed rules presented by either the department or by NMOGA and API, correct?
Unless otherwise changed, that's correct.
Ms. Felix, no other program in the United States includes an automatic deferral as part of their low carbon fuel standard programs, correct?
That's my understanding.
A proposal from NMOGA and API that includes an automatic deferral is different than any other program that is currently functioning effectively in other states, correct?
Can you repeat that?
The proposal from NMOGA and API to include the automatic deferral is different than any other program currently functioning effectively in any other state.
To my knowledge, yes.
Ms. Felix, I next want to transition to NMOGA's criticism about the advisory committee. In the joint statement on page 9, you state that the CTFP advisory committee only conducted 3 meetings, correct?
That's correct.
You are aware that the advisory committee actually met 4 times on June 21st, June 28th, July 12th, and July 26th of 2024, correct?
That's well, was they did meet 4 times, but I thought the official advisory committee meetings consisted of just 3.
Ms. Felix, even though NMOGA nor API were selected as a member of the advisory committee, you are aware that the advisory committee meetings were open to the public to attend. Is that correct?
Absolutely, and Prentice and I attended all of them.
You personally attended them?
Yes, ma'am.
Would it surprise you to know that your name doesn't appear on any of the attendance lists?
Yes, it would, because I was at all 3 of them.
A number of NMOGA and API's individual members were selected to have seats on the advisory committee, correct?
That's correct.
And as it relates to the proposed rules presented to this board, NMOGA and API were unable to reach a consensus about the 7 key issues that have been presented. Is that correct?
Can you repeat that?
I'm actually going to back up and break it into 2 questions.
Okay.
Are you aware that on August 6th, 2025, Missy Courier, I hope I'm saying her last name correctly, who's the president of NMOGA, presented by email a list of 7 key issues that were concerning to NMOGA and API?
Yes.
And those same 7 issues are ultimately described in your joint statement, correct?
Yes, ma'am.
And NMOGA and API were not able to reach and their members were not able to reach a consensus about those 7 issues until August 6th, 2025, correct?
That's not correct. NMOGA and API, as soon as the work group received the petition rules, we immediately went to work. We're talking over hundreds of hours weekly with many members. And in order to gain that consensus, it took us till then and even September 2nd to come up with the red line.
I was not accusing your organizations of not working during that.
No, that's fine. I just wanted the record to be clear.
So the consensus wasn't reached till August 6th, 2025, or beginnings of a consensus. That's approximately 8 months after the discussion draft was released by the department in December 2024, correct?
That's correct, but the discussion draft and the petition draft are very different.
If it took 8 months for members of NMOGA and API, or I'm trying to do math in my head again, 3 to 4 months from the petition draft to reach consensus about the issues, how can NMOGA and API have been effective as a representative member to represent their members' consensus much earlier in the process had they been selected on the advisory committee?
So the 7 items that were submitted to Secretary Kinney in August were from the petitioned rule in May. It was not from the discussion draft rule that was provided in November, to be very clear.
Okay, but even if it took 3 months from the petition draft rule to reach that consensus, and that consensus could not be reached until August, how could NMOGA and API have been effective much earlier in the process to represent a consensus amongst their members?
I still am challenging you on the 3 months. The consensus on those 7 items was reached well before the 3 months. Secretary Kinney and his team had asked us for a red line. We were not able to get a red line due to the amount of work group members and the amount of pages of the proposed rule from when it was petitioned in May. So the 7 items was to get something to Secretary Kinney of what the main concerns of the work group were. Those concerns, 4 of those concerns remain the same from the initial meeting when we met with the department in November on the draft discussion rule.
And the other remaining had just been, I believe the language of that email said, recently identified and agreed upon, correct?
Yes, ma'am, based off the petitioned rule.
Even without direct representation as a member on the advisory committee, NMOGA and API had the opportunity to meet with and discuss its concerns with the department on several occasions, correct?
That's correct.
It's my understanding that NMOGA and API even met with the department the Friday before this hearing began on September 19th, correct?
That's correct.
And in fact, as a result of those meetings, the department had presented a revised rule to this board, which does immediately provide for greenhouse gas reduction project credits as requested by NMOGA and API, correct?
That's correct.
And one of the criticisms about the advisory committee described in the joint statement is that the advisory committee did not review and approve any version of the proposed rule now before this board, correct?
That's correct.
And the enabling statute for the CTFP does not require the advisory committee to have approved any such rules, correct?
It's our understanding that the advisory committee was expected to have a complete role in the process per the statute.
What section of the statute requires that the advisory committee review the department's draft rules before it presents it to the board?
I don't know that.
Do you believe that that express language is included in the statute?
I don't know if it's to that tone of language.
So you are interpreting the requirement that the advisory committee meet and convene prior to the rulemaking to require that the advisory committee have reviewed draft rules.
I think what we simply said was that the advisory committee, let me go back and look. I don't want to lie. That the advisory committee never reviewed the actual rules now pending before the EIB.
And you're not sure whether the statute requires the advisory committee to have done that, correct?
But Madam Hearing Officer, I would object. Calls for a legal conclusion.
I'm asking her knowledge of the statute.
Right. If you have an understanding other than as a lawyer, you can answer.
I would just refer back to our written statement that simply says, which is a procedural prerequisite for adoption of the NMED proposed CTFP rules.
What is the basis for that statement?
Our understanding of the regulation.
Your understanding of the statute?
Yes, ma'am.
And that's not a legal conclusion, correct?
No, that's my understanding.
And the consideration of a proposed rule for adoption is expressly reserved for this board, correct?
Yes, ma'am, as written in my statement.
And if the advisory committee were to come to a consensus regarding a proposed rule for adoption by this board, that entire process would essentially require a quasi rulemaking proceeding to occur before the advisory committee, correct?
Objection calls for legal conclusion.
I don't believe it.
I'm not sure that it does, actually. Do you understand the question?
Can you repeat it?
Sure. If the advisory committee were to come to a consensus regarding a proposed rule, regarding a proposed rule for adoption by this board, that process would essentially require a quasi rulemaking proceeding to occur before the advisory committee, correct?
I don't believe so, no.
How else would the advisory committee come to a consensus about the rule?
Through the same process that they went through the first time. They came to consensus, or we are to assume, on the advisory committee report.
Okay. Madam Hearing Officer, may I have just 1 second to confer with my co-counsel?
Yes, and you have 8 minutes left.
Thank you, Madam Hearing Officer. I'm just about done, Ms. Felix.
Okay.
Was the point of the advisory committee to reach a consensus on all points?
I don't know the answer to that. I believe the point of, in my opinion, of the advisory committee was to provide a roadmap and a report to be used by the department to help streamline the rulemaking process.
And I just want to go back to the discussion we had a few moments ago about OPG. The prior recommendation through testimony and written materials, including a letter from NMOGA and API, was that, quote, we recommend utilizing default values from OPG and GREET models to develop the baseline. And this comes from NMED exhibit number 37, part B on page 493. Is that recommendation now different?
So that recommendation was based off the draft discussion rule, and the recommendations that set forth in testimony today is based off of the petitioned rule.
And even though we agree that OPG is the most accurate tool, your recommendation, NMOGA and API's recommendation, is that it not be included in modeling for this rule, correct?
That's not what's included in our testimony.
So let's just back up then. Does NMOGA and API recommend the use of OPG?
Madam Chair, we're continuing on the same lineup of questions. These questions have been asked and answered in several different ways. Just going back through the OPG line of question yet once again.
Madam Hearing Officer, her testimony has changed. I'm trying to get clarity.
Yeah, I didn't hear the end of the question she was about to pose. Go ahead.
Is it NMOGA and API's recommendation that OPG should be included in the R&D GREET model unmodified?
No.
So okay. Thank you, Ms. Felix. I have no further questions.
Thank you very much, Ms. Nixon. We turn now to board questions. Let's see, shall we start? Do you want to start, Member Ely or Member Garcia? Member Ely.
Well, the beauty of CROSS is it answered a lot of my questions, so I appreciate that. Getting on to the project credit section of the rule, in the underlying strikeout, NMOGA proposes a start date of January 1, 2019 for certain projects. So what's the magic about that date, or why January 1st, 2019, going back that far?
The baseline being 2018, you wouldn't want to take credit for things that happened before the baseline, so you would take credit for things that had happened after that.
Okay, even though we don't have a program in place, but yeah, okay. And then I think this is directed to you, Dr. Renzig. There's a proposal to, delay implementation to give industry an opportunity to get caught up, provide some certainty in the data and what the market might bring. Are there other mechanisms for phasing in compliance maybe in the first couple years of the program, which seems to be of your greatest concern, such as allowing deficits to be carried over from one compliance year to the other without a penalty? Is that an option that other jurisdictions have looked at, or are there other ways to do this without necessarily delaying the program, but providing more flexibility?
Yes, my understanding is that both Oregon and Washington chose a lengthy first compliance period so that there were many quarters before compliance had to be demonstrated, 2 years roughly. But in that 2-year reduction, they got the equivalent amount of reductions as they would have with 2 separate compliance years, each with different. So you've got a target of 1.8 in the first year. I forget what the second year is. A 2-year compliance period that averages that reduction would get the same tons, but it would give everybody a chance to get their house in order before they had to prove they were in compliance.
Any other examples? Not just of strategies, not just state.
Well, yeah, not terribly specifically, because BC and California, starting from zero, said, we need data. We'll have a first year reporting only. The federal government in Canada had all kinds of issues getting things rolling, so they did roughly the same thing, but they were in a situation like New Mexico. They weren't starting from zero. They already had a renewable volume mandate that was counted into the baseline. But I'd have to go into a lot of math to give you the details. Let's see if I can summarize it. They set their carbon intensity numbers based on diesel and gasoline with no renewable content, but they set the target to reflect that in 2023 there was renewable content. So the credit generation started below the baseline. A bit messy. But in terms of other mechanisms to sort this out, from the rules that we've got, there's sort of 2 ways of go about it. Reporting only year, where you forgo reductions, but you want the data, or an extended first compliance period to give time to correct errors without failure to comply with the basic requirement of the rule.
Thank you. That's all for me. Thank you.
Member Garcia.
Thank you, Madam Hearing Officer, and thank you, panel, for your presentation today. So one item I just want to clear up 100% in my mind. Several people have touched on this issue, and maybe this would go to Ms. Felix. I'm not sure any of you can answer. You outlined items that you still take issue with in the rule, and let me see. One of them was not allowing, well, Ms. Losi identified that her testimony was based on the first version of the rule, and we now have the revised version before us. Now the revised version has the ability to get project credits earlier. And so is that issue just eliminated now? Is that not an issue anymore for you all? Can we be 100% clear about that? Because
Can you hear me?
yes.
Sorry. Okay. I wasn't sure if that was on. Yes, that issue, as what's currently proposed in the September 2nd red line of NMED, does strike that off of our list.
Great.
Thank you.
Good to hear. Thank you. And the other item is sort of a big picture item. Maybe Mr. Rensing could answer this. One of the items you bring up is that with each time that the other 3 states and also BC has implemented a low carbon clean transportation fuel program, there's been disruption in the market and it takes a while to stabilize. And that presents some issues for the regulated community. And, you know, we hear before every rulemaking about how industry needs to have assurance of what is before them. And so there's going to be disruption anytime they implement it, whether it's, you know, in February, July, whenever it is. Wouldn't it be better for the industry to get it started so that things will stabilize sooner? Would that not be helpful?
It's all relative to the compliance deadline, because that's when things really matter, right? And the amount of time between when they get started to when things matter is important, because it gives a chance for information to start to flow the earlier you start. So from that point of view, yes, it would be a good idea. However, the implementation of software is never a smooth road, and I've been involved in 3 or 4 major projects along those lines, and it is always uncertain as whether you're going to succeed until everything's up and running and the users have tried to crash it, if you will. The timelines are doable. I'm sure they're the real project timelines, because those would be my timelines. But what happens if something goes wrong? And then there's a bit of a cascading effect that somebody can't use the system to register, so they can't report. They can register and report, but they've passed the deadline for generating the credits, but they still have to generate the deficits. That's the interpretation of what I see in the statute. You then have those credits available to the people who generated them, but they can't place them in the market for someone to buy them until the end of the quarter that the department approves them. So that is the quarter in which they report and they approve, and then they're posted and available the next quarter. Now we're 2 quarters down the road from the startup, right? If there was any glitch, we're 3 or 4 quarters. You then start getting transactions. And when I'm referring to the market in this case, I'm meaning the credit market. The fuel market is a different kind of market and a different set of drivers. But in the credit market then, you then start getting some transactions. And I'll guarantee you in the beginning, nobody knows what to do. They're going to look to other states. They're going to look to the prices of fuel. My guess is the smartest startup is a few people will do what's called a price discovery auction. You hold an auction and see what people are willing to pay. Then you need a few more transactions, which then includes, okay, we now see that X amount of credits is likely to show up every month or every quarter. We don't have to panic buy. We can wait till the next quarter or a little longer than that. The more we compress that time, the harder it is for the companies who are selling and buying to plan their activities, because we're now down to weeks. So you're filing your paperwork and you're expecting to get a response in 30 days or the 8-week deadlines from a group that's doing it for the first time on your report. So it kind of happens on all sides that if everything's perfect, it'll work. But if there's a glitch, the consequence could be that a deficit generator cannot demonstrate compliance in time. And they couldn't demonstrate compliance for circumstances outside of their control. They could have made best efforts, conducted all their due diligence, and it is a matter of how long it took that a deadline slipped by 1 day past a statutory requirement. And that becomes worse if you're shortening it to, say, a July 1st start. Now you've only got 2 quarters. And I forget what the term was, but a lot of people talk about the first quarter in the new compliance year being a true up. That's a chance for people to trade credits. And kind of by definition, the credits available are the ones that were generated during the compliance period. They just have to be bought in the first quarter of the second year. So that's why reporting 1 month after the end of the first quarter. But those credits need to be out there. The suppliers in the beginning need to be comfortable that there are going to be enough credits for them to comply if they rely on the market. Then they don't have to go after more expensive options. And they can pay what they would consider a reasonable price. Early prices are all going to be a little on the high side if there's a perception that there's not going to be enough credits, and on the low side if they think it's going to be. That market figures that out. But the market figures it out by getting feedback from the market. So you get 3 or 4 sales. A month later, the data comes online for everybody to see. There were 3 sales. The average price was this much. This many credits were generated from electricity, from other fuels, and so on. And particularly in the early years, and if you're looking for cost-effective compliance, electricity is important. And electricity credits move from those who don't need them to those who do need them. And those who need them have no idea how big that market is, how big that opportunity is. It's 100% trust in the models. That's why you're hearing so much about, we're concerned if the model's not quite right. We're concerned if the credit shows up in April instead of January, or start of October instead of January, because it affects your ability to write a check for $25 million to buy those credits. Is that?
Yes.
Help? Okay.
Yes. More than answers my question. Thank you very much.
All right. On the platform, Member Hunker, do you have questions?
No additional questions.
Thank you. Member Bitzer, do you have questions?
I'm good. Thank you very much. Can you hear me?
Yes, very clearly. Member Bitzer, if you're talking, I can't hear you. What happened? Oh, I'm sorry, Member Bitzer. If you didn't have questions, I'll move on. I didn't hear you correctly then. Vice Chair Trujillo?
I had a lot of questions, and I believe Member Ely and Member Garcia really asked a lot of my questions there. I'm gonna go and defer to Chair Sweeney for a bit.
All right, Chair Sweeney.
Thank you, Madam Hearing Officer, and thank you, panel, for your presentation. And thank you, Member Ely and Member Garcia, for your questions and the cross, because those were a lot of my questions. But I do have a remaining one that came out in the discussion and the responses to my fellow board members' questions. And one question, I think, for you, Dr. Rensing, were you here to hear or online to hear the testimony by NMED the NMED panels regarding the resources and the work they're doing right now to prepare for this program?
I was paying close attention for the first 2 days.
Okay.
So I believe there were 2 NMED panels, and I heard the first one.
Okay, and I can't remember. There's been so much testimony.
Okay,
So,
yeah, and there was some discussion of the resources. Yeah.
of the resources that NMED is doing to prepare for this program. And so since you might have heard some of the testimony, and again, I would have to go back to the record to hear exactly which witness and what day it was. But if you did you consider that in your oral testimony today in regards to your ongoing concerns about your recommendations regarding the timeline proposed?
Yes, I did. And just to give the bit of the nuance, written testimony was based on no knowledge. There was some information in the written testimony. I heard the oral testimony, and I am very reassured that they're not starting later than this, and they've been working on it for, I can't remember, a year or so already. And that's really good news. But there was also some project updates. And for example, the tool to support registration and reporting, which is the first thing that's needed, is not ready yet. And that means that it needs to be finished. It needs to go through quality testing to go online. And I'm not aware, and I didn't hear anything that said that any of the users had been invited to test the system yet. It would be a huge accomplishment if there weren't problems.
Thank you for that response. And I just have maybe a point of clarification for me on process. I know there's going to be rebuttal in November testimony. I know, as we heard, there's been September 2nd is a big day on all of the information being available for folks and on multiple sites. So I was just wondering, once that, maybe Madam Hearing Officer, once all the parties get to look at that, will they all come back in November so we could, have another point of maybe that we're all up to speed on the latest?
Well, so there will be a filing deadline for rebuttal, and sitting here, I would need to dig out my pre-hearing order to tell you what that filing deadline is. I might be able to find it while I'm speaking. The parties are not required to come back with rebuttal, but if they do not, then they stand the risk of someone else rebutting their testimony, leaving it there and kind of prevailing on that point. November 7th at noon is the rebuttal NOI deadline for everybody.
Thank you, Madam Hearing Officer. And I was just wondering, maybe throwing that out, like Vice Chair said about red lines and so forth, and the information that is helpful to the board. And I think what I've heard, and I think, even in Member Garcia's question to you, Ms. Felix, that, some new testimony that came up then address some of the concerns, not all, but I just want to kind of put that out there that we continue to work together to try to come to resolution on some of the points of clarification. And I'm hopeful, at least with what was provided today in terms of some of the comments and additional information and over the last couple of weeks, that we can keep working together. So I just want to say, I want to maybe reserve some of my additional questions after things work out a little bit further. So I'll stop there. Thank you, Madam Hearing Officer.
Does that raise anything for you, Vice Chair?
No, actually, I just want to also say I support Chair Sweena's comments on that, because I really did find Member Garcia's question to Ms. Felix extremely helpful, and I would love to see what comes out of that. So.
All right, thank you. We haven't been going exactly 90 minutes, but it's real close. Let's just take a 10-minute break and then we'll come back for redirect. Come back from the break, please. Yes? All right. We're back after a short break. Mr. Trujillo, before you begin redirect, I'm wondering, there are a few people who would like to know now up here on the stage whether we are starting at 8 or 8:30 or 9 in the morning. And I guess what I'm doing is looking for an opinion from council, an opinion I could count on, as to what, sorry.
I defer to Mr. Mullenberg.
Yeah, as to whether, you know, if we didn't start at 8, would we be really confident that we could still finish by 5? We have 3 witnesses left, as I understand it, 2 from Oxy and 1 from American Fuel. Is that true?
Madam Mayor, so yes, that's my understanding. It would seem like we could, and I'll let Oxy actually talk us through Mr. Tucker.
Yes. And David, I think you can rest for a moment.
Good afternoon, Madam Hearing Officer. That's correct. Oxy has 2 witnesses that will be presenting. I'm very confident we can get through both those witnesses tomorrow, as well as AFPMs. Well, I won't speak for AFPM, but they have 1 witness, and I suspect we'll be able to get through pretty easily tomorrow, starting at 9.
All right, and that includes all the cross and redirect. Okay.
I can only speculate as to how much cross the other parties will have, but based on kind of the cross recently, I think we should be able to get through everything starting at 9.
All right, Ms. Sona, do you have an opinion?
Thank you, Madam Hearing Officer. I don't have super great concerns that if we were to start at 9, we wouldn't be able to get through it. I think if cross is to proceed the way it did today, we'd be more than comfortable finishing. I'm not sure if CCAE will have lengthier cross than they had today. It seems like most of the other parties don't have any besides them and NMED. But I don't foresee that NMEDs would cause us to go over.
All right. Salen?
Thank you, Madam. Thank you, Madam Hearing Officer. I don't expect we're going to have much cross for the remaining witnesses, so I think we'll be all right.
All right. So starting at 9 then still? Is that okay? All right. Thank you all for your input on that. So let's bring this panel home, Mr. Trujillo, and you have up to 10 minutes with each of them.
So if we make things efficient, Madam Chair, I'm going to, my redirect question is going to be directed to both Mr. Sears and Ms. Felix at the same time. One of them may be able to answer just to hopefully expedite instead of taking 20 minutes. And hopefully you're going to take 10 or less.
That's fine.
However, my first question, I'm going to start with Ms. Felix. Ms. Felix, was this your first time ever appearing before a board or commission in New Mexico?
Yes, it was. I have my sticker now.
Welcome. And the rest of the set of questions is going to be directed to, like I said, both of you two. And then Mr. Malberg will come up and ask some questions to the remaining technical witnesses. Thank you. There were some questions in particular directed to Ms. Felix, and again, either one of you can answer, dealt with project crediting, and there's some indication that we've seen some movement there. Are there still some remaining concerns? And if so, what are those with respect to project crediting?
I'll start first. It seems with NMED's petition red line that they submitted on September 2nd, that we have made some crossroads and we are looking like we have alignment. We do still have some work to do with other parties to ensure that we have guardrails, but we feel very good about where we're going.
Searles, do you have anything to add?
No, I think that covers it. Thank you.
Had a lot of questions, especially Ms. Felix and some of you, Mr. Searles, regarding the advisory committee process. I guess I'll pose the question to you this way. What's the temperature of your memberships in terms of the feeling of their input being considered and or accepted at this juncture?
I'll take that one. Our members have worked very hard and very diligently, and they have put Prentice and I to the test. It is a huge lift. We can only imagine what the lift is for NMED, and that's why Prentice, NMOGA, and API came together to form this joint work group to try to gauge consensus among an industry for a unified voice as much as we can. Our members 100% support the rulemaking process and that these rules will be implemented. What they're looking for is executable, transparent, science-based rules. And to be completely honest with you, our members have they are feeling like they have not been heard by the department over the various meetings that we've had. Prentice and I have kept, I guess you'd say, tooting the horn of continued collaboration. But very much so, we want to be part of this process. Our members do want to be heard, and they ultimately are going to be the regulated party, and we 100% need them to understand the rules in which their company needs to operate. We heard a lot about planning, and has industry been planning? 100% industry has been planning since legislation was put in place of March of last year. However, we didn't have for our companies to go back and communicate internally at the corporate level of what it's going to look like for them to comply with their rule, because there was no rule put out there. There was the discussion draft rule, so they could start there, right? But then we had a petition rule in May, and now we have a revised rule now in September. That makes it very hard for companies to plan internally and to make plans and processes to comply.
Yeah, the only thing I would add to that is it would be, there's obviously some disconnect between InMed and API NMOGA, and it'd be great to be able to get buy-in from us into the InMed. Our suggestions and recommendations are intended to improve the rule, to make it where, if we don't have a problem with an emergency deferral, great. We hope that never happens, but at least you've got some guardrails in case something does happen. And so that's where, where we're coming from is trying to improve the rule.
Along those lines, question again to both of you. Did NMOGA and API or its members submit feedback as a part of the advisory committee panel? And
So NMOGA and API jointly submitted verbal feedback at one of the advisory committee meetings of the three. And to clarify, there were 4. One of them was a non-technical meeting of the advisory committee. 3 of them were technical. We also submitted as a joint work group written comments through the advisory committee process.
And as a follow-up to that, was that feedback included in ultimately the proposed rule that was originally petitioned?
That feedback submitted through the advisory committee process was not represented in the discussion draft rule.
Little different topic here. Do fuel producers have the power to set fuel prices in a competitive market?
Absolutely not. You can see it on the street and there's a study done by the National Association of Convenience Stores on a gas price on the street. If people will make a left-hand turn across the street to save a penny on a gallon of gasoline, and if you're a nickel off, they're willing to drive a half a mile for that. That type of competitiveness runs up through the entire supply chain. So no individual can look at this and go, I'm going to just today raise my prices without having, and everybody makes their own individual decisions about what they want to do and how they want to do it. But they have to assess the market to determine whether, and oops, seems like it's fading. They have to assess the market on any price changes they decide to make and what the implications are for them.
Madam Hearing Officer, I would just like to note for the record that that answer was far beyond the scope of cross-examination that was presented by New Mexico, the New Mexico Environment Department to Mr. Searles. And so I think that question was beyond the scope appropriate for direct.
All right. Just a reminder as to scope, Mr. Trujillo, please proceed.
Thank you, Madam Hearing Officer. Much like some questions that were posed by the department to their witnesses on redirect, I'm going to ask you a similar question, and that is if you had, based on the testimony that you've given today, is there a particular message that either one of you or both of you would like to leave that you think is very important for the board to consider?
Okay, I'll go first. I'd like to leave the board with today that, as we heard even through public comment, the support of these rules and these regulations, that support also does come from our industry. Our industry has not tried to obstruct the rulemaking process. We've tried to help and make it better, and we open-armedly continue to want to have those conversations and try to get the board to adopt a rule that is implementable and executable for all New Mexicans.
I should have gone first. Andrea said effectively what I was going to say.
At this time, I'll turn it over to Mr. Mollenberg for the remaining redirect. Thank you.
Thank you, Mr. Trujillo.
Thank you, Madam Hearing Officer. Dr. Rensing, just a few things for you. My first question, I was going to ask you about a question you were asked on the CTFP DMS system development. I know you were asked a question about that from a board member. And I know you've shared some of your experience with that in the program in British Columbia. I would just ask if you had anything to add on that point.
I don't think I have much to add on that. I just acknowledge that it's challenging. Problems always seem to come from unforeseen areas, and it comes back to the timing. If there is something that causes the schedule implementation to slip past a statutory timing date that is important, there can be consequences.
Thank you. And Dr. Rensing, you were asked on cross some questions relating to your knowledge about potential participation by public utilities in the program here in New Mexico. And I was wondering if there was anything from your experience, again, in British Columbia that might relate to those questions and your answers.
Yeah, actually there is. So British Columbia electricity is supplied by two regulated utilities. One of them is private, but the larger one is publicly owned. And those two utilities were working with the department from the beginning on the expectation that at some point there would be credits from charging. Once they understood that they were obligated to participate or expected to participate. New Mexico's past that stage. It's pretty clear. But we got to the point where we finally had the resources to enable a reporting system. And so we worked through all the policy and the tools. We had an operational software reporting system, that we added the capability for the electricity credits to be generated after the suppliers had registered their chargers. All of those provisions should have gone through no time at all, right? Everybody knows how much charging they're doing. Everybody knows where they are and all the rest. Didn't work out that way. One entity putting all these chargers in place, they couldn't remember where they installed them all. They couldn't remember and tell if all of them were working. They were just pretty sure, and they would have to find out. They got to the site and found out that that had been broken down and replaced, and nobody had recorded the serial number. And the records were for the previous unit that was there. And there's private operated chargers, which we call public chargers, right? A public charger is one that any member of the public can drive up to. Those tend to be not operated by the utilities in the concepts that people are talking about. It's just companies like Tesla and ChargePoint. They were eager to get involved. And then the turf wars started. And there are provisions in the New Mexico regulations that say there are a few possible reporting parties. There will be documentation that's required to clarify who will report. And there's that fallback to the backstop aggregator. You cannot implement all of those steps with giving people 5 days to fix their records and moving forward. Everything takes 30 days, 60 days, whatever the legally fair administrative timing is. And as soon as those glitches started showing up, it actually took us, we were ready. It took us 6 months to get the details sorted out so that we knew that there weren't multiple parties reporting the same chargers.
Thank you, Dr. Losey.
Rensing?
Or Dr. Rensing, I'm sorry, it's late in the day. And I just gave Ms. Losey a new degree. Dr. Rensing, I think earlier you identified 3 main points that you wanted to make to the board to consider in terms of potential changes to the rule. And I'd ask you to recap those and then let me know if any of the discussion today has changed your views with regard to those key points.
Right. So in my testimony this morning, I summarized the 3 areas at a high level. So the suggestions then to the board are amend the proposed rule to implement a more measured pace for the transition into the rule. So that's my concerns about the very early quarters and first compliance period. Add provisions for emergency deferrals based on credit deficit balances. It appears to me that the regulation hasn't got any tool in the toolbox for the department to address a problem that comes up where there's a clear shortage or a clear dysfunction in the credit market, because the emergency provisions are for physical products and force majeure. They don't address the credit market. And then the third one is that it would build trust and understanding and provide more transparency if the credit forecast process were conducted by a third party and there was public review before committing to whether or not that leads to a deferral. And so it's the same as I was saying this morning.
Okay, thank you very much, Dr. Rensing, for your testimony today. Ms. Losey, it might be helpful for my redirect if you have a copy of the, probably particularly the NMOGA red line in front of you, and turn to the section starting with 201.
Do you have the page number for me? Okay. Thank you. This red line is very long. Okay, I'm with you.
Thank you very much. You recall some questioning about tier 1 and tier 2 calculators from earlier today?
Yes.
And is it your understanding that the NMOGA API red line eliminates the use of those terms, Tier 1 and Tier 2 calculators?
Yes.
Objection, Madam Hearing Officer. I
Yeah.
guess I didn't get that out quick enough. Ms. Losey's testimony during cross-examination was that she was not familiar with the red line and did not know the contents of the red line. And so I would object to a question that asks her to interpret the red line.
Okay, Mr. Mullenberg is clearly following up on an area of questioning that in your case was unfortunately cut short. And I myself am very interested in hearing what she has to say about the proposal to eliminate Tier 1, if you will. And if by doing that she's referencing the red line, I guess I don't see the harm in that. We did hear that she didn't prepare it. I get that. Go ahead, Mr. Mullenberg.
Sorry, could I clarify one thing? I did say that I've read the red line. I just said I couldn't say that I was an expert on all parts of the content. When I was asked, you know, generally was this in here without a citation of exactly where I was looking for. I couldn't speculate on that, but I have read it.
It's fine. Go ahead.
Okay.
Yes, thank you. And I'm not intending to take a deep dive here. Ms. Losey, both the proposed rule from the department and the NMOGA API red line contain a table 5. Is that right?
Yes, that's my understanding.
And in fact, for purposes of the NMOGA APA red line, I'll let you get to that for a minute.
I'm with you.
Yeah, did you provide some revised text and values for the table 5 in the NMOGA API red line?
Yes, my firm provided the values listed in the revised table 5.
Okay. Aside from the values, and particularly as it relates to how a regulated party might use table 5, can you give the board your understanding of the differences between the use of table 5 in the proposed rule versus table 5 in the NMOGA API red line?
Sure. So table 5 in the proposed rule is temporary pathways. So fuel producers that are listed in the first column of table 5 would be able to enter the program using the CI listed in the final column of the table for 6 months, I believe, is the default kind of first period. And then I think there is the opportunity to extend as if needed or if petitioned. The NMOGA API red line is suggesting that a fuel producer listed in the first column could use the CI in table 5 indefinitely. So that 6-month limit would be eliminated.
Okay, thank you. As an alternative to using table 5 under the really either of the versions of the rule, or the tier 1 calculator as that's referenced in the proposed rule, does the NMOGA API red line contain in section 202 a provision to calculate carbon intensity values using the GREET model?
Yes, in both cases, to generate a pathway application so in both cases, meaning the API NMOGA red line and the proposed rule, pathway applicant would need to submit an application, or low carbon fuels producer would need to submit a pathway application calculating their CI using the designated GREET model.
And then in section 203 of the NMOGA API version, can you briefly explain the difference between how section 202 and 203 works under the NMOGA API redline?
Sure. It's essentially the same idea as the rule as proposed. You can use in the red line, it's called a default pathway, which the default pathways are now the pathways listed in table 5. So instead of those being temporary pathways, the red line now calls them default pathways to eliminate the connotation that they would be temporary. And then as with the proposed rule, if you didn't want to, or you, in the proposed rule is if you either didn't want to or ran out of time on your temporary pathway, in the red line, it would be, if you chose to, you could submit a pathway application with your site-specific pathway application, as is listed in the proposed rule, using the designated GREET model.
Thank you. Ms. Losey, do you recall some discussion today regarding, I think the questions probably were in the context of project credits and getting credits for greenhouse gas emissions reductions. Do you recall that?
Yes.
And are you generally familiar with what that means and how to do that?
Yes.
Okay. Ms. Losey, for a non-fossil fuel, alternative fuel, biofuel, whatever it is, can greenhouse gas reductions gained through a particular production process be accounted for through the GREET model and resulting carbon intensity calculations?
Madam Hearing Officer, objection. This was not part of the scope of cross-examination for Ms. Losey, so it's inappropriate for the scope of redirect.
Mr. Molenberg?
Madam Hearing Officer, I believe this question was actually asked of the panel and deferred to Ms. Losey, but it never got around to response to that.
So it's ringing bells in my head that this topic was pursued. Ms. Sona?
Yes, so I believe that Ms. Felix or Mr. Searles were presented with this question and declined to answer and deferred it to Ms. Losey after the point of her cross-examination. Now, if council is able to cross-examine her on this topic, it would be appropriate for her to answer on redirect, but I don't believe that the scope of a panel presentation goes so broad as to allow it to redirect to any potential witness when the specific question was about the knowledge of Ms. Felix and or Mr. Searles.
All right, Mr. Molenberg, will you refresh my memory as to whether Ms. Losey addressed this in her written testimony?
Honestly, I don't recall, although I would mention that Ms. Losey already has answered yes, and actually that's the end of my question.
Okay. All right, so let's move on.
Okay. Ms. Losey, just to conclude here, is there anything else that has come up in your questioning today or the discussion that you would like to clarify or address at this point?
Yeah, I think there's one thing that I would like to clarify. The reduction of the CI target, it doesn't directly mean that you're actually reducing greenhouse gas emissions in the state overall. So you could, reduce the CI target as much as you want, but if the amount of energy that is being consumed in the state goes up, your overall emissions will also go up. So I just want to clarify that because that seemed to be a point of some misunderstanding.
Okay. Thank you, Ms. Losey. That's all I have. I believe that's all we have for the panel at this point. So if there's not a reason to let them go, I'd ask that the panel be excused.
All right, thank you. Thank you very much, all of you, Dr. Rensing, Ms. Losey, Mr. Searles, and Ms. Felix, and Mr. Molenberg and Mr. Trujillo. Thank you all. Pursuant to our discussion following the last break, we will begin at 9 a.m. tomorrow morning. And we'll begin, as I understand it, with the 2 Oxy witnesses. Yes? All right. And then move to the American Fuel witness and then proceed toward rebuttal. Ms. Sona.
Thank you, Madam Hearing Officer. This is a question for the board or just a statement for the board. I don't want to surprise you tomorrow. We've heard a lot of your questions. We've heard your encouragement for red lines. And I think given the unique nature of this proceeding that we have rebuttal coming later rather than rebuttal and direct combined, if there are any particular issues that you feel you really would like clarification on from the parties to outline their perspectives in a different or more clear manner, identifying those issues I think would really help us, in addition to the parties working together to find potential points of agreement and be clear about where there might still be disagreement. So no answer required, but just wanted to flag that the NMED would find that very helpful. Thank you.
Thank you, Ms. Sona. I'm sure they'll reflect on that. Member Ely.
What would be the form of clarifying those issues? I mean, we can't really talk to you individually. It's ex parte. How would we handle that?
Thank you, Madam Ely, or Member Ely. I believe one potential non-prejudicial way would be after the close of all the direct testimony. So once we conclude Oxy's and AFPM's witnesses tomorrow, when we finish all of that, maybe just brief statements from you on the record could be possible. I'm open to, I haven't discussed this with other council yet.
So actually I can think of one other way to do it. I think I've done this with the Water Quality Control Commission. The members, the board could communicate with me and I could kind of compile that and share that with all 18 parties. That's another possibility. Chair Sweeney.
Oh, thank you, Madam Hearing Officer. I was also wondering if we might also hear from our board legal counsel and at some point on his opinion too, along with yours, to see if whatever's appropriate.
His opinion as to whether it's appropriate for the board to indicate areas they would want to hear more on?
Yes, and if so, what would be the best way forward to do that? If it's your recommendation, that's great, or if it's another way, we just want to make sure we're all compliant and transparent.
Yeah, I think so long as it's being shared with all parties, whether that's through me or speaking it directly from the dais, I don't know that either of those would be inappropriate. Mr. Ugarte, do you have comments?
Thank you, Madam Hearing Officer. And Chair Sweeney. I agree with what you just said. I think that's spot on, and I don't have any concerns with that approach.
Thank you very much, Mr. Ugarte. Anything else before we adjourn for the day? Nope. See you at 9, and there's another 1 p.m. public comment tomorrow.